Hi, Melissa. How are you?
I'm doing just fine. Can you hear me okay?
Yeah, I can. I'm not quite. I'm just doing some other stuff around the house here. Not tired for the meeting just yet. So I got a little
No,
bit
that's
longer.
okay. I'm gonna just change my name from Mark to Melissa and just be waiting.
Yeah, sure. I just sent you an email. There was a party who apparently thought they didn't submit an exhibit list. I found one, and anyway, sent me another one, I guess, and I looked at them. They're identical. So
Oh, is it onward?
yeah, it's
Yeah,
it's
I
the same
did.
thing. I checked. There was an exhibit list in there.
Oh,
So I don't know what they're thinking.
okay. Well,
Anyway,
I will if you could come back with me when I set up, I'd like to just do a test and make sure everything's working, but I'm not completely set up either, but I wanted to make sure that I was able to get on, so that's good.
sure, no problem.
All right, thanks.
No
Bye.
problem. Bye.
Mr. Hearing Examiner, this is Peter Gould. I will say this at the hearing, but I'm going to be representing Anna Mary today. My daughter is recovering from COVID. I'm not hearing you. Hold on here. This is weird. Okay. Can you, Mr. Ryan, can you hear me? I cannot hear you. Okay. It might be something wrong with my system.
No, I can hear you.
Well, but I can't hear the hearing examiner.
Can you hear me?
I can.
Okay, that's a good troubleshooting.
And this is Rick Alvidrez. I also cannot hear the hearing examiner.
Yes. I think,
Well,
I think,
I always assume these technical glitches are my, you know,
What
Mr.
about now? Is that better?
That is much better.
oh, yes,
You can hear me.
coming
Yeah,
through.
something happened with the mic on the headset.
Well, as
That's
I
right.
was saying, my co-counsel, in our pre-hearing memo, we just mentioned her, and she's been handling the case and then came down over the weekend with COVID, is recovering, but is basically still too sick to participate. So I'll be participating in all the days in this month. She may pick up the torch again
Okay,
in
that's
December.
understandable.
But I just wanted to give you a heads up on that. I will make my appearance on the record when we go on the record.
Very good.
Okay, thank you.
Thank you.
Oh, and one other thing, Mr. Dauphinay is not available today, but we looking at the list of witnesses that are coming today and the amount of cross-examination. We did not think he would need to be available. So,
No, yeah, there's
Yeah.
no way.
yeah,
No,
exactly.
today will be 3 witnesses as far as I can tell. Yeah, I mean, definitely going to only be, we won't even get through Nagel entirely. So,
Yeah, okay. Very good. Okay,
Sure.
thank you. I'm going to put it on mute for a few moments while I get ready for the hearing and
yeah.
put it. Okay, thank you.
Ms. Gonzalez, everything okay on your end? You're
Yeah.
you're good.
Yes, I'm hearing everyone so far just fine.
Terrific.
And Ms. Gonzalez, this is Mr. Albright on behalf of Bernalillo County.
Yes,
Can you hear me adequately as well?
yes, I can. And I do show you, yes. All right. Check mark.
And Ms. Gonzalez, this is Bruce Throne, I represent Onward Energy Holdings Company.
Okay.
Can you hear me okay?
Yes, I can. Thank you for checking.
Morning, Mr. Hearing Examiner. Good morning, Mrs. Gonzalez. This is Joseph Yar. I'm also here on behalf of Onward Energy Holdings.
And we'll do a little rundown. I mean, part of the reason of taking appearances in these circumstances, everybody will get a opportunity to make sure their audio is working. But yeah, no, it's, you put your thing on mute and then the machine like decides it's not going to register the headset mic anymore. It's wild the way all these peripherals work with Zoom's interface. Well,
Mr. Ryan, this is Mark
Yes.
Fenton. Can you hear me okay?
I can hear you fine, Mr. Fenn. How are you?
Good. How are you?
Fine, thanks.
Thanks. Thank you.
I'm guessing everybody's going to jump in last minute because we're got 5 minutes and I don't see a lot of the folks.
Yeah, that's typically how it works, Mr. Hearing Examiner. Everyone waits till like about the 5 minute mark before they jump on.
Yeah, it's interesting. I mean, I prefer to get this stuff all set up way in advance just because getting the YouTube stream running, making sure your machine isn't going to do something crazy. There's so many problems that can happen. It just feels like whatever.
Yep, that's the prudent thing to do.
Well, it's just a way to bring order to or like the perception of order to a chaotic universe, right?
Yep.
That already happened to me this morning. I'm glad I started early.
Yeah, you really have to. I mean, and then on our end, you know, we have all these people behind the scenes ensuring that the YouTube stream is running up on the commission website. It's a lot of little details that have to happen. So,
May I ask, are you home or are you in the Bochum building?
no, I'm in my home office area.
Oh,
I
Oh,
go to
like-
the Bochum office 3 days a week. You know, but some of the hearing examiners I know are staying at home still out of COVID concerns. And then also once you've transported 17 boxes of record, you know, you don't want to have to transport it anywhere else. So there's multiple.
I asked because my first law office 45 years ago was in the Bochum building, and I suspect it wasn't in great shape then. I suspect it hasn't improved much in 45 years.
You know, they've made a real effort, and it's the folks who got it all set up acted heroically. It's definitely an older building, but we're making do.
Good morning, everyone. Could I just test my audio and video? This is a new setup for me, so.
Loud and clear.
Okay, good. I'm gonna try to put this camera in the middle so it doesn't look like I'm staring off into some other. That's probably better. Okay.
Can somebody say something?
Yes. Who said, who is that? Is that Mr. Getco? Yeah. His audio is.
You're muted, Kevin.
I apologize. Can someone say something now?
Yeah. Hi, Mr. Getco. How are you? Can you hear me?
I'm doing well. Thank you, Mr. Ryan. Thank you, Mr. Hearing Examiner.
Sure. So I've got 8:58. We'll just wait till 9, but folks are definitely trickling in. So. Okay, it's 9 a.m. now, according to Xfinity. So we'll commence proceedings. Miss Gonzalez, is that the correct pronunciation of your name? Did I do that close enough?
It's close enough.
What would you say if you were to say it?
Gonzalez, like resolves.
Oh, Gonzalez. Okay,
Uh-huh.
very good.
Kind of weird.
No, that's fine. I wanted to clarify that.
Okay,
Very good. So you ready to go, Miss Gonzalez?
I am.
Terrific. All right, we'll go on the record then. We are here for a hearing in case 21-00215-UT. Today is Friday, November 12th, 2021. My name is Christopher Ryan. I was appointed as a hearing examiner to preside over this case. And we will begin by taking appearances. And let's begin with PNM.
Good morning, Mr. Hearing Examiner. Leslie Padilla appearing on behalf of Public Service Company of New Mexico. And with me is Richard Alvidrez, outside counsel for PNM.
Thank you. And Mr. Alvidrez, I believe we checked in with you earlier, sir. I'm just going to do this to make sure everyone's mics are working. But how are you?
I'm well, Your Honor. How are you?
Very good. And we can hear you loud and clear.
Great.
All right. Onward Energy Holdings.
Good morning, Mr. Hearing Examiner. Bruce Throne for Onward Energy Holdings Company. With me today, also representing Onward, is Joseph Yar. And although I will be conducting the examination during this hearing, in case we need to do the share screen feature and put a document up, with your permission, Mr. Yar would handle that for me.
That's a good idea. Thank you very much. And Mr. Yar, just to check in again, how are you, sir?
Fine, thank you, Your Honor.
Very good. And I can hear you loud and clear. New Energy Economy.
Good morning, all. Good morning, Hearing Examiner Ryan. Marian Lanassi for New Energy Economy.
Very good. And it's Mr. Davis. I think that's the individual who you sought to have admitted pro hac vice, Ms. Nanasi. Is he going to appear or no?
No, he's not.
I see. Okay. ABCWUA, Albuquerque. No, I might have just butchered that. So, Mr. Herman, you can correct me if I'm wrong.
Good morning, Mr. Examiner. Keith Herman on behalf of the Albuquerque Bernalillo County Water Utility Authority, or ABCWA. Also monitoring the proceeding probably over the YouTube is my co-counsel Dal Harris, and we may be switching out throughout the day. We didn't want to overload the video feed, but so we will not be able to test Mr. Harris's audio at this time.
That's fine. And yeah, that's understandable. Western Resources Advocates.
Good morning, Sydney Beatles for Western Resource Advocates.
Terrific. Bernalillo County.
Yes, good morning, Mr. Hearing Examiner colleagues and our court reporter. Jeff Albright representing Bernalillo County. And I would request, we have no expert witness in this case. And I would ask that, although I should be here for today, I may periodically be absent on Monday with some other commitments. And I certainly agree to abide by any rulings or any admissions and testimony that I'm not here for, but would request the hearing examiner's indulgence in the event that I have to miss an hour or two on Monday.
That's fine, Mr. Albright. Thank you for bringing that up.
Thank you, sir.
All right, where did we go here? NM area.
Good morning, Mr. Hearing Examiner colleagues. Peter Gould for NM area. As I mentioned before we got started, I'm going to be representing NM area in this proceeding. My co-counsel, Kelly Gould, is recovering from COVID. And unfortunately, also my office manager is recovering from COVID. And so is my grandson. So I don't have anybody to help me with the technical difficulties. So if I screw up, it's totally on me. I don't even have a 4-year-old boy to show me which buttons to push.
I'm sorry to hear all
but-
that. It's,
Well, they're doing better. Everybody's getting better.
Good.
But to echo what Mr. Albright said, we don't have any cross-examination today. I've got to do some other client matters. As you understand, there's lots going on. And I will be in and out of the hearing. I'll do it in such a way not to disturb anybody. I'll mute myself. But again, I'll abide by any rulings that you make in my absence. But as you noticed from our pre-hearing order, pre-hearing motion, we are not going to be cross-examining any witnesses. So we're not going to be objecting to any testimony either. So you can assume our concurrence with any admission of any testimony that you deem proper. Thank you, sir.
Thank you, Mr. Gould. And I guess I will just say, since you raise it, if you are effectively here and sort of in the background silent, do please make sure your mute is on. I think everyone knows why that's essential. As particularly if you're going to walk away from your desk for a while, just make sure you're muted because it can be disruptive to hear people's sounds in the background.
I will do that right now. Thank you.
Sure. And that's just a reminder for everybody else. I mean, there's pretty wild stuff that happens on Zoom from time to time. So just be aware. And I'll just note too, for the record, well, not for the record, but more for the benefit of all the parties, you are being streamed over YouTube. Anyone in the world can watch you at the commission's website. So when we break, be sure to mute and turn off your video if you're going to be doing things that you would not wish the world to see or hear. So FYI to that. CCAE.
Good morning, Your Honor. I'm present and I'll be participating in the entirety of the hearing, except that I asked to be excused for about an hour or two on Tuesday morning because of a conflict.
And wait, so Ms. Lynch, real quickly, we have today and then Monday that we're not meeting Tuesday.
I'm sorry, I meant Monday.
Got you. All right. And then just for the record, it's Ms. Lynch who appearing for CCAE. So
Correct.
Thank you very much. Interwest.
Good morning, sir. This is Joan Drake for Interwest Energy Alliance, and with me this morning is Haley Adams. And Miss Adams and I will both be appearing for Interwest. I expect we will be coming and going somewhat since, like Mr. Gould, we don't have any witnesses and we have not reserved time to cross-examine any witnesses. So we would request excusal to come and go. We're hoping that just one of us, primarily Miss Adams, will be on the Zoom so as not to take up too many of the Zoom spaces. And so I'll probably eventually drop off and I'll just watch on YouTube.
Thank you, Ms. Drake. And Ms. Adams, how are you?
Morning, hearing examiner. I'm well.
Your audio is a little low, FYI. I mean, it doesn't sound like you're going to have too much participation, but I guess you'll have to project if you ever chime in.
Okay, thank you.
Sure. The New Mexico Attorney General.
Good morning, everyone. Good morning, Mr. Hearing Examiner. I'm Kevin Gedko and representing the New Mexico Office of the Attorney General. Thank you.
Thank you, sir. Are there any, before I get to staff, is there any other parties that I missed? I think I got everyone. Mr. Borman.
Good morning, Mr. Hearing Examiner. Bradford Borman appearing on behalf of Utility Division staff. I'm joined by Elizabeth Jeffries, who may be I may force her to do some of the work on this case. And I think Naomi Velasquez, one of our witnesses, is on as well. The rest of the team is watching on YouTube.
Terrific. Ms. Jeffries, how are you?
Fine, thank you. Hi, everyone.
Very good. Your audio is working fine. Okay, so that's appearances. I don't believe any parties have failed to appear. As far as I'm aware, everyone is here. This is just housekeeping stuff we're going through at the moment. Public comment. As folks might remember, there were 7 public comments filed on the docket in case 21-00083. And I went back and read those the other day, and those do relate to these issues of the procurement, not just the abandonment. I can't remember if every single one related to the replacement resources, but it's my intention to treat those comments as if they were filed in this docket in light of the fact that this case branched off of 21-00083. Is there any objection to me doing so? Very good. No one has contacted the hearing examiner's paralegal, Ms. Kippebrock, to make public comment at the inception of today's hearing. So there is no additional public comment to be made at this point. I received I believe one email from Mr. Yar indicating that he'd filed. I did find a onward exhibit list shared on Dropbox, but he sent me an additional one. So anyway, Ms. Gonzalez has both of those. Is there anything else as far as Dropbox or sharing of exhibits that anyone wishes to address or wants to bring up? Mr. Albright.
Yes, Mr. Hearing Examiner, I'd sent through an email last week, I believe, or maybe it was early in the week, that our exhibits 1 and 1A did not appear in the Dropbox. I just went through again and didn't see those, but they replicate P&M's exhibits. And so we can simply refer to them so we don't have duplicate references. I think all of ours, all of the documents that we filed as Bernalillo County exhibits are exhibits from other parties. So we will just, as best we can, just use those so we don't have duplicate references and duplicate documents, but we don't have any additional documents that aren't already in the record by someone else. But we didn't know that until, for certainty, until we saw what was filed in the Dropbox.
I understand. And just for, I guess your exhibit list will reference those things, but practically speaking, you'll just point to the other exhibits which were already in there. That's
correct, Mr. Hearing.
That's fine.
Thank
Yeah,
you.
that makes sense. Keep it simple. Okay. Anything else Dropbox related exhibits? I mean, apart from objections, I'm just talking about the mechanics.
Your Honor,
Yes, Mr. Gedko.
I don't know if now is the appropriate time, but in one of the pre-hearing motions, the joint supplemental pre-hearing motion, we respectfully requested the possibility of stipulating into the record the direct testimony of Andrea Crane. It was not applicable to the matters that have ended up in the 215 docket, and all parties appeared to agree. Well, they did agree, and there is no cross. And I ask now, just so that if you do want her to make an appearance, Ms. Crane, so that we can bring her direct testimony into the record, I'll want to communicate with her. That's essentially my question.
Yeah. So no, I don't believe anyone has asked to cross-examine her. I mean, we're not going to get to her today. So can I tell you, Mr. Gedko, let me just think about that and look at her testimony. I've obviously read it, but I've been focused on the stuff we're going to address today. Before I answer your question and say I have nothing to ask her, I don't want to say that and be incorrect. So it's not a concern for today, Mr. Gedko. But I'll do that by the end of the day. And let me ask this question: is there any objection to stipulating to the admission of Ms. Crane's materials?
No.
All right, so let me just look at it, Mr. Gedko, and then I will address that at some point, probably tomorrow, frankly. Is that acceptable?
That's wonderful. Thank you very much.
Thank you.
Mr. Hearing Examiner,
Yeah, Ms. Padilla.
Leslie Padilla for PNM. I have, I believe, 3 items to discuss. One of them also relates to whether it's possible to stipulate testimony of several witnesses who have not been reserved for any cross-examination time, but let me know when you want us to go ahead and discuss that.
Yeah, let's do, Well, since we're talking about witnesses and stipulating a testimony, which are the witnesses, Ms. Padilla, that, I mean, I recall you writing about this, but there's just so much
Yeah,
details to handle, so
no,
it's easier.
absolutely. The three witnesses who have no cross-examination time reserved are Kyle Sanders, Michael Setledge, and Elizabeth Eden. In our pre-hearing memo, now in our earlier motion to designate testimony, which also contains some other pre-hearing requests, we did in that motion ask that Mr. Sanders and Ms. Eden's testimony be stipulated into the record if there were no objections. And then also in our pre-hearing memo, we again noted that well, it's a slight variation, but if Ms. Eden's testimony isn't stipulated into the record, that Kyle Sanders be allowed to adopt the relevant portions of Ms. Eden's testimony relevant to this matter. But the three witnesses are Mr. Sanders, Mr. Setledge, and Ms. Eden. I recognize you may have, as with the Attorney General's witness, you may have questions for them.
Yeah, and I have all of those papers nicely organized right beside me. So what I guess I'd like is, if it's possible, I mean, I was just doing as much as I can to prepare for today's proceedings. Those witnesses will not, if they were even to participate, would not participate today, right? We can safely assume that.
Well, Mr. Hearing Examiner, I mean, I know we've been thinking in optimistic terms, and if all of the if all of the reserve time isn't used for Mr. Fenton and Mr. Falgren, it is possible, because Mr. Sanders and Mr. Setledge are our third and fourth witnesses.
Okay, well, let's ask. And I guess, Ms. Spiel, maybe just remind me, did you identify in previous, I see Mr. Setledge's stuff do these witnesses have any contribution to they are going to speak about replacement resource issues, right?
They do. Very discrete issues related to the requirements of Rule 551 for the most part.
And is it a difficulty to, I mean, the only witness that I'm looking at, as far as I may have a question for, I see this next to me is, well, actually Sanders and Setledge. I have some tabs. I do not, I believe I have anything for Miss Eden, however. Let me ask the other parties present, is there any objection to stipulating to the admission of Sanders and Setledge in the event I review that and determine there's no questions?
No objection.
No.
Okay, so I guess the question is for me, Ms. Padilla. I will just need I'm not going to stop now, but I guess as to that matter, I just need an opportunity to look through the testimony again and just verify. I can do that during either our break. I don't think we're going to get beyond Falgren before lunch. Right?
Oh, I would agree with you there. Yeah.
So you can give me lunchtime to answer these questions, and I think I can go through Ms. Crane's stuff too. Although she's like a less priority because that's much further down the line. So I will look at Sanders and Setledge at lunch and come back this afternoon. Is that acceptable?
Yes, thank you very much. And as to Ms. Eden's testimony?
I don't believe I have any questions for Miss Eden. So to the extent, I do see it right over there, and I see I have no tabs. So I'm assuming that means I try to create visual cues for myself to remember stuff. So I don't have any reason to say no to that. Is the protocol to effectively? I mean, I'm not sure how do the other hearing examiners handle that? You know, we're going to treat it as if she appeared today, sat for cross-examination, affirmed that the testimony, she would enter it as if she were present. I mean, is that the basic premise, Ms. Padilla?
I believe so. I'm not familiar with other instances in which we've done that recently, but I think then you would just actually then admit the the testimony so that it is in the record.
Sure. And so can you identify which exhibit that is? Ms.
Certainly.
Padilla?
Ms. Eden's testimony is PNM Exhibit 17. Direct testimony of Elizabeth Eden filed in case number 21-00083.
Terrific. And is there any objection to the stipulated admission of this exhibit? Ms. Eden has not appeared, but as though there's no questions, we're just doing this for efficiency.
Objection.
No objection.
Very good. So we will admit PNM exhibit, say it the number again, Ms. Padilla?
17. PNM
17.
17.
PNM exhibit 17 is admitted. Okay, so that does that take care of that issue, Ms. Padilla?
Yes, thank you.
Those issues in any event.
Yes, thank you very much.
No problem. All right, so now let's move into more substantive questions of housekeeping. I issued a order yesterday on PNM's motion to strike the rebuttal testimony of Mary Lee Souls. So Ms. Padilla, you saw what I write there, I'm sure. Would you like the opportunity to voir dire Ms. Souls? As I indicate, you would be given the opportunity to do so if you wished.
Yes, PNM would like that opportunity.
Very good. So that's going to happen. Obviously not today. That's likely our third day, right? So we're projecting far out actually as to that event. But I don't think anything else needs to be said at this point about the motion, unless you have anything to say, Ms. Padilla.
No, nothing at this point. Thank you.
All righty. Ms. Nanasi, do you have anything to say about that subject?
No, I just figured that we would deal with that on December 3rd.
Precisely. Thank you. Very good. So then there is PNM's objections to the proposed hearing exhibits. I understand for efficiency, everyone wants to move along as briskly as possible. As I thought about it, I've read those objections. Obviously, I've not had opportunity to read all of the testimony. I can't comment meaningfully on what is said in all of the pages that intend to be admitted as exhibits. I hope that's understandable. My view would be that we deal with the objections to proposed hearing exhibits as the questioning proceeds, as would occur in a normal proceeding, as if we didn't have these commission rules that we do everything in advance. And the reason for doing so, and why I'm suggesting that we happen that way, is, you know, the context of the questioning is essential to understand why the document is being sought to be admitted. And so for purposes of ruling on an objection to the document's use, I mean, I think there's some macro objections that, you know, you could probably address and say, I acknowledge a continuing objection on that basis. We don't need to belabor the point, but to the extent to which, you know, the context of how the individual or the party wishes to use the document, I mean, that seems necessary to understand to rule on the subject, right? So that's my proposal. Any comments about that subject?
Nope.
Nope. Very good. All right, so motion wise, all that's I'm going to move on unless there's other things anyone wants to bring up.
Mr. Hearing Examiner, Leslie Padilla for PNM. I did have two other items. One, I just wanted to request also the stipulated admission of PNM's application, just to move things along. That's PNM Exhibit 1. That was the application filed in case number 21-00083.
Yeah, that seems sensible. Is there an objection to the stipulated admission of that exhibit?
Objection.
Okay, so hearing no objection, PNM Exhibit 1 be admitted. Okay, Ms. Padilla, anything else?
Then I did have another question to discuss, and maybe this will need to wait till Monday morning, but PNM again being optimistic about perhaps getting through witnesses more quickly than the amount of time reserved would indicate. We were wondering if it is possible to extend the hearing time on Monday. It might only be slightly depending on what happens today, to allow all PNM witnesses to complete testimony by Monday afternoon. There is a lot of time reserved for PNM witnesses. I tallied up, it's 820 minutes. So that's a little over 13 and a half hours. And I know you had kind of used a rule of thumb, I think 6 hours per day of testimony. So that we're obviously over that with the 820 minutes, but if possible, if it looks like we could extend Monday's schedule a little bit, either on either end or perhaps both ends, starting earlier, ending later, we just wanted to propose that.
Yeah, I mean, so we've had meaningful, okay, I can appreciate why you wish to do that, Ms. Padilla, but one of the things to be aware of is, I mean, I'm sure as attorneys who communicate through writing, we all understand, I think once you get past about 5 hours of meaningful writing, you're effectively useless. And so I'm saying that because think about Ms. Gonzalez. She is this entire time sitting there writing, and I'm understood, not from Ms. Gonzalez telling me this, but from other court reporters we've worked with. It's a significant task, and it's more preferable that we not ask her to engage in heroic efforts, that we really just stick to 8 hours. So that's my response to that. Whether we can move along more quickly than people anticipate, that remains to be seen. And I don't think we could form any judgment about that at this juncture. And I understand, Ms. Padilla, why you wish to have these proceedings concluded. I think at this point, we're just going to have to say, we'll see how it goes, frankly. And if we wrap up quicker than we can or than anticipated, then PNM's interests are served. And if things just take longer, I mean, I don't want to rush my own questioning either. And I feel like I'm in a position I have to ultimately explain a lot of stuff. And, I just had an experience on the TEP case with EPE, and I felt ultimately having sort of the most straightforward, simple explication of, I mean, that's not the most complicated ideas, but you really want to try to help folks understand the issues. And for me, I'm trying to understand a lot of stuff, and then to communicate to others complex ideas, it takes time. So anyhow.
Certainly understood. Just thought it was worth proposing, especially if we do actually move more quickly than we might.
And I think we'll get a sense of that as today progresses. So is that satisfactory for the moment?
Absolutely. Thank you so much, Mr. Hearing Examiner.
Yeah, and again, I'm just saying, I'm not trying to sort of like brush aside your desire to hurry, but my point about the court reporters and thinking about them, I mean, they're essential to the operation today, and we do really want to accommodate them as much as we can. And that's our message as hearing examiners to the court reporters who thankfully work with us. So that's all I can say about that. All right, anything else on those issues? Okay, so we have an order of presentation. I ordered the parties to submit pre-hearing memoranda in which they specified orders of cross-examination and times and everything. And so that process resulted in an agreed upon order of witnesses and the time for cross-examination, which everybody has received. There were amendments made by the interveners to equitably share all the time, and we're going to be utilizing that chart that was supplied to me by everyone. And everyone has agreed to that. So I'm just stating that for the record. And if there's nothing further, we'll move to PNM to bring their first witness.
PNM calls Mark Fenton.
Very good. Mr. Fenton, where are you? There you are. And Ms. Gonzalez. Sorry, Ms. Fenton. Mr. Gonzalez, if you could swear Mr. Fenton in.
Thank you. Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you.
Good morning, Mr. Fenton. How are you?
Good. Good morning.
Could you please state your name and your position at PNM for the record?
My name is Mark Fenton. I'm the Executive Director of Regulatory Policy and Case Management here at PNM.
Okay. And do you have what's been marked PNM Exhibit 2 in front of you?
I do.
Could you identify that, please?
Exhibit 2 is my direct testimony that I filed on April 2nd, 2021.
Do you have any corrections or changes to that testimony to make at this time?
I have three relatively minor corrections that are cites. The first correction is on page 10, line 7. I would like to correct the reference to Rule 550.8. That should be 551.8 instead of 550.8.
Okay, and
My second correction's on page 16, line 16. The reference to section 62-5-9 should actually be 62-9-5. And the third and last correction is on page 24, line 18. The reference to section 62-6-16B should be 62-6-12B. And those are the three corrections, Ms. Padilla.
And Mr. Hearing examiner, I'll represent that those corrections are reflected in the copy of PNM Exhibit 1 that has been uploaded to Dropbox.
Perfect.
With those corrections, Mr. Fenton, is your testimony true and correct to the best of your knowledge?
Yes, it is.
And if you were asked the same questions today, would your answers be the same?
Yes.
Right. PNM moves admission of PNM Exhibit 2.
Any objections?
Nope.
Right.
PNM Exhibit 2 will be admitted.
And PNM makes Mr. Fenton available for cross-examination.
Mr. Throne, you've reserved 125 minutes, so that's 2 hours, 5 minutes. My guess is, Mr. Throne, I will probably try to go for like an hour and a half or something, and then break at a certain point just for, people's needs to use restrooms or, whatever. Is that acceptable?
Certainly. And could you give me a 10-minute warning when we get 10 minutes are left, just so I can focus on questions rather than clocks?
Yeah, that's fine. So what I'll do is I'm going to set my start now for 2 hours and 5 minutes as you've requested. And I think maybe around the hour mark, I'll just see where we are and chime in. Does that make sense?
Certainly. Thank you.
And then for 10 minutes towards the end, I'll certainly provide for that to you as well.
Appreciate that. Thank you.
No problem. All right. So Mr. Throne, go ahead, sir.
Good morning, Mr. Fenton.
Morning, Mr. Throne.
Bruce Throne for Onward Energy. Nice to see you again, and I mean that.
Good to see you.
Thank you. Per the hearing examiner's November 5th order, I just want to make sure you have available to you, in case I have questions about it, Onward Exhibits 3 through 11.
I do. Yes.
Okay, thank you.
Yes, I have somebody here to hand them to me.
Okay, and that was my next question. So who's in the room with you, if I may ask, and are you in communication with anybody else during your examination?
Deandra Lopez, a regulatory administrator's in the room with me. She'll be handling the exhibits. I'm not in communication with anyone else. We're the only two in this room.
Thank you. So as I understand it, you became Executive Director of Regulatory Policy and Case Management for PNM in February of 2019, correct?
That's correct.
And again, off your resume, my understanding is you had that position while case numbers 19-00018 UT and 19-195 UT addressing PNM's application for authority to abandon its interest in the San Juan Generating Station and to procure replacement resources for that resource were being addressed. Is that correct?
I believe that is correct. I'd have to be subject to check the dates of those two cases, but certainly when the final orders were issued in those cases, yes.
Based on your resume, which is your exhibit MF1, Am I correct that in your position, one of your responsibilities is to oversee and manage the preparation of P&M's applications and testimony for regulatory approvals before the commission?
Yes,
And you also submitted direct testimony for P&M in case number 19-000195 UT, correct?
correct.
Just for
And,
clarification, Mr. Throwen, hold on a second. That's 00195, correct?
Oh, I'm sorry. One too
I'm
many.
just noting it for the record so we don't confuse anybody who, whatever reads this effort.
Yes, and going forward, just to save on time and zeros, I'll just refer to that case as 19-195 UT.
Very good.
Thank you, sir, for clearing that up. Prior to your appearing today, Mr. Fenton, did you review Onward's identification of its hearing exhibits in its pre-hearing memo?
I did not. No, I did not specifically look at them. No,
Well, did you look at the identification of them is what I'm asking.
I have it in front of me now, but no, I did not look at Onward's exhibit list.
Okay, why not?
Objection, irrelevant.
Overruled. I want to hear what he has to say about the subject.
I just didn't feel the need to look at the exhibit list. I saw the email. I may have glanced at it on email, but I didn't study it in detail. I didn't feel the need to.
It's correct, is it not, Mr. Fenton, that in case 19-195 UT, in support of P&M's request for commission approval of replacement resources for the San Juan Generating Station, P&M submitted and asked the commission to rely on direct and rebuttal testimony by Nicholas Phillips and Nick Wintermantel. I'll spell out Wintermantel. It's Wintermantel, and who are witnesses in this case. That's correct, isn't it?
I did not prepare looking at case number 19-00195, my testimony or what have you. Is there a place in my testimony that you're referring to?
Well, you were the regulatory policy and case manager, executive director for P&M during that case, and I'm just asking if it's correct that in that case, P&M, in support of its application in that case, submitted direct and rebuttal testimonies by Mr. Phillips and Mr. Wintermantel.
Yes, my recollection is that Mr. Phillips and Mr. Wintermantel were witnesses in that case. I don't remember direct versus rebuttal, but I believe that's an accurate statement, subject to check.
And would you agree with me that the record in that case would be the best record of whether or not they submitted both rebuttal and direct testimonies in that case?
I would agree with that.
And would you agree that whatever the testimonies that were submitted by them were admitted into the commission's record in that case?
I believe they were.
Do you have any reason, as you sit here today, to believe that any of those testimonies by Mr. Phillips or Mr. Wintermantel were not true and correct at the time they were submitted to the commission?
I don't have any reason to dispute that. I think it would be better for you to ask Mr. Phillips and Mr. Wintermantel. They're both witnesses in this case. That I think you have a lot of time scheduled for both of those witnesses.
And is it correct, Mr. Fenton, that in that case number 19-195 UT, P&M also submitted and asked the commission to rely on a direct and rebuttal testimony by Mr. Gary Dorris, and I'll spell out Dorris as D-O-R-R-I-S.
Objection. I'd like to object to this line of questioning about testimony in a case that is not this case. If Mr. Throne would like to move, would like to ask Mr. Fenton questions about that testimony, I will also have an objection at that point. But my general objection is to this line of questioning of Mr. Fenton, who's a witness in the current case, about a previous docket that is not related to P&M's request for new resources in this case.
Right, Mr. Throne, what's the response there?
As you know, Mr. Hearing Examiner, one of P&M's many objections to Onward's exhibits is their objection that there's no proper authentication of Mr. Doris's direct and rebuttal testimonies in the 195 UT case. And so I am addressing questions for the foundation questions for the admission of those exhibits. I'm going to wait until I go through my questions before I move or ask for administrative notice and ask for move for admission. But I believe you wanted to handle that as we proceeded with the questioning.
So one comment is, and to the extent to which we're talking about sort of a macro level issue, I was reviewing Mr. Fenton and Mr. Falgren's testimony this morning at like 7, and in their testimonies, and I don't recall the exact places, but I know it's in there. They refer to what P&M did in 19-00195 at times, and I think for the very obvious reason that these cases aren't all appropriately thought of as like these discrete things that exist in their own universes only. The broader movement as necessitated by the RPS standards and the procurement of renewable resources, and even the testimony today about how one plans to integrate all of this, right? The modeling that one needs to do. These questions all touch on each other in ways that are inescapable. And I believe that, like, in the testimonies of the witnesses today that we'll talk to, they refer to what P&M did in 195 to set the stage for, what they're explaining in their testimony. And that's totally understandable, because you try to do something consistent and rational, not just willy-nilly here and there, right? So I think it seems to me at the broadest level, Onward has to have opportunity as protesting this specific application to talk about what P&M does more broadly as it incorporates new procurements, and that will invariably touch upon what was done in other cases. Ms. Padilla, do you have any?
Well, I do. As to the particular questions that Mr. Throne is asking now, he said he's using questioning of Mr. Fenton to authenticate testimony of other witnesses in another case. That's just not proper. I mean, Mr. Fenton, it's not his testimony. Two of the witnesses that Mr. Throne is asking about are witnesses in this case, so they may be able to serve that authentication purposes. One witness, Mr. Doris or Dr. Doris, is not a witness in this case. It's improper that Mr. Fenton is being asked to authenticate testimony that's not his.
And so let me ask this question, Ms. Padilla. So Mr. Doris, as I understand, I glanced at his testimony just very briefly. He was an independent consultant who was obtained to offer an opinion about the replacement resources in the 195 case. Is that correct?
I believe so.
Yeah, I mean, that's my understanding of his. And obviously, one of the arguments you make there is that he's not a witness in this case.
And so the issue that, if we want to go ahead and talk about the specific issue with Mr. Doris's case, allowing testimony of a person who's not a witness in this case, there would be a hearsay objection for one. There's also a general objection if Mr. Throne is seeking administrative notice. This was briefed in our written objections that testimony is not a proper subject for administrative notice under the commission's rule on administrative notice. And it is not the type of record that's contemplated in that rule. There was a recent decision by one of your colleagues, Mr. Hearing Examiner, that did, deny requests for administrative notice of pre-filed testimony in a previous proceeding.
Yeah, I looked at that actually, and you, Mr. Dia, that's the Lexis citation you provided. Is that correct?
Yes.
I couldn't find the specific portion of that testimony that actually refers to that.
It was an order, I believe, that we cited in that in that citation.
Yeah, no, I pulled it up. I had to actually find it on Lexis, which I eventually did because the Westlaw site doesn't work there. But then I couldn't find where I believe it was hearing examiners Medeiros and Schanauer. I couldn't find in that document where it said something addressing that it would be inappropriate to take administrative testimony of a witness in a prior hearing. I couldn't find that proposition.
May I respond?
Yeah, Mr. Throne, go ahead. Ms. Padilla heard me. Well, what would you like to say, sir?
I mean, well, first of all, I'm prepared to address all of the objections when at the time we ask formally for administrative notice or move with exhibit in. We're not even there yet.
Yeah.
I mean, one of the reasons why we proposed that there be identification of the objections ahead of time was to save time. And now Ms. Padilla is now arguing there orally what they've already put in writing. And what I'd like to do is point out that, I've already established that Mr. Fenton, he's the Executive Director of Regulatory Policy and Case Management for P&M, and one of his job responsibilities is to oversee and manage the preparation of P&M's applications and testimony for regulatory approvals before the commission. That's right off of his resume. And he is the best witness to address whether or not to deal with the authentication requirements to the extent regarding administrative notice of these prior testimonies. I don't want to yet address the case cited by P&M and its objections because we're not there yet, but I'm ready to do that, and I can explain why we believe that their reliance on that case is entirely misplaced. And in fact, the commission has not said you can't introduce through administrative notice prior testimonies of a party and why it's not hearsay. I'm prepared to deal with that, but I'd like to go through my authentication questions with Mr. Fenton first, and then we can address the objections.
Okay. So Ms. Padilla's objection is that Mr. Fenton cannot authenticate some of the documents to which you are referencing. Is that correct, Ms. Padilla?
That's correct, Mr. Hearing Examiner.
And so to the extent to which you're doing that, Mr. Throne, I guess your answer is what you've just supplied me, is that in fact this gentleman should be able to do that in light of the fact that he is the head of P&M's regulatory compliance department or whatever it's called.
And not only that, under the very rules, and even though we understand under our Rule 35 of evidence, the commission is not bound by the Mexico rules of evidence, but even under the rules that are cited by P&M in its objections for authentication, all you need to do for authentication is to establish that a document is what the proponent purports it to be. We're just trying to establish that in fact that testimony was submitted. It was submitted by an individual in his representative capacity on behalf of a party opponent. And it's not even hearsay under the commission, under the rules of evidence of New Mexico. But again, I will make that argument at the appropriate time. But the question objected to was, whether or not Mr. Fenton, in his capacity with the company, can acknowledge that Mr. or Dr. Doris's testimony submitted in case 19-195 UT were submitted by P&M, and P&M asked the commission to rely on that testimony. And I would add one other thing. The testimony we're dealing with doesn't deal with the resources or the replacement resources that were proposed in that case. Yes, that's what that case addressed, but we're addressing the modeling. The modeling that P&M stated in that case was not only necessary for it to inform the commission about what it needed in terms of providing reliable service going forward, but also what the commission needed to consider. And so I will get to that in my argument, but I want to make it clear we're not trying to put in this testimony to address resources that are not at issue in this case. We're focused on the modeling, and as you, I think, correctly pointed out a few minutes ago, there is certainly continuity in that, and in fact, we will establish during the hearing through questions of the witnesses that they acknowledge that there are implications if the commission approves the resources proposed in this case regarding their ability to provide, P&M's ability to provide reliable and an adequate service going forward.
Yeah, and I understand that's your intention. So, Ms. Padilla, I'm going to agree with Mr. Throne on this one. I think, Mr. Fenton, while he certainly cannot, he can identify whether or not P&M utilized Dr. Doris and say, yeah, this person testified in that case and it was admitted and this was the testimony, right? This isn't trying to do anything that's really outlandish. So I'll overrule the objection as to authentication and ask Mr. Throne to proceed. And then to the extent to which we have other fights about whether specific portions of testimony or testimony more generally, he hasn't sought to admit it yet. So we'll put that fight off for whatever amount of time we can.
Okay, thank you.
Thank you.
Thank you, Your Honor. And again, just to get this in the record, clearly, Mr. Fenton, it's correct, is it not? In case number 19-195 UT, P&M submitted and asked the commission to rely on direct and rebuttal testimony by Dr. Gary Doris.
I do recall Dr. Doris submitting testimony in 19-00195. I would like to clarify, though, that Mr. Phillips is our Director of Integrated Resource Planning, and all the modeling testimony that was done in this case, as well as the modeling testimony that was done in the San Juan replacement case, Mr. Phillips directed those resource planning witnesses, including Mr. Wintermantel and Mr. Doris in that case, and in this case, Mr. Wintermantel and Mr. Schlag. So to the extent I do not have an understanding of the modeling that was done in the 195 case, the assumptions that were done in the 195 case, or in this case for comparison and contrast, I am aware that Mr. Doris submitted testimony in the 195 case in the 00018 case.
Okay, thank you. And I'm not going to ask you questions about his testimony, Mr. Fenton. But as you sit here testifying today, do you have any reason to believe that any of the testimony submitted by Dr. Doris in that case was not true and correct?
I don't have any reason to believe it's not. I think Mr. Phillips would be a better witness to discuss what may have changed between now and then.
Am I correct that your responsibilities as Executive Director of Regulatory Policy and Case Management for P&M also included your awareness that on October 21 of this year, P&M filed its response to comments on its 2020 Integrated Resource Plan in Commission Case number 21-00033 UT?
Yes, I'm generally familiar with that. There's a case manager under my direction that was the case manager. And then our legal team put that together. Mr. Phillips, again, he's been the business lead in those comments. So I've had a very limited role in putting those comments together, Mr. Throne.
But you had some role, is that correct?
I had a role in awareness. I have an awareness of that notice of proposed rulemaking. I'm generally familiar with the comments, but not in detail.
Is it fair to say that P&M's response comments in that case accurately reflect P&M's positions regarding the comments and recommendations submitted by other commenters regarding P&M's 2020 IRP?
Could you repeat your question?
Is it fair to say that P&M's response to comments in that case number 21-00033 UT document accurately reflect P&M's positions regarding the comments and recommendations submitted by other commenters in that case?
I don't know about with respect to the other commenters. My recollection at a very high level of that case is P&M filed two sets of comments, initial comments that were due in a very short period of time, and then more detailed comments. I think they were P&M's comments. I'm not sure about your reference to those of other commenters.
Well, I'm just referring to the October 21st, 2021 P&M response comments.
Those were PNM's comments at that time. I would agree with that.
Okay. Okay. Yeah, I have time limited, so I'll move on. At this point, Mr. Hearing Examiner, I would ask for administrative notice in this case of the following testimony in case number 19195 that was previously identified in Onward's pre-hearing memo, and that's Onward exhibits 3 through 9, and number 9 being the P&M October 21, 2021 response comments to comments that were made by other parties on P&M's 2020 integrated resource plan. And I am aware of P&M's objections, and I am prepared at this time to respond to those objections.
So let's go. Yeah, I mean, we'll have give up Ms. Padilla opportunity to speak more as well. But so just for present purposes, Mr. Throne, to the question about testimony in other cases, and you said you're prepared to talk about that. Tell me about that one.
Yes, and based on P&M's objections, I'm going to, if I may, first start with the relevance objections to Onward exhibits 3 through 8. Those are the prior testimonies.
Yeah, and I would say the focus you should principally be on is Mr. Doris. I mean, Mr. Wintermantle and Mr. Phillips are participants in this proceeding. So certainly anything they've submitted previously, they are present here in this proceeding to talk about what they said and can correct any misinterpretations that, or whatever the interveners are going to throw at them, you know? So I'm mostly interested in what you have to say about the testimony of Gary Doris, which I understand is a doctor.
Okay. Let me, I mean, I can skip if I'm not going to have to argue relevance on the others.
Well, you can go ahead and do it if you want to make your record on it, sir. But I mean, I mean, my basic kind of idea would be, well, look, this is they've submitted testimony in prior cases. You're pointing to that testimony for strategic purposes to sort of, meet your interests. To say that, well, it's not relevant. Well, they're here. I mean, they're witnesses in this case testifying as to these modeling matters, so they can talk about that. So if you would wish to say more, you can, but my prime principal interest is in Mr. Doris.
I understand. Thank you. Because of the relevance objections, I do want to make a record on this.
Go ahead.
As I'm sure you are aware, sir, under the Commission's rule of evidence 1.2.2.35A and MAC provides that subject to other provisions in the rule, all relevant evidence is admissible, which in the opinion of the presiding officer is the best evidence, most reasonably obtainable, having due regard to its necessity, competence, availability, and trustworthiness. And I believe Commission hearing examiners have noted in a number of other cases where P&M has objected to administrative notice requests on relevance grounds. For example, Mr. Medeiros, and recently in case number 21-00017 UT, that this Commission's rule of evidence is more liberal and relaxed than the New Mexico rules of evidence in district courts. As provided, as you know, in subsection A2 of the Commission's evidence rule number 35, the presiding officer is supposed to give due consideration, but is not bound by the New Mexico rules of evidence. But as I'm going to address shortly, even under the New Mexico rules of evidence cited by P&M in its objections, that is rule L11-401 NMRA addressing relevance, and rule 11-901 NMRA addressing authentication of documentary evidence. Onward exhibits 3 through 8, as well as 9, 10, and 11, which I'll get to later, objected to, are those exhibits are admissible. The direct testimonies by P&M in this case by Mr. Schlag, and that's spelled S-C-H-L-A-G, Mr. Phillips and Mr. Wintermantle, and even Mr. Fenton, who refers in their direct testimonies in this case, refer in the direct testimony in this case, make it clear that the resource modeling database inputs and methods relied on by PNM to support its replacement analysis and its proposed no new combustion resources in this case, and the commission's approval of those new solar and storage resources in this case will have implications regarding both the types of resource technologies and the amount of their capacities the PNM will need to propose in subsequent resource procurement proceedings in order to ensure that PNM will be able to provide cost-effective and reliable service to its customers as it transitions to its stated carbon-free portfolio objective by 2040. And for example, in terms of relevance, again, as noted in Mr. Spurgeon's direct testimony, at page 32, Mr. Schlag testifies that the new solar and storage resources selected and proposed by PNM in its application will, and I quote, have implications for the resources PNM should consider for future procurements to meet resource adequacy needs, including what he repeatedly refers to as firm resources, such as firm natural gas-fired resources that might be converted to hydrogen or some other non-carbon emitting fuel by 2040. And this is due to the diminishing effective load carrying capability, or the acronym is in all capital letters ELCC, of intermittent solar and wind resources, and what PNM refers to as energy limited battery storage resources that are addressed in this case in the testimonies, direct testimonies of Mr. Wintermantel and Mr. Phillips. Now, for example, in Mr. Phillips' direct testimony in the 19-195 UT case, which is Onward Exhibit 7, for example, at pages 24 and 27, and in his rebuttal testimony at pages 36 to 37, he repeatedly represented to the commission that due to the diminishing effective load carrying capability of new solar, wind, and battery storage additions to PNM's supply portfolio, PNM's modeling, which is based on planning reserve margin targets using Encompass, and Encompass is, I'll just spell that for the court reporter, capital E, small n, capital C, OMPASS. That software and using capacity sufficiency modeling and metrics such as LOLE capacity, which I'll spell that out. It's in all capital letters, LOLE, and then in small capital letters, CAP. That modeling is not adequate either for PNM or for the commission to reasonably assess PNM's resource adequacy and flexibility needs as it transitions to a carbon-free portfolio. Mr. Phillips' testimony in that 19-195 UT case that we've asked for to be exhibits also makes it very clear that PNM and the commission also need to consider resource flexibility, adequacy modeling, and metrics using ASTRAPES, and I'll spell that ASTRAPE', their proprietary SERVM software. SERVM is in all capital letters, SERVM, or some similar reliability modeling software and metrics, such as those measured by another proprietary software, which is called PowerSim. I'll spell that out, capital letters, POWERSIMM. And that was the Ascend resource planning model that was addressed by PNM witness Dr. Doris in that 19-195 UT case. When PNM submitted that testimony, Mr. Hearing Examiner, they didn't do it as cumulative or redundant testimony. They did it because the flexibility modeling that was provided by Dr. Doris, as well as the using his proprietary PowerSim model, as well as the flexibility modeling and metrics and analysis provided by Mr. Wintermantel, who relied on SERVM. They provided additional information that P&M said was very important for the commission to consider to deal with the fact that as these more and more intermittent resources, particularly solar and wind and storage, as they're added, they have a lower and lower or diminishing, in their words, effective load carrying capability, which then raises concerns about whether or not P&M can meet its needs going forward because of a lack of flexibility of its resources. That is the ability of resources to ramp up and ramp down when there is a sudden change in the output of those intermittent resources.
Mr. Throne, I don't want to cut you off and make your record. I mean, I've understood that's what we're fighting about here, and if ultimately the position of Onward Energy is that Valencia is necessary, and that's where this is headed. I guess two questions real quickly. So tell me about former testimony and why is that? I mean, it seems 1.2.2.35. I don't mean to go too fast with a court reporter, but D1D, so 1.2.2.35 D1D, the commissioner presiding officer may take administrative notice of decisions records. I mean, the word record, it's a lot. It's a lot of things that could fall into the category of records.
It is.
Dr. Doris was Dr. Doris subject to cross-examination in the course of the admitting testimony in the.
Yes, he was. I was getting to that. I was trying to do relevance first, but.
No, I understand your relevance argument. I know exactly where you're going.
Okay.
With this.
Okay. Then I'll move on to the administrative notice objections. And you're exactly right. Contrary to the objections that P&M submitted under the our evidentiary rule 1.2.2.35D parentheses 1 parentheses small d, as well as 1.2.2.35.g of New Mexico Administrative Code. These are a proper, these are records, a prior testimony that is, again, wasn't just pre-file testimony. We don't have a situation here where someone pre-files testimony, doesn't show up for the hearing and is not subject to cross-examination. These were admitted and subject to cross-examination. And the witnesses testified they were true and correct to the best of their belief at the time they submitted it. And so, I think that part of their P&M's objections is clearly not supported by the rule.
Okay. And so, Ms. Padilla, I guess the question I'd have for you would be, so Mr. Throne's asking a very reasonable thing. I want to speak about P&M's former expert that it utilized, who talked about matters that are touching upon the things that we're here today to talk about, and ask witnesses questions about what that consultant stated under oath and subject to cross-examination in another case. I mean, that doesn't strike me as something that Mr. Throne is probing into areas where there's records that P&M wouldn't have notice of or can claim ignorance about. I mean, was P&M's witness in a former case who offered testimony subject to perjury and under cross-examination. I mean, it strikes me as something very reasonable to request to admit.
Let me first address a more general issue, and that is, while we object to the commission taking administrative notice of the prior testimony because it is not a type of document that's contemplated by the rule. So we would also object to their being admitted into evidence. We have not objected to the prior testimony of Mr. Wintermantel, Mr. Phillips being used to cross-examine those witnesses. They're here. They will be here. So we have no objection to Onward using that prior testimony in cross-examination of those witnesses. If they remember that testimony, if they're familiar with it, of course, all of those usual things. As to Dr. Doris, however, he's not, again, I think there's just a more basic issue of him not being available for, cross-examination and subject to subject to cross in this case.
Well, I think Mr. Throne's, I assume, I don't know. I mean, I'm just assuming he's going to say, well, Dr. Sodoris said this, and tell me, Mr. Fenton, how is what you're doing now consistent with that? I mean,
Well,
that's what I
here-
anticipate.
Then we have a hearsay objection because he would be using that testimony for the truth of the matter asserted.
Right, and I'm just trying to remember off the top of my head the rule for what is the Latin term for the hearsay that allows. So hearsay. In an administrative proceeding, the hearsay problem is only a problem if there's absolutely no evidence available to support the proposition. I mean, in some ways, it's a strange thing because you're the applicant. You have to prove this, and you couldn't rely on it. That's what that rule's
Right.
about. Mr. Throne can certainly point to former testimony bearing on similar matters and say, hey, no, this application or the modeling used to submit this shouldn't be the paradigm moving forward.
Right.
Mr.
Hearing Examiner, you kind of made me recall one other issue that I wanted to raise, because one of the first points that Mr. Throne made was that, the best evidence rule. I think the best evidence of the points Mr. Throne is trying to make would have been rebuttal or discovery. In this case, they did, Onward conducted extensive discovery. And that probably would have been better evidence because it would be more in proximity to the request that we're making in this case. So I just wanted to make that point, but I think we'll leave it there in terms of explaining our objections.
I understand. Thank you, Ms. Padilla. Go ahead, Mr. Throne. Yeah.
Okay, well, first on this best evidence rule, I mean, that's a misapplication of the rule. We already quoted to you what's the most reliable evidence about what a witness said in a prior case. I mean, even with the time allocated to me, which I understand the reason for the constraint, the best evidence of what a witness said in a prior case is his testimony in the prior case that was admitted into the record.
Agreed.
There's no point in me of asking Mr. Phillips, do you recall saying such and such in this case? When the rules allow us to put administrative notice in saying this is exactly what he said. This is exactly what Mr. Wintermantle said. And this is exactly what Mr. Doris said. And by the way, in the testimony that in the prior 195 UT case testimony that Mr. Phillips that we've asked to be admitted, he specifically relies on the testimony, the direct testimony by Mr. Wintermantle in that case and by Mr. Doris in that case. So I think that's a misapplication of best evidence concepts. But more importantly, I think I was going to get to this, but we're here now, is the whole hearsay. Even under the rules of evidence, the district courts, this is not hearsay. The rule is NMRA Rule 11-801 D parentheses 1 and parentheses 2. Okay, that is the definition of statements by a declarant or by a person authorized on behalf of an opposing party to make a prior statement. Those are not hearsay. And this is a party opponent, and this also explains why the citation that P&M provided you with to the hearing examiner's 2019 order denying requests by San Juan County in the city of Farmington in the 19-00018 UT case for administrative notice of prior testimonies, why that's not opposite and is not supportive. There are three distinctions. First of all, in that case, that was a case where the parties in that San Juan case were trying to supplement their own testimony in that case by asking for administrative notice of prior testimony by their own witnesses that didn't appear in that case, in a prior case. We're not asking to supplement our testimony with prior Onward testimony or Southwest Generation testimony. This is testimony by a party opponent. So that case was a totally different situation. Secondly, there were procedural violations by the parties trying to ask for administrative notice. They hadn't properly identified it ahead of time as required by the hearing examiners in that case. And lastly, again, we get to this whole hearsay issue. It's not hearsay. And I mean, I have a copy of the rule here. I don't know if it's readily available to you, but again, it's Rule 11-801, and statements that are not hearsay and subject. So
I'm familiar. I know. And I, Mr. Throne, just FYI, I mean, I had Mr. Yar in a case involving it was a emergency medical transport, non-emergency medical transport. And the similar problem came up in which, there was a motion to keep statements of the ambulance employees out. And the answer was, well, no, the answer was it's party opponent. And I wrote that. So I'm familiar with your arguments. I didn't understand where you're going with that.
May I just add one other thing, because P&M threw a lot of objections in, and I just want to make sure I cover all of them for the record. So that there's no question that they weren't adequately addressed at the hearing.
No, I'm just thinking about your time. I'm trying to keep you moving along. I know you want to ask
I know.
questions.
Well, I had hoped to save time by another procedure, but I knew this was going to happen because I've been involved for over 40 years with P&M. So I know they like to waste my time with this. Okay, they argue at page 4 of the objection that P&M would be prejudiced by Dr. Doris's testimony. Well, that is not a grounds for excluding testimony under the rule of 11, New Mexico Rules of Evidence 11-801 D2. I mean, in fact, the very purpose of that rule is to allow in statements by a party opponent that may be inconsistent with their position in the current case. And then finally, I think this is their last objection. Well, they object also on the grounds that providing or admitting administrative notice of Dr. Doris's testimony would violate the hearing examiner's August 27 procedural order in this case, and we're requiring witnesses to appear if their pre-filed testimony is going to be admitted. That's just a misstatement of the order, and also the commission's rule 1.2.2.35I NMAC. Again, this is not a situation where we're trying to get in prepared testimony without a witness being sworn in and subject to cross-examination. So that would cover the prior testimonies, and I am prepared now to turn to their objections.
Could I just add one thing? I do have the Westlaw citation for the order by hearing examiner Medeiros, and so apologize if well, no, see, it is the one that we 625-2301.
Yeah, but so when you plug that into Lexis, which is what the commission purchases for us, it can't, it's not discoverable. So I had to go in to Lexis using the commission's search field, and then you can pull it up and it comes up. The pagination is different. See, this is the importance of vendor neutral citations for those who have done other stuff. It's like, this will drive you crazy.
So, Mr. Hearing Examiner, you did not find the order denying
I did, but
request?
I don't know. The Lexis version is not the same as the Westlaw. So you cite page *3.
Oh.
There is no page well, there's the 3, but it's the Lexis version of 3. And however they all format their authority is different. So
I see. Because
that's the trick.
I did want to point out in response to Mr. Throne's arguments about that is that the hearing examiner in that case did conclude that prior testimony is not a type of document that the rule contemplates. It's and the second finding was that the testimony did represent, I'll quote, prototypical examples of inadmissible hearsay. So again, as to the prior testimony of Mr. Wintermantle and Mr. Phillips, we don't object to Mr. Throne questioning those witnesses about that. We do not think it's appropriate for the commission to take administrative notice or for the testimony to be admitted into evidence. And
Okay,
as
so
to Dr. Doris, we do, we would object that we would object to his testimony being used to cross-examine witnesses in this case and not Dr. Doris himself.
Just two questions, Ms. Padilla. Is there, do you agree that Dr. Doris was subject to, be sworn in and subject to cross-examination during the course of that proceeding?
I would assume so, but I don't have direct knowledge of that. But of course, I would assume so since he was, well, Mr. Throne, I mean, I do have to answer in that way. I was not involved in that case. But certainly I would assume so.
Okay, and then I guess the next question I had for you is, I've heard a lot of discussion in commission meetings about decisional silos, right? And so in some ways, what Mr. Throne is trying to establish here is, this is a decisional silo. And if you look at other statements, this is not consistent. And that's why he wants to talk about what our Dr. Doris said.
But
and we can dispute that. I understand.
I would just add though, I mean, the proper, I mean, he's looking at the underlying testimony in a case. Wouldn't a decisional silo, if you wanted to avoid that, you would look at what the commission actually determined in that case and what's in the recommended decision and final order.
Right.
Those
I understand
would be
that.
proper subjects for administrative notice.
Let me ask this is the question I wanted to ask, which was, is there a mechanism that Mr. Throne could utilize to talk about Mr. Doris's testimony? Because Dr. Doris was, or Mr. Doris, I don't know if this person's a doctor. How does Mr. Throne talk about that to the extent to which he wishes, if you don't make that person a witness in the case?
Well, Mr. Hughes, I don't think if Mr. Doris's testimony were cited or discussed in the recommended decision, that would be, I think that would be appropriate. If the commission depended on Dr. Doris's testimony or findings or conclusions to reach its decision, that would be appropriate.
Okay. So I appreciate the citation to authority that you've noted, Ms. Padilla, but I think, so what two things I'll say real quickly. As to the ability of, we just heard Mr. Fenton say effectively, I don't really know a whole lot about certain subjects. So that's going to have to guide Mr. Throne's inquiries in this matter. I mean, it appears to be there's a particular witnesses that are going to be capable of speaking about stuff, and there's no reason to continually ask a witness questions if they don't have answers to it. So let's just keep that in mind. And then the second position I would take is, Dr. Doris appeared as a PNM witness in a former proceeding, was sworn, and then offered testimony subject to cross-examination. I fail to see how we couldn't take administrative notice, not to establish the truth of what Dr. Doris said there, but at least as to PNM's thinking as to how resource modeling should be conducted, to the extent to which Dr. Doris already spoke about such subjects, and that's in the person's testimony. It just seems perfectly reasonable to say that is a matter we can look at and then use the basis for questioning if it appears there's inconsistencies with what witnesses are now saying in this case. Now, I'm not judging whether any of that is actually true. It's just, can we ask those questions? And if Mr. Throne wasn't permitted to do that, you effectively wall off a witness and the witness's testimony. And I don't know if he could subpoena the person. I mean, that's the only other thought I had, but I mean, I'm not going to go there really, frankly, because I think you could take administrative notice of that record and use it to question a witness in this case to establish or fail to establish that what PNM is doing now is in Mr. Throne's view wrong, right? And I know right or wrong isn't exactly where we are, but that's the basic point.
Mr. Ryan, may I?
Yeah, go ahead, Mr. Throne.
Yeah, I want to point out something else. Number one, with the time constraints we're having, in addition to, I'm not going to ask Mr. Fenton about Dr. Doris's testimony. I've already explained that the best evidence of what Dr. Doris said and told the commission, said, here's what we think is you should rely on, is that testimony. But I want to point out that the other purpose of administrative notice is simply so that we can refer to it in our brief. I've been in countless cases with PNM where if anybody refers in their brief to anything in a prior case that was not, for which administrative notice was not properly taken and granted, they've objected to it, and hearing examiners have agreed with them. So, I obviously now don't have with the time allotted to question about all the prior testimony, but we should be allowed to address it in the record. And one of the reasons why we put the entire testimony in there is so that P&M can't do also what it usually does, is object on the grounds that, well, you can't put part of it, you're taking it out of context. So we put the whole thing in there, and that allows us to cite in our post-hearing brief to you what we think is relevant and supports our position. And P&M and the other parties can rely on anything that they think that's in that testimony that doesn't support it or supports their position. So I just wanted to make that point, and also, and I know we haven't even gotten to the exhibit onward exhibit 9. I want to get to that, their objections to that, but I'm hoping you're going to give me some allowance here on time, because we filed this joint motion with New Energy Economy to avoid this kind of extensive re-arguing of the same thing that P&M has argued in its papers. And now it's and one of the reasons why I asked for more time with Mr. Fenton is I anticipated this, because as I say, I've been doing this a long time and I know how P&M rolls. And so I would ask that, we be able to move on so we can make our rulings and I can continue with my cross, and I get some allowance here on my time, because, well, I'll stop.
Yeah, okay. I mean, right, so we've already heard from P&M on the Wintermantel and Phillips. That's onward exhibits 5, 6, 7, and 8. Ms. Padilla, I'm not misstating that you said that you are amenable to admission of those documents to the extent to which cross-examination of Mr. Wintermantel and Mr. Phillips, that Mr. Throne is going to reference these documents and ask those gentlemen questions.
No, Mr. Hearing Examiner, we don't object to those documents being used in cross-examination, but we do object to their admission into evidence in this case. If Mr. Throne wants to question our witnesses about those documents and use that testimony elicited from that questioning in any briefs, that's acceptable. But what we don't want is to allow a document to come in, evidence, and for Mr. Throne and onward to cite documents that haven't, portions of those documents that have not been, haven't been questioned, subject to questioning of our witnesses. So,
but they could question, they can answer them right in this case. I mean,
yes.
So to the extent to which those things are admitted, and you're saying, well, Mr. Wintermantel, Mr. Phillips, didn't you really mean this when you were talking about that in this case? They could just say, well, yeah.
Or Mr.
Right?
Throne could use other portions of the testimony besides, because that's what he just suggested he wants to be able to do in briefs. If he wants to ask questions of our witnesses without that's fine, and you don't need to introduce an exhibit into evidence to do that, or seek administrative notice of it either.
Mr. Ryan, if I may.
Sure.
With respect, Ms. Padilla is rewriting the commission's rules of evidence. There is no commission rule that says that the only way you can use a document for administrative notice is through cross-examination, but it can't be admitted. In fact, that, if a document under the commission's administrative notice rule, if it's admissible as administrative notice, it's in the record, and then parties can use it however they want to use it. But for her to basically suggest that there should be a limit in how I can use the document, they're just making up a rule here.
That is why we object to taking administrative notice of it. But Mr. Throne can question our witnesses on those documents. So I don't quite understand.
Let's stop. Let's not have it go just yelling match each other. But Ms. Padilla, real quickly, again, explain to me how this is not a record. And then another matter you can take administrative notice of is a transcript. Transcripts themselves are just commemorations of statements in other commission proceedings. How is these witnesses' testimonies not a record in another commission proceeding?
I think that I would think that the transcript would be of the
a transcript of the proceeding itself?
Maybe a transcript of a commission meeting. So the list of documents in the rule, obviously rules, regulations, administrative filings, contents of certificates. tariffs, classifications, decisions, records, and transcripts and other commission proceedings, statutes. It's documents that have some kind of, to use a fancy word, imprimatur of like of officialness.
Mr. Ryan, with all due respect, as I think commission is aware that all of these exhibits were not only admitted in the record, they're actually attached to the transcripts. I mean, that's how we had to get him to submit them, because we couldn't use the pre-file testimony. We had to use the testimony that was actually admitted at the hearing because of the corrections that were made, and we didn't want to be subject to objections on the grounds that this isn't the corrected testimony.
Yeah,
Examiner, I am so sorry. Mary Ellen Lanassi, New Energy Economy. I know that this is not my witness, but this is just like on the verge of ridiculous at this point. These are P&M witnesses. They're sworn statements of party opponents. They absolutely are not hearsay. And this is a regular thing that
I don't think the question
have-
is hearsay. Is it appropriate to take administrative notice of testimony from another proceeding? And it's a theoretical matter, like much of the rules of evidence is about sort of reliability of stuff. I mean, that's what all hearsay is about. And it's a similar question to what we're facing here. But I mean, I think ultimately my judgment is that former testimony that has been admitted in a proceeding for related matters that P&M has offered to support an application should be able to be examined to test the testimony that they're offering in a subsequent case. I mean, it's not like Mr. Throne is pointing to something that is just, it was never in P&M's control even. I mean, these witnesses appeared for P&M, offered testimony at a hearing for good reason. And then he's saying, I just want to be able to look at that testimony and I understand the next part is to say, well, then now he can ask our witnesses, but not admit it into the record. I don't know that I agree with that. Administrative notice of a record in a commission proceeding where it's been subject to the witness was sworn and there was cross-examination. There's no risk of reliability. There's no problem with him pointing to former testimony if in fact it appears to be inconsistent with what P&M is saying now. And I know that's his view. So I don't see any difficulty with taking these documents for purposes of administrative notice. At least 1 through 8.
Address number 9 now?
Sure.
Sure. Again, there were 2 objections to Onward Exhibit 9. Those are the October 21, 2021 response comments by P&M on its 2020 IRP in case number 21-00033UT. First, as to the, we've already covered this. These are properly subject to administrative notice under the administrative notice rule. That's 1.1.2.2.35 capital D, 1 small d, and G of that rule. So I won't belabor that point. These are also records. They're records on file in another. Literally, the rule D1D literally says records and other proceedings. So I will turn then to the relevance objection, which is the other objection to those comments. First, those comments are relevant because P&M witness Mr. Phillips expressly relies on the Encompass and Serva modeling used by P&M for its modeling in its 2020 IRP in his direct testimony in this case. And in fact, he includes that IRP and the modeling in its entirety as exhibits, P&M exhibits NLP-1 and NLP-2 to his June 14, 2021 supplemental testimony. A second reason why it's relevant in this case is because P&M is asserting in this case through Mr. Phillips' rebuttal testimony at pages 11 and 12 and 25 through 27. And indeed, and even in its objections, that the commission need not address the resource modeling issues and recommendations addressed in Mr. Spurgeon's direct testimony because they are outside the scope of this case. However, these P&M response comments assert, for example, at pages 30 and 37, and I'm going to quote here, that the commission's, quote, IRP rule does not contemplate that the commission can impose RFP or modeling requirements in an IRP proceeding that reach into separate resource acquisition cases, close quote. And those comments there go on to assert that the commission can only address those RFP matters and modeling matters in a utilities resource acquisition cases, which is exactly what this case is. P&M's position appears to be, no, we should just keep kicking the can down the road and we'll look at RFP and modeling issues in the next case. But the problem is, by the time the next case arrives, P&M repeatedly, and he did it in this case, says we need pretty prompt action by the commission approving both our modeling and our proposed resources, because if we don't get that, we're not going to have those resources in place in time to avoid brownouts in the future when we need those resources. So those comments are relevant in terms of the appropriateness of addressing the recommendations by Onward and Mr. Spurgeon's direct testimony at pages 90 to 92, why that is within the scope of this case. And finally, there's another reason why those comments are relevant. And I will point out, by the way, to the extent that P&M also objected on the grounds that they were not, was not timely to address this. Keep in mind that the comments were filed on October 21 of this year, which was after the deadline for rebuttal testimony in this case. The PM comments, response comments, are relevant because they acknowledge at page 9, for the first time in front of the commission, that the Encompass model, and I'm going to quote here, quote, has the functionality to model ELCC curves only for individual technologies, parentheses, or resource types such as solar, wind, or 4-hour batteries, close parentheses, and cannot model dynamic ELCC for a combination of resource types, close quote. And those comments also go on that page 9 to basically say that that limitation in the Encompass modeling, which I believe is apparently a limitation for CERVM as well, quote, may lead to an underestimation of synergistic effects between new resources, close quote, as the amount of the new resources additions proposed by P&M grows compared to the existing capacity in its portfolio. Now, this is relevant because, as we will get to during the hearing, particularly with Mr. Phillips' testimony, but also with Mr. Winter's testimony, is there are certain assumptions in the modeling regarding effective load carrying capability curves for solar, particularly the 450 megawatts of new solar that P&M is proposing in this case. And that's going to have implications, as I said earlier, and as Mr. Schlag says in his direct testimony, for what kinds of or what types of technologies P&M is going to have to rely on, and how much of that and the cost of that it's going to happen in subsequent resource procurement cases. So that's why it's relevant, and that's why it's timely. And this is something that, of course, could not be referred to by Mr. Spurgeon in his direct testimony, or for that matter, his rebuttal testimony. Although I believe Mr. Spurgeon did explain that he did not try to analyze the reasonableness of the effective load carrying capability assumptions in P&M's model.
So Ms. Padilla, I'll give you a chance to respond. Before I let you say anything, I just wanted to ask, I'm looking at that document right now, the October 21, 2021 PNM response comments in docket number 21-00033. And did you write those comments?
Mr. Hearing Examiner, I was the lawyer responsible for working with PNM's resource planning team on those comments.
Okay, I'm just looking at the very last page. It's page 43, and it's just your signatures there. And I'm just wondering, and I guess my question is more generally is, I mean, are these facts, or is this like some sort of pleading?
Mr. Hearing Examiner, is it pleading? The IRP rule requires, has a process that allows commenters to make comments on filed IRPs, and then the utility is obligated under the rule to respond to the comments that are received on the IRP. So
Okay.
that's what this document is.
So I mean, are these facts or is this law?
Well, I'd say it is a factual response to the comments that parties made to PNM's 2020 integrated resource plan.
Okay, so then now my next question is if you wish to respond to what Mr. Throne had
Yeah.
just described there.
First of all, as to administrative notice, I mean, I know this, I don't want to belabor this, but if any record is allowed to come in under subsection D of the applicable rule here, if I think Mr. Throne's position is that anything that's filed in a case, I mean, is a record that at what point does the commission not allow anything that's filed in a case to come in as for administered notice? Excuse me.
Well, no, we're just talking about sworn. I mean, I understand that argument, but I mean, my response to that would be the testimony of individuals offered by PNM who were subject to cross-examination and put under oath. I mean, the fact that those procedures occur, I mean, there is a certain degree to which we can have assurance that their testimony would not, I mean, it can only be so manipulated in some future proceeding, because we're not talking about any document, right? We're talking
Right. I mean, what the PNM response comments are, not sworn testimony, of course. We stand by our comments, of course, but
Right.
we don't think it's appropriate for administrative notice in this case. And then as to relevance, the issues, the resources that PNM is seeking approval of in this case are current resources that we need to have online in 2023, and they're based on our past resource modeling. Mr. Throne, and I recognize that his onwards position is that resource modeling and assumptions should change in the future. But as to the issues that are before the commission in this case, the resource planning, the resource acquisition proposals, we do not believe our response comments to an IRP, to our 2020 IRP are relevant. I'll leave it at that because I know we do need to move on. But Mr. Hearing Examiner, if I could just say, this is the typical way that parties object to exhibits when the party is seeking to introduce them. And I know Mr. Throne wanted to save time by doing this in advance, but this is fairly typical in my experience that you would, make these objections to exhibits at the time that the party was seeking to use them in a hearing.
Yeah, no, I appreciate why Mr. Throne's asking, because he wants to use the maximum amount of time he can to question the witnesses. So it's fine. I'm not too concerned about anything. I appreciate that. But so as to the IRP document, it strikes me, Ms. Padilla, that there is also discussion in witness testimony, PNM's own witnesses in this case, and I'm at a loss to say exactly where. There's a whole lot of documents, but I know that I encountered varying iterations, and perhaps it's responsive to Mr. Throne's witnesses, Mr. Spurgeon's testimony, talking about the IRP and whether what's going on here is consistent with what they're saying in the IRP context, and it seems like it just interjects it all. And the broader point ultimately, though, is that PNM should be saying consistent things in all proceedings if in fact they have if PNM has a concrete sense as to how it should be proceeding with replacement resources. And that's Mr. Throne's position. And I don't see the evidentiary problem with admitting a document that PNM saying in another proceeding that's frankly is kind of like inseparable in some ways. This is our position over here. So as an evidentiary matter, I mean, it's PNM's own statements, and I don't see how that could be problematic for purposes of administrative notice, as it is a record in another commission proceeding. In any case, so let's just do this. All right. So my judgment ultimately, as I've read PNM's objections, the memo that was submitted prior to this proceeding. I'm familiar with what was said there. We've just had extensive discussion about all of this. I think it's permissible under commission rules, cited and discussed already at length, to admit onward exhibits 3, 4, 5, 6, 7, 8, and 9 into the record in this case. I mean, the caveat I will add to that is none of this is being admitted to relitigate what is going on in 195. It is all being admitted to evaluate the position in this case of Onward Energy that PNM is somehow engaged in something that's incorrect here that needs commission attention and action. So all we're talking about is the consequence of what was said in a prior case to the issues before us now. So unless I need to say anything else, I mean, that my ruling would be to admit those documents through administrative notice. Anything further? Okay, it's 10:41. We need to probably take a break. At least I know I do. I think we can come back, and then why don't we just call this a 10-minute break? So Ms. Gonzalez will go off the record now. Let's come back at, I'm sorry, my cell phone I have to look at that. It's 10:46. Let's call it a 15-minute break. We'll come back at 11. Okay. 9 into the record in this case.
Sorry,
That's okay.
I'm trying to put an exhibit marker in here. Exhibit marker, exhibit.
Okay, it's 11. Ms. Gonzalez, we'll go back on the
Yes.
record.
I'm ready.
Mr. Throne, back to you.
Yes, Mr. Hearing, could you give me an idea of, given that we spent about an hour on the
We
objections?
did spend almost, it was an hour. I have 51 minutes left. You know, if you need a little extra time, I understand. We took a lot of time there with that discussion, so.
Thank you. I'll proceed as expeditiously as I can. Mr. Fenton, I'm looking at your resume, your exhibit MF-1 on your direct. Tell me when you have it in front of you.
I have it in front of me. Thank you.
And under your professional experience, and there's a second paragraph where it says, in my current position, I oversee and manage. There's 4 bullet points. That accurately describe your responsibilities?
Yes, it does.
And as part of those responsibilities, does that include your access to communications between PNM's counsel and counsel for other parties and Mr. Stephen Schwebke, that's spelled S-C-H-W-E-B-K-E?
Stephen Schwebke is a case manager. He does not report directly to me. He reports to Carrie Salas, who does report to me. But I wouldn't say that I'm responsible or familiar with all of their communications, but
in terms of matters that come up during a case, to the extent there is communications like that, you have access to that, don't you, as the case manager?
well, I'm not a case manager. I'm the executive director of regulatory policy, but I may or may not have access to an email like Mr. Schwebke that you used as an example there. He reports to Carrie Salas. I may be copied on an email, or I may not be. It's hard to say.
Okay. And was that sort of the chain of command, so to speak, or how things worked in terms of case management in that case number 19-195 UT? Similar.
Similar. Yeah, okay. Similar.
Yeah. Did you have, I want you to take a look at what's been marked as Onward Exhibit 10. Those are the email exchange between me and Mr. Ryan German and some other parties at PNM regarding access to confidential information. Do you have that in front of you?
I'm getting it in front of me, Mr. Throne. I have not looked at this previously, as we discussed earlier.
Why don't you take a look at that if you would, sir? You have that now?
I haven't read the whole thing. It's a couple pages here. I just started reading it.
Yeah.
I have quickly reviewed this.
Okay, and you recognize the names. Well, first of all, Ryan German is one of PNM Resources attorneys that was involved in that case where you testified. Is that correct?
He was. I don't know how heavily he was involved, but I think he was involved in the discovery phase of that case, and he is an attorney with PNM. Yes.
Right, and you recognize the CCs to the PNM representatives on that email as involved in that case.
I am familiar with the PNM and Mr. Alvidrez, who's not a PNM employee, but is an outside counsel for PNM. Ms. Goodwin is Associate General Counsel, and Steve Schwepke is a case manager at PNM.
Okay, and then looking over at Onward Exhibit 11, take a look at that, would you please? And that's the Southwest Generation Operating Company's notice of withdrawal of a prior request by Jeffrey Spurgeon for access to confidential material. You see that? It says it's got the stamp showing the date in which it was filed with the commission, in that case number 19195 UT.
I see that it was filed on November 8th of 2019 and executed by you as the attorney.
Yeah, and so because you were involved in that case, does this refresh your recollection? Does this refresh your recollection that first of all that that there had been a filing by Mr. Spurgeon, who's actually a witness in this case, of a confidentiality agreement pursuant to the protective order in that case, but then that was withdrawn on that date.
Not really, because this appears to be a discovery issue related to confidential materials. And
Excuse me,
Yes.
Mr. Bender, just one moment. I'm sorry, I was on mute. I think I need to note that we do have, we did lodge objections to both Exhibit 10 and Exhibit 11.
Yes.
Onward Exhibit in writing, and it appears that Mr. Throne is attempting to use Mr. Fenton to authenticate these documents. I would
Yes.
point out he is not even copied on the email. That
Yes.
is Onward Exhibit 10. And so that's kind of I think a predicate to speaking about Exhibit 11 and whether Mr. Throne could authenticate that.
Yeah, no, so well, there's two questions there. I mean, yeah, Mr. Fenton knows nothing about these documents, obviously. Ms. Padilla wrote in her motion, why wasn't this admitted as part of his direct testimony? And then I guess the third question is, I've never seen these documents before. What is the relevance of this material?
All right, I'm prepared to address that now. I hadn't moved it in. I was trying to, again.
Yeah, I know where you're going.
Yeah, okay. So let me go ahead and respond to that. So again, we think these are well, certainly the notice of the purpose of the notice of withdrawal is just to show that that occurred, and the purpose of Exhibit 10 is to show the reason why it occurred, because it's not readily apparent to the commission why Mr. Spurgeon withdrew, is because PNM objected on the grounds that that the database for modeling and RFP bid information provided in the modeling, which was provided to other parties as confidential material, could not be accessed by Mr. Spurgeon or anybody employed in-house by Southwest Generation, because Southwest Generation was actively involved in competitive requests for proposals conducted by PNM. We didn't want to make an issue out of that case. We weren't, Southwest Generation was the predecessor of Onward Energy. We weren't involved in the case to try to gain any competitive advantage. And so to avoid any controversy about that, the notice of withdrawal of Mr. Spurgeon's confidentiality agreement was filed. the evidence of why they did that was P&M's objection, but that P&M, objected as part of discovery, so they didn't file it. We avoided that kind of a fight, formal objection. Why is it relevant? But we're not contesting, and this is kind of a misrepresentation in the objections. We're not contesting because we're not admitting this or asking for it to be admitted because we protest the position of P&M that Onward or any other competitor that's involved in RFP process should have access to confidential information. We accept that. The reason why this is relevant, it's relevant because, and this has to do with the recommendation in Mr. Spurgeon's testimony regarding future reasonableness of P&M's requirements for access to parties who want to, because they don't have the resources to conduct their own modeling using Encompass or SURVEM, which is extremely expensive, and you have to have experts to even understand the databases that go into that. So there was another method that was adopted by former hearing examiner Glick in this case, as proposed by P&M, that parties could request it, but the only way they can request it is by going into the confidential database that P&M has provided on its venue site and indicating precisely which of the inputs need to be modified for the request. Well, in order to do that, you have to have an expert. And so the point of this is to show that unless you hire and spend hundreds of thousands of dollars, frankly, to get someone trained on Encompass and SURVEM who understand these databases and exactly how they need to be modified, it really doesn't provide access, a reasonable access to not just Onward, but to other parties or for staff for that matter. And we'll get into this more during the hearing. But we're talking about going forward. In other words, we're not challenging that in this case, but Mr. Spurgeon's recommendation is going forward. There should be a different method proposed and addressed by the commission, so there is reasonable access by parties if they want to model any combination of resources that are proposed different than that which is proposed by the company going forward in its resource procurement cases. So that's what this relates to. And as to their objection that this should have been put into Mr. Spurgeon's direct testimony, we're responding here to the rebuttal testimony of P&M. Onward and Mr. Spurgeon did not know what P&M's position was going to be regarding Onward's and Mr. Spurgeon's recommendations regarding RFP practices and modeling going forward until P&M filed its rebuttal testimony. And that rebuttal by Mr. Phillips basically indicates that he believes that not only are they not necessary, I think he used the word, they're not meaningful, they wouldn't be helpful. And they specifically, in his rebuttal testimony, he said that, gee, the commission has twice approved this method for staff and interveners to request through discovery modeling of alternative resource portfolios by P&M, and therefore it shouldn't be changed. And so, again, we're not challenging it in this case, but we're saying this should be changed. And one of the reasons we're pointing out it needs to be changed is because for an intervener like Onward, we don't have a problem not having access to confidential information, but if there isn't a procedure that's developed that allows us to at least request the modeling, and we did so, by the way, we did this, in the Southwest Generation actually did hire someone, and as P&M actually deposed Mr. Spurgeon about this, but cost quite a bit of money to hire somebody just to request that P&M do independent modeling. And then after P&M did the modeling, they basically said, well, it's not meaningful because it's inconsistent with the way we did the modeling. So, that's the reason why we're offering it, is simply to show that this is a matter going forward that the commission should consider when it provide reasonable access to modeling when P&M is relying on this proprietary modeling that's very expensive, and it's really clear that you not only have to have specialized equipment to do the modeling yourself, but if you want to request modeling, you have to have the training, not just on Compass. You have to have training for how to operate Servum as well.
So before Ms. Padilla chimes in again, let me ask Mr. Throne though, is this going to factor into your questioning of Mr. Fenton?
No.
Well,
We just want this. We want administrative notice taken of the notice of withdrawal of the request by Mr. Spurgeon, and we want admission of the exhibit explaining why he withdrew, simply so that it's part of the record, and it could be something that we can refer to in our post-hearing brief. We don't have any actually question for any other P&M witnesses about this. But as I've previously indicated, that is one of the essential functions of the administrative notice rule, and there's certainly to allow parties to address it in their briefs. And there's certainly no requirement that if something is properly admitted under the administrative notice rule, that you have to question witnesses about it at the hearing.
just so I understand what this document is, you're indicating this was admitted in the 195 case?
The notice was filed as indicated on the onward exhibit
Cover page?
11. Yeah,
11.
that was filed because we had Mr. Spurgeon, as well as me and other people outside the company, had signed a confidentiality agreement pursuant to the protective order in that case. But after we did so, that's when we got the email from Mr. German saying, we're going to object to this unless you withdraw. And so we did. We said, well, we don't want to, why get into a fight about that? We didn't want to get into a litigation over whether or not we were trying to get access to competitively confidential information. That's not why we're getting involved in these cases. So we agreed, and that's just to explain why the notice of withdrawal was filed, because the notice itself does not contain P&M's objection, which they made through the discovery process.
So wait, I'm just make sure I understand. Was Exhibit 10 admitted into the record in 195?
The emails were not. No, the emails were not admitted.
Okay, so
Those are
under
not-
what basis could I take administrative notice of Exhibit number 10?
We didn't ask for administrative notice of 10. We asked for it to be admitted as an exhibit. And I believe under the even under the New Mexico rules of evidence, and certainly under our more liberal Rule 35 of evidence, under Rule 11-901, which is the requirement of authentication or identification of documents. There are several examples of how, I mean, and I'm just reading from the rule.
Yeah, no, okay, go ahead. Yeah.
Well, it just, we're just trying to show that, the proponent is producing sufficient evidence to support a finding that the item is what the proponent claims it is. We're just claiming that this reflects the fact that the reason the objection was communicated to us by P&M, and that's the reason why we filed the notice of withdrawal, and why Mr. Spurgeon, and for that matter, onward to today, has no access to any confidential information that was provided in discovery by P&M in this case regarding its model.
So as an Exhibit 10, I mean, my preference would be, Mr. Throne, that you would, I mean, if you're just trying to use this as a cross exhibit, use it at a period of time when it is appropriate to do so, right? When the witness that you're questioning says, no, sir, you're, whatever, however you're going to do that. Because you're making an offer of proof, I suppose, at this time, how you intend to use this, but why don't we just wait till we get there?
Okay, I guess I would then, well.
11 is a document from, Ms. Padilla, do you have any objection to the document Exhibit number 11? Because Mr. Throne is seeking administrative notice of that?
No, I am
Ms. Padilla, you're silent.
Right, I understand that Mr. Throne is seeking administrative notice of this notice that they filed in a case. And yes, we would object. It goes back to the point I made previously that what he's arguing is anything that's filed in a previous case could come in subject as something that the commission gives administrative notice to, which that just undermines the rule and allows any filed document to come in.
Well, subject to relevance too. I mean,
Yes.
that's right. I mean, that's not qualification.
I did want to respond briefly to Mr. Throne's argument about, because we did make a point that Onward could have included this with their direct testimony. I would point to page 92 of Mr. Spurgeon's direct testimony, where he does make very specific recommendations. I mean, after 90 pages of testimony, that about what procedures should be changed going forward. So I don't believe that there was anything in our rebuttal that would have specifically caused Onward to realize they should include this now, these documents now as exhibits. And actually, this is also, of course, supplemental to the fact that Mr. Fenton did not receive this email. He just reviewed it now on the stand, and so he cannot authenticate this document.
Yeah, Mr. Throne, I mean, I
Mr. Hearing Examiner, may I weigh in?
yeah, Ms. Beatles.
Thank you. So in my experience with the commission, the relationship between regulated entities and their regulators is a decades-long relationship. Companies have to be accountable for their statements, representations, and commitments from case to case. And if conditions or circumstances have changed or are different, they can say so. But since regulation is prospective, except for enforcement, and it's always complex, regulators need all the context they can get. And I've never been restricted in the past from, citing to record evidence from previous cases to support or point out to the commission what they also need to consider. So I'm having trouble dealing with the objections to administrative notice.
So let's just be really clear, make sure that I understand. Exhibit number 10, Mr. Throne is not seeking administrative notice. Correct, Mr. Throne?
That's correct, because it's not a prior record of the commission.
Right, exactly.
That's why that's why I did the authentic.
Exactly. I understand. So the next question then becomes, but Exhibit 11 only makes sense in light of Exhibit 10.
Yes, it explains the reason for it, because when you file a notice of withdrawal, there was no need for us to explain, okay, P&M objected to the act to Southwest Gen, Mr. Spurgeon or anybody else in-house to having access. So it's there just to make it make sense and so understand it. And again, the reason why it wasn't included in Mr. Spurgeon's direct testimony is we didn't know how P&M was we were kind of hoping that P&M would say, okay, we will provide a different way to provide access to make it easier for not just us, but for WRA, for staff, or anybody else who wants to ask for modeling by P&M. So
you're not going to ask Mr. Fenton about exhibit number 10.
Correct.
How is it relevant at this point?
Well, I think you've made it clear that it's relevant to explain. It's relevant to explain why the notice of withdrawal was filed.
Yeah, I understand, but I'm going to deny it for the moment. And when you get to a point in this proceeding when you can say, hey, look, you're lying about this, then you can admit that, and then we'll get to 11 to the extent to which we need to. But for the moment, I see no reason to get into this morass now because it's all hypothetical.
Certainly, I'll proceed. I understand. Again, we just want to be able to, when we write our briefs, explain what the problem is for our access. And
John, we just need to, before
Okay.
you ask me to assume that I know where you're going to go with the witness and, there's one document that only comes in if it's relevant to a discussion you're going to have. And then the subsequent document relates to that. And you're asking for administrative notice of that. my preference would be to do all that when it's relevant to talk about the principal document.
So just to be clear, are you admitting the administrative notice request?
No, not at this stage.
Okay, thank you. All right. Mr. Fenton, if you would go to your direct page 5, starting at line 19. Okay, are you there?
Yes.
Okay. And there you say that the question is P&M seeking approval to procure new resources for the system when the lease interests are returned. My question is, you're referring there to the proposed solar PPAs and the storage agreements for 20-year terms, correct?
Yeah, I'm talking about the approval of the 150 megawatt PPA for solar, the 40 megawatt 4-hour energy storage facility, the 300 megawatt.
I understand what it is. I'm just asking you to confirm that's what you're referring to. I don't have a lot of time for you to summarize P&M's proposal. Okay, so is P&M requesting in this case that the commission approve its 2020 RFP instructions to bidders and the bid evaluation processes that were described in Mr. Nagel's testimony?
P&M is asking for approval. We've spent a lot of time this morning talking about things we're not asking for approval of, but we're asking for approval of the PPAs and ESAs in this phase of the docket. That's what we're asking for. We're not asking for approval of modeling assumptions. We're not asking for approval of RFP instructions. You just referenced RFP instructions. What we're asking for is approval of the PPAs and ESAs, and no parties provided an alternative portfolio, and I don't think anybody is opposed to that. So no, we're not asking for approval of an RFP. We're asking for approval of the PPAs and ESAs that we requested.
Is it correct, based on your response, that P&M would have no objection if the commission's final order in this case expressly states that the commission is not approving P&M's 2020 RFP instructions or bid evaluation processes?
I don't think that would be necessary. We didn't ask for that in our application. I'm not aware of, if you could point me to my testimony or anybody else's where we asked for approval of those instructions, I'd appreciate it.
But you don't have any objection, P&M doesn't have any objection to that, is that correct?
Well, I don't think it's necessary to not approve it, just like I don't think it's necessary to approve all the modeling assumptions. I think what's necessary is to approve the PPAs and ESAs and to do it very quickly because we do need those resources.
And would I be correct that you would, if I asked you any questions about the P&M's 2020 RFP instructions, you would refer me to Mr. Nagel?
Mr. Nagel or Mr. Falgren or Mr. Phillips, one of those three.
In your capacity, in your official capacity and that you've described earlier, do you know, generally speaking, whether if a bidder believes that any of P&M's RFP instructions are not reasonable or are not competitively fair for any reason, is there any recourse for them? Do you understand what recourse a bidder would have for that if they wanted to object to that?
I do not. I'm not familiar with I'm not involved at all, Mr. Throne, with our RFP process. So no.
And would your answer be the same about whether or not, if any bidder has a problem with any of P&M's RFP instructions, whether it can take that matter to the commission? And
Objection, PNM Laca Foundation, Mr. Fenton has already testified that he does not have much to do with our with RFPs.
Did just say that, Mr. Throne.
I'm sorry?
I understood you asked him a question. Ms. Padilla's objection was effectively, he just stated that he couldn't answer your subsequent questions unless you want to.
Okay, I'll move on. I asked him a different question. My question was whether or not there was any way they could bring that matter as a basis to the commission, but I never got to an answer.
I thought he did testify that he's not involved with the RFP process in a way that would permit him to answer that question. I thought that's what he said.
Right. I was talking about remedies at the commission, but I'll move on. Is it your general understanding, Mr. Fenton, that PNM's request for commission approval of the 20-year power purchase agreement and energy storage agreement resources proposed in PNM's application is based in part on what PNM refers to as its replacement analysis in this case?
In part, yes. I believe PNM refers to both a replacement analysis and a abandonment replacement analysis and a reliability type of analysis. We also refer to an abandonment analysis that was done prior to actually making the resource replacement analysis.
And is it your general understanding that for its replacement analysis in this case, PNM modeled portfolios using both the no new combustion and the technology neutral resource identification and modeling approaches that are described by Mr. Phillips in his testimony?
Yes.
And is it your understanding that PNM's request for commission approval of those PPAs and those energy storage agreements proposed in PNM's application asked the commission to approve the reasonableness of PNM's replacement analysis methodology described by Mr. Phillips?
No. No, that's not my understanding. We're asking for replacement of approval of the replacement resources themselves. You would need to show me where you think we're asking for approval of the modeling assumptions. I do not think we are asking for approval of the modeling assumptions. We're asking for approval of the portfolio, which nobody else has proposed an alternate portfolio. And I'm not aware of anybody even opposed to the portfolio itself.
Well, can you explain to me how it is that you want approval of the proposed resources in the application, but not the replacement analysis on which that proposal is based?
Because the end result is the portfolio itself, is the replacement resources itself. Different people will use different modeling assumptions. Nobody has provided an alternative portfolio here, but my experience has not been that when a resource is approved, that you go back and look at all the assumptions that were used and say, oh, all those assumptions are going to have to be used from this point forward. Those assumptions, I think, are better argued in an IRP or better argued in other places. But in this case, we're not asking for approval of the underlying assumptions. We're asking for approval of the resources, which are undisputed.
So is it correct then that your testimony is that PNM is not asking for commission approval in this case of the reasonableness of the modeling methods and database inputs relied on by PNM and Astrape using the proprietary Encompass and Servum software for its replacement analysis described by Mr. Phillips and Mr. Mintermantle?
I think Mr. Phillips in his testimony has a paragraph where he discusses that he believes his assumptions were reasonable and onward and challenge those resource assumptions. But you'd have to show me where we're asking for approval of the assumptions themselves. I believe we're asking for timely approval of these resources. And historically, that, you've spent some time today, Mr. Throne, talking about 19-00195-UT. And in that case, there was assumptions that were underlying the portfolio that was identified as CCAE 1. I don't think those assumptions are necessarily moving forward and were approved. So I guess I don't see that logic.
Yeah, I'm hoping to get through my cross, so I understand you want to go explain things that I'm not asking about. But let me ask you this: is it fair to say that in past P&M cases before this commission that you've been involved with, if the commission has approved specific conduct by P&M regarding a particular subject or matter, P&M has found it reasonable to rely on that commission approval as precedent in subsequent cases addressing similar subjects?
If there was a specific approval on some item, like if there was a specific approval of a 13% reserve margin in 08-00305, we may have used that. But if as in this case, there's approval of the resources themselves, I don't recall us going back and saying that each and every of the underlying assumptions is also appropriate in the future.
Let me ask you to move down to your direct to page 29. And starting with the question on line 1, which reads, is there precedent for the commission to approve regulatory assets for the future collection of utility costs and undepreciated investments? I realize that's not an issue in this case, but isn't that an example of you relying on past commission decisions as precedent for proposals by the company in subsequent cases?
Well, it's along the lines of a very specific example. You were asking about modeling assumptions earlier, and I was talking about the end result. This is certainly if there's a specific request that was made and the commission specifically adopted that request, P&M would rely on it in the future.
Well, isn't the very purpose of the literally thousands of pages of testimony that P&M has submitted in this case, the purpose is for the commission to rely on that to support your proposed replacement resources?
No, I think the purpose of that testimony was to support the portfolio that we recommended, to ensure that it's reliable, to support that portfolio. We didn't know when we made this filing that nobody was going to oppose the resource portfolio. So Mr. Phillips and Mr. Wintermantel and Mr. Schlag, I think, did a really good job of supporting what we proposed. So we didn't know, as I just stated, I hate to repeat myself, but we didn't know it would be the portfolio would be unopposed, and it is.
Now you understand, right, don't you, that Mr. Phillips actually put in his June 14th supplemental testimony, in this case, the entire P&M 2020 IRP?
I didn't look at all of Mr. Phillips' exhibits. So no, I did not know that necessarily, no.
Okay, well, we'll let the record speak for itself on that. Are you aware that as of today's date, the commission has not yet had an opportunity to address whether or not it accepts P&M's 2020 IRP as being compliant with the commission's integrated resource planning rule?
Yes, I am aware that we're in the process of that it hasn't been accepted yet. I know P&M filed its response to your recommendation of rejection, and next is staff's recommendation is due.
Okay, let me have you refer to page 6 of your direct, lines 4 to 9, please.
Okay.
And there, you're answering a question, are you not? Question is, did P&M update its cost benefit analysis for the proposed replacement resources? Am I correct that the updated cost benefit analysis you're referring to here compares the costs and benefits of P&M's proposed new power purchase agreement and energy storage agreement resources to the costs and benefits of a P&M decision to purchase its 114 megawatts of Palo Verde lease interest upon the expiration of those leases.
Yes, that's correct. In this question, I'm comparing it to the earlier analysis, which was an abandonment analysis. And this is the replacement analysis that lowered the savings to customers, but still resulted in significant savings to the customers. And there's
Okay,
two.
and now, as I understand it, and moving down to line 23 at the bottom of that page, but am I correct that that comparison is based on a comparison of the 20-year net present value of revenue requirements associated with those alternative resource decisions?
It is a 20-year analysis, is my understanding. Mr. Phillips performed the analysis. On line 8 of page 6, we've got the 88 to 94 million identified, which is related to the replacement resources. That amount is lowered on line 23 to 22 to 55 million on a net present value basis, which I think also includes the reliability resources.
Again, I'm just trying to confirm what I believe is in your testimony. I know you're trying to expand on it, but if you could
I'm just trying to,
Yeah.
I'm sorry, Mr. Thur, I'm just trying to explain it. I didn't totally understand your question.
Yeah,
So
well, I'm trying to ask questions, just confirm what's in thousands of pages of P&M testimony, because rather than, I understand sometimes a question calls for an explanation. Let me have you move now to page 34, line 14 of your testimony.
page 34, line 14.
Yeah, and beginning on that line and carrying over to page 35, line 36, if you would, take a look at that.
Beginning on line 14, page 34 till what? Till
Carrying
page-
over to the next page on line, I'm sorry, to the to the end of the page.
to the end of page 35.
Hold on a second, let me just double check here. Well, just go to page 6 on the next page, if you would.
Page,
Page 35, line 6, in other words. Tell me when you're there.
I'm there. Let me read the sentence, please. Line 6 is just the end of it.
Let me ask my question when you're ready.
Okay, go ahead.
So there you say that in analyzing potential portfolios to meet P&M's 2023 resource needs for its replacement analysis, in this case, P&M relied not only on the Energy Transition Act, but also quote unquote policy guidance, close quote, provided by the commission in case numbers 19-195 UT and 19-349 UT for weighing costs, reliability, and environmental factors in resource acquisition cases. Is that correct?
Yes, I refer to an El Paso Electric case, 19-00349, which is a case where they were asking for approval of a CCN for 228 megawatts of a natural gas turbine at their Newman facility. That's what I'm referring to there.
Okay, and so you reviewed that commission's final order in that case as part of that your policy guidance that you're referring to here, correct?
Yes, I have reviewed the recommended decision. I was also at the commission open meeting, as I recall, when they made that decision, and I listened to what the commissioners were saying.
Okay, would you agree with me, Mr. Fenton, that the best evidence in this case of that policy guidance by the commission is what is stated in those final orders in those cases, and to the extent they adopted the recommended decisions in those cases, those recommended decisions?
I would agree that the final order is what really governs, as opposed to the recommended decision. But in that case, the final order essentially adopted the recommended decision.
As you testify here today, can you recall any statement in either of those final orders or in any recommended decision adopted by them indicating that in an RFP process or resource procurement application, an electric public utility should not consider or evaluate any resource proposals that would not provide the utility with incremental capacity in the first year when the utility believes it needs that capacity?
Could you repeat that?
As you testify today, can you recall any statement in either of those final orders, in those cases, or either of the recommended decisions adopted by those orders, indicating that in an RFP process or resource procurement application, an electric public utility should not consider or evaluate any resource proposals that would not provide PNM with incremental capacity in the first year when PNM believes it needs incremental capacity?
Well, I'm not sure which order you're referring to, but if you're referring to the one on line 6 that we were talking about, case 19-00349, that was related to El Paso Electric's request for Newman. So there was no reference to PNM at all in that particular order.
I'm asking about policy guidance, and your answer is can you answer the question?
I don't recall the order talking about policy guidance in terms of the RFP. I do know that my recollection of the recommended decision in order in that case is that the hearing examiner had some concerns about El Paso Electric's RFP process, but I don't recall any particular policy guidance other than they were concerned with the way they handled their RFP.
Okay, and as you testify today, can you recall any statement in either of those final orders in those cases where the recommended decisions adopted by those orders, indicating that in an RFP process or resource procurement application, an electric public utility should not consider or evaluate a proposed extension of an existing power purchase agreement until near the time when that power purchase agreement is due to expire?
Which two orders are we talking about? I want to be clear on that because I'm looking at on page 6, I refer to 19-00349. Are we referring to another one also?
Yeah, you referred to two orders. You referred to the 19-195 UT final order as well.
Oh, on the previous page. Okay. I don't recall the 19-349 order talking about a situation like you're alluding to with Valencia, where the PPA expires in 2028. I don't remember that specific example being addressed in that order.
Is it correct, Mr. Fenton, that if approved by the commission in this case, the PPAs and energy storage agreements will provide PNM with incremental capacity and energy compared to the capacity provided by the resources in PNM's existing supply side resource portfolio, not only for the year 2023, but also for 19 years thereafter, because they are 20-year agreements?
They are 20-year agreements, but these resources are specifically to meet the replacement resources needs in 2023 and to meet the reliability needs in 2023. That's being done through ESAs and PPAs that I agree have a term of 20 years.
Okay. Beginning on line 14 on page 35 of your direct, you testify that PNM's analysis also modeled lower cost scenarios that included combustion units that could be converted to non-carbon fuel supplies. Is that correct?
Yes.
So do you, as I understand your testimony there, you know, based on your own personal knowledge, that P&M modeled more than one such lower cost scenario that included that type of non-carbon fuel combustion turbine resource?
I do not. Mr. Phillips did the modeling. You would need to address what modeling options he reviewed with him.
So you don't know if there was more than one lower cost scenario modeled by P&M?
I know that Mr. Phillips provided an analysis that was no new combustion and a technology neutral option. And within those options, I think there were, within each of those two different paths, there were several options and several sensitivities. But to get into the detail of what he reviewed and evaluated, you would need to talk to him directly.
Well, let me ask you, since you refer to his testimony, let me have you look at Mr. Phillips' direct testimony. Let's see here, correct. I believe P&M Exhibit 6.
I don't have his exhibits in front of me. I have his testimony. He had some pretty extensive exhibits.
Well, I'm referring, since you refer to it in your direct testimony, could you get in front of you P&M Exhibit 6, please?
Could you show me where I refer to Exhibit 6 in my testimony?
No, you refer to Mr. Phillips' direct testimony in your, do you not acknowledge that your testimony says that, refers to Mr. Phillips' direct testimony regarding the portfolios modeled as part of P&M's replacement analysis?
Yes, I do refer to Mr. Phillips, but you're
Okay.
wanting me to look at Exhibit 6, and I'm suspecting that's going to be a very detailed exhibit with a lot of background, and I don't know that I was referring to Exhibit 6.
Well, I want you referring to you just referred to the two, the no new combustion portfolio and the technology neutral. And so I want to ask you to take a look at page 35 of Mr. Phillips' direct testimony, which is P&M figure NLP 4, and find out if those are the replacement scenarios that you're referring to in your direct testimony.
So, Mr. Throne, this is Leslie Padilla. Could I just interject? I think there may be some confusion when you referred to P&M Exhibit 6, Mr. Throne, you're referring to Mr. Phillips' direct testimony. Is that right?
I think I said that twice already, yes.
Well, no, not as clearly as it could have been stated, I don't think. So I just wanted to make sure that Mr. Fenton knew that you were asking him to look at Mr. Phillips' direct.
Yes, I do now understand that. I'm looking at page 35. I thought, Mr. Throne, you were talking about an exhibit attached to Mr. Phillips' direct testimony. You're talking about page 35. I'm there.
Yeah, so that NLP figure, P&M figure NLP 4, you see that, and they've got those boxes there that on the left-hand side, the top one describing the no new combustion proposed portfolio, and then the one on the bottom, the technology neutral portfolio. You see that?
I do.
And is it your understanding that P&M did not propose in this case approval of the technology neutral portfolio, but that just included that for, I believe it refers to as illustrative purposes. Is that correct?
Yes, Mr. Phillips evaluated a technology neutral portfolio and no new combustion, and for a company, the company decided to go with the no new combustion alternative as supported in my testimony.
Okay, and I'm just looking at the technology neutral box in the lower left-hand side on that page, and that's in that one in the lower half of that box where P&M included in that model one LM6000 gas turbine, and it says parentheses La Luz 40 megawatt capacity. Is that what you were referring to as the lower cost portfolio in your testimony?
I believe it is. I think you'll need to talk to Mr. Phillips, though, about what he modeled for gas. But yes, certainly the technology neutral portfolio that Mr. Phillips modeled is what I was referring to.
Do you know whether so you don't know anything about the details of that? I have to ask Mr. Phillips about that in terms of that, how they modeled that that one LM 6000 gas turbine?
I do not know the details.
Okay. But you do know that the La Luz, the reference to La Luz there refers to the site of P&M's existing La Luz Energy Center that is owned by P&M, correct?
Yes, I believe that's true.
And so what you're understanding, just looking at that, is what's modeled there is a P&M owned resource in the form of a LM 6000 gas turbine, correct?
Yes, I believe it's a new 40 megawatt facility at that site. I don't know if the assumption is P&M owning it or not, but.
Well, if it's located at La Luz and La Luz is on property owned and controlled by P&M, it couldn't be owned by anybody else. Isn't that correct?
That's correct. But again, I think you need to talk to Mr. Phillips about the underlying assumptions.
And again, looking at that that same NLP P&M figure NLP4 on page 35 of Mr. Phillips' direct testimony, you see where it has on the left-hand side, those two boxes, those NPV values. That's based on is your understanding that that's based on P&M's modeling using its proprietary Encompass software?
My understanding it's based on P&M's modeling. I know I'm repeating myself, but I think Mr. Phillips is the appropriate witness. I am not involved in the modeling or the calculation of the NPV, so he would be better to ask.
Okay, and just looking at the again, because you refer to his testimony in your direct, it's correct, is it not, that that this replacement analysis presented by Mr. Phillips here shows that on a 20-year basis, which is the modeling period, the portfolio of resources being proposed, that is in the upper box on the left-hand side, would actually have greater carbon dioxide emissions over a 20-year period than the technology neutral portfolio that is represented at the bottom left-hand side box.
Objection, Mr. Hearing Examiner.
Go ahead, Ms. Padilla.
Leslie Padilla with P&M. So Mr. Benton does reference Mr. Phillips' testimony in Mr. Benton's testimony, but I don't think that means Mr. Benton can be asked anything that's in Mr. Phillips' testimony. And Mr. Benton, I would add, has already stated that he's not familiar with some of these aspects of Mr. Phillips' testimony that Mr. Throne is questioning Mr. Fenton about.
Mr. Throne? Yes,
this is an issue that's come up over the years many times, where you have P&M witnesses in effect supporting their testimony by referencing the direct testimony of other witnesses. And I'm not going to ask a lot of questions about this, but I'm asking this one because Mr. Fenton specifically relies on Mr. Phillips' testimony and his testimony to support P&M's application for the particular resources being proposed. And so I wanted to ask him just a couple of questions or about this, what appears on this. And if he doesn't know, or if this is news to him, then he can tell us and I'll move on.
Yeah, I think that's fair. So I'll overrule the objection. You know, and just Mr. Throne, if his answer is, I don't know, that's the answer.
Mr. Throne, what I relied on from Mr. Phillips is on page 36, where he said that there was savings of 88 to 94 million. And then after you include the resource adequacy requirements, it's 22 to 55. You're now asking me about the portfolio tons of carbon, I believe, in this figure. And I do see that Mr. Phillips includes not only the net present value numbers, but he includes the portfolio tons of carbon. I'm not familiar with how that number was derived. I see them just like you see them, but I don't know the underlying support for those numbers.
Okay. So you never discussed, when your testimony, in your direct testimony, when you talked about following policy guidance from the commission, and I just wanted to make sure I'm clear about this. So you never discussed with Mr. Phillips when P&M made the decision to choose a no new combustion portfolio, you never discussed this carbon emissions result that was modeled by Mr. Phillips with Mr. Phillips?
I did not discuss the carbon emissions with Mr. Phillips. I explained in my testimony that the company's policy decision to go with no gas in this particular portfolio was driven by the fact that Palo Verde is no carbon emissions, and we wanted to replace Palo Verde with a no carbon emissions resource. In this particular case, I go on in my testimony to discuss how that doesn't mean we wouldn't consider gas in the future. And I not only supported the carbon-free being replaced with carbon-free, I also referenced the El Paso case, which we had just heard about from the commission and seen in an order where they denied their natural gas. So I did not get into detail. I did not get into a discussion with Mr. Phillips on the carbon emissions of the portfolios he described.
Okay. I'll get back to your testimony again. So it's exhibit 2.
Just for the reference, Mr. Throne, you've got about 16 minutes left.
Thank you. Go to page 35, line 22 of your direct, if you would.
Page 35, line 22.
Yeah. And carrying over to page 36. So there, you say, well, the commission has made clear that cost is a principal driver. It also is given similar, if not greater weight to environmental factors when reliability can be maintained. And then on the next page, you say, and I quote, P&M witness Phillips demonstrates that this combination of PPAs and ESAs, when added to P&M's existing and planned generation portfolio, make up an acquisition portfolio that meets P&M system reliability and customer loads for 2023 summer peak and is consistent with the no new combustion outcomes for energy transition outlined in P&M's 2020 RFP. Is that correct?
Yes, you read that correctly.
And is it correct that the existing and planned generation portfolio that you're referring to there includes the assumptions that are stated and modeled in P&M's 2020 IRP regarding its planned reliance on its existing P&M-owned gas resources between 2023 and 2040?
I think the portfolio I'm describing there on lines 1 through 1 through 3 is the no new combustion portfolio that we recommended in this application. And we're saying it's consistent with the 2020 IRP, but the portfolio I'm referring to specifically is the portfolio we proposed here to meet the 2023 summer peak, which is what we're asking for approval in this case.
Yeah. Now, again, looking at page, I guess it's 36 on line 2, and you're referring there to PNM, not just its planned generation, but its existing. So my question to you is, when you talk about the existing generation, you're referring there, are you not, to whatever the assumptions are regarding existing generation that are stated and modeled in PNM's 2020 IRP regarding PNM's planned reliance on those, on PNM's own gas-fired resources between 2023 and 2040?
I believe what I'm saying is that the resources we proposed here, the no new combustion resources, the ones we're asking specifically for approval, when they're added to our existing and planned portfolio, they make up an acquisition portfolio that meets the reliability standards. And that's consistent also with the 2020 IRP. And Mr. Phillips talks about that consistency in his testimony.
Okay, go. Well, you would agree that whatever PNM's plans are for its existing resource, they're reflected in PNM's 2020 IRP, correct?
The one we just filed, the 2020 IRP, you're referring to the one that we filed in January of 2021?
Yes.
Yes.
Thank you. Please go to page 36, starting at line 7, and carrying down to line 17. There you say that consistent with its 2020 IRP, PNM believes that in subsequent resource acquisitions, PNM should not foreclose consideration of new gas combustion that is convertible to hydrogen use in the 2040 timeframe or before, if necessary, to bring greater value and reliability to PNM's portfolio at a lower cost than continuing to add only solar and energy storage solutions to resource needs. Close quote, correct?
Correct.
So there you're addressing how PNM should consider its gas combustion and resource options in its RFP processes and resource acquisition applications subsequent to PNM's 2020 RFP process, correct?
I think I'm saying exactly what it says, that although we didn't pick a gas portfolio in this particular case for the replacement resources, that we shouldn't foreclose that opportunity in the future, and that both our RFPs and our planning process and our ultimate selection, we should continue to consider a gas option.
So that's a going forward recommendation by you there, right?
It's not a recommendation for this particular case because we did not recommend gas, but going forward, we will be issuing all resource RFPs. Yes, but I'm not specifically talking about RFPs here. I'm talking about going forward. We don't want to foreclose the possibility of using natural gas combustion.
Okay, so that's just forward-looking testimony. Is that a better way to say that on your part?
Yeah.
Okay. When you refer there to new gas combustion that is convertible to hydrogen use, are you referring to the specific type of aeroderivative combustion turbine technology that is described and also modeled by PNM in its 2020 IRP?
I'm not referring to any particular technology there. I'm just referring to the fact that PNM has a goal of being carbon free by 2040. The ETA is 2045. So that when you get to the 2040 timeframe, the natural gas combustion, whatever the technology would be, would need, it'd have to be carbon emission free. So that's all I'm referring to.
Okay, but you do say there, consistent with P&M's 2020 IRP, don't you?
Yeah, consistent with the IRP is that there are other technologies that P&M is going to review. It's not.
Isn't it correct, Mr. Fenton, that P&M's appendices to the IRP has a section and also the narrative section that identifies potential new resources that were modeled, that specifically identifies the specific types of resources that P&M plans to consider going forward?
I'm not familiar with the appendix, but I would note that the IRP is a planning tool. It's not a tool that's going to identify the specific technology or the specific type of resource that P&M is going to select in a future CCN application. It's a planning tool.
And again, referring to the same testimony there at page 36, lines 7 to 17, where you say by greater value and reliability. By greater value and reliability in that statement, are you referring to the greater economic value and reliability that may be provided by dispatchable, flexible gas-fired resources with quick start ramping capability?
Where's the greater value? Which line is that on?
I believe it's.
Oh, I see it. New. Yeah.
Yeah. See it?
Yeah. We're referring to that. What I'm referring to here is that the natural gas resource, as we add more and more renewables to our system, there is value and reliability of adding natural gas potentially. So I think we need to go back to what I say in the beginning is this is not foreclosing consideration of no new gas combustion. Even though we picked a resource here that is not gas, I am making clear that the company's position is in the future that we would consider gas combustion for greater value and reliability.
And in greater value, you're referring to economic value, correct?
Potentially, but I think probably greater value. I'm also referring to the reliability portion of it. The greater.
Well, that's why I'm asking, because you use the term, you use them in the conjunctive. You say greater value and reliability. Those are two distinct concepts when it comes to utility resources, correct?
There may be greater value. I mean, in this case, you can see from the cost savings numbers that we presented that the gas option was the technology neutral option was cheaper. For the replacement resources, it was 88 million compared to 94 million. So greater value, it is could be less cost, certainly.
Is it correct that P&M retained Mr. Nagel and his firm Aon, which is spelled A-I-O-N, to develop what became P&M's 2020 RFP after P&M made its decision internally to return the Palo Verde lease interest to its lessors rather than to purchase those assets upon their expiration of the leases?
I know that P&M has retained Mr. Nagel, but Mr. Falgren and Mr. Phillips are the ones that retained Mr. Nagel. So the timing of it and why they retained him, those kind of things would be more appropriate for Mr. Phillips or Mr. Falgren.
So you don't know. You don't know when that firm was retained. Is that correct?
I don't know specifically, no.
Okay. How much time do I have left, Mr. Ryan?
5 minutes.
May I request then, I'm going to conclude at this point, and I would like to kind of slip my time onto the next witness and save that 5 if I can, and I'll conclude here with Mr. Fenton.
Okay. I mean, unless there's an objection to that, does anyone object to extending his 5 minutes to the next witness?
Mr. Higgins, Leslie Padilla for PNM, would that mean Onward intends to cross Mr. Falcon for 155 minutes potentially?
Yeah, that's what I understand he's asking.
Okay. No, we don't have an objection.
And to be clear, Mr. Ryan, the reason why we put this in our pre-hearing memo and in the joint pre-hearing was because it was very difficult to determine which witness was going to answer what questions or defer to other folks. The only way we could try to manage this is to try to, if we finish, we have some time left over, is to move it to the next witness. And then I'd like to keep doing that just to make sure. I mean, I'm not going to use more than my total allotted time, but that's how we're trying to allocate as best we can within your time limits, sir.
Sure. Okay,
Thank
well,
you,
if there's
thank-
no object, yeah, there's no
Thank you,
objection.
Mr.
we'll-
Chairman.
Thank you,
Uh,
Mr. Chairman.
Ms. Nanasi, you've requested 20 minutes.
Yeah, can I ask you what you're thinking about in terms of a lunch break?
I'd prefer to go till 1, if that's acceptable to everybody, and keep progress.
Be my preference also.
Yeah,
Okay, can I just have a minute then, because I need to reschedule a Zoom call with a bunch of other people. Can I have 1 minute?
yeah, no, let's take
Because-
5. Let's do a 5-minute break here. That's fine. I could use the quick rest stop as well. So we'll come back at 12:20, 21-ish.
So can I just ask you, so are you thinking about going from 1 to 2 then?
No, we
For
stop
lunch?
it. Yeah, for lunch, yes. Lunch should be 1 to 2. I mean, we
Okay.
may finish up shortly before 1. I don't know. We'll see how much we get done here, but yeah, that's the concept.
Okay, thank you.
Yep. Ms. Padilla.
Hello.
All right, so are we back on the record? Do we have everybody here?
I think we still need our witness. Mr. Fenton is
Oh, I see,
on his
yes.
way to his chair, or maybe they just have not turned on the camera yet.
Yeah, it's fine.
Okay, we have Mr. Fenton.
Okay, Ms. Gonzalez back on the record. And it is Ms. Nanasi and NEE for 20 minutes with Mr. Fenton.
I'm ready. Thank you so much. For the record, Marion Lanassi with New Energy Economy. Good afternoon, Mr. Fenton.
Good afternoon. How are you?
You are P&M's regulatory expert in this case, are you not?
I'm P&M's Executive Director, Regulatory Policy and Case Management, yes.
The lease interests in the Palo Verde nuclear generating station terminate in January 2023 and January 2024, respectively, 104 megawatts in Unit 1 and approximately 10 megawatts in Unit 2 were found to be imprudently acquired by hearing examiner Glick, the Commission, and the New Mexico Supreme Court, correct?
Mr. Hearing Examiner, this is Leslie Padilla with PNM. I will object. I believe that is not in the scope of this case or relevant to the portion of Mr. Fenton's testimony that's relevant to this case.
I was wondering that myself. Ms. Nanasi?
I believe he refers to these specific resources on page 3 at line 16. And so I'm asking if they were imprudently acquired.
Because you want to make a point about that aspect of this case, or because you're asking him about replacement resources?
Well, it will ultimately go into the replacement resources, yes, and some other aspects of this case. It's just one question.
Yeah, but I don't, I guess that's the point. I'll give you a little leeway, Ms. Nanasi, but we're not here to talk about the issues that are retained within 21-00083.
I understand that. Thank you so much, sir. Could you answer?
So maybe repeat your question.
The leased interests in the Palo Verde nuclear generating station terminate in January 2023 and January 2024, respectively 104 megawatts in Unit 1 and approximately 10 megawatts in Unit 2. They were found to be imprudently acquired by hearing examiner Glick, the Commission, and the New Mexico Supreme Court, correct?
I don't agree with your characterization there. I do agree that those leases terminate in January 2023 and January 2024. In the recommended decision 15-261, Ms. Glick made certain determinations. The final order was different than the recommended decision. For example, the leases were allowed to be extended at 50%. So it's not that she determined that the Commission determined that they were imprudent. They were allowed to be extended at 50% of the costs. So I don't agree with your imprudence finding.
And what is it about the imprudence finding that's a characterization in my question?
You said that that the Commission found that PNM was imprudent. I understood your question that PNM was imprudent in extending those leases.
So your interpretation of the final order in 261 was that the Commission did not find PNM to have imprudently extended those leases? Is that your testimony?
They allowed us to extend the leases at the 50% at 50% cost. So yes, that is my testimony.
After January 2023 and January 2024, those leases will not be used and useful and will not serve ratepayers, will they?
Wait, Mr. Nassi, we need questions about replacement resources. I mean, this is questioning about the 83 case. If you're gonna get to replacement resource questions, a leeway is a little not. I don't know what you're doing, to be honest with you.
Mm-hmm. Could you go to page 30 of your testimony?
Okay.
And specifically line 20. In what docket did the commission determine that costs associated with the 114 megawatt leased interests that will have not been collected from customers by 2023 and 2024, after those interests will no longer be serving customers, be eligible for cost recovery?
Yes.
Objection.
Ms. Padilla, sustained. I already know what you think.
Okay.
Well,
Thank you, Mr. Although I would note again, let's just be clear, the commission determined in the earlier proceedings in the 21-0083 case that PNM was not required to seek abandonment. So there is no, that abandonment was kind of assumed, just giving shorthand here. So there is no question that PNM needs replacement resources for Palo Verde capacity that is going away in 2023.
agreed.
Is it PNM's testimony that the modeling and selection process took into account applicable commission rules and orders and the energy policies of the state as embodied in the Energy Transition Act and the Renewable Energy Act?
What is your question? What exactly is the question?
Is it PNM's testimony that the modeling and selection processes took into account applicable commission rules and orders and the energy policies of the state as embodied in the Energy Transition Act and the Renewable Energy Act?
Certainly the modeling followed any commission rules. In terms of the policy, I say in my testimony that we considered the Renewable Energy Act, we considered the Energy Transition Act. We were just coming off the 195 case where the commission required a renewable portfolio. So we did consider at a high level what the commission, the Energy Transition Act, we considered what had happened in the El Paso Electric case, not allowing gas, and we wanted to replace this resource, which is a carbon-free resource, with another carbon-free resource. So Mr. Throne and I talked about that.
Yes, can you go to New Energy Economy Exhibit 3, which is that recommended decision that you just referred to and is also cited in your testimony and what you were talking to Mr. Throne about. Can you go to page 78, please?
Okay, can you give me Exhibit 3, please? Is this 19-00349?
Yes, sir.
Okay. And
Which page again, Ms. Nanasi, were you asking him to go to?
78.
78. Thank you.
The statement at the bottom of the page reads as follows. The hearing examiner finds that when considering the authorization of a generation resource, it is reasonable and necessary for the commission to be able to evaluate how long the resource will provide service and potential impediments affecting that projected service life. Such information allows the commission to more thoroughly and accurately analyze the proposed resource types and potential negative or positive impacts upon the utilities ratepayers and the citizens of New Mexico. Does P&M agree with the hearing examiner statement here?
Can I read it a little more carefully, please? I believe what is being referred to there is, in this case, they were asking for approval of a gas resource. And as you read more of this recommended decision, the hearing examiner, Ms. Hurst, was concerned that they hadn't considered the ETA and the requirements in New Mexico related to the ETA. So I think what she was saying is that they needed to recognize that the gas unit might have a life beyond 2045. And she didn't think they were recognizing that, I believe. So
I'm going to ask you my question again, which is
Okay.
the part of that I just read of Ms. Hurst's recommended decision at the bottom of 78. Does P&M agree with the hearing examiner's statement as I read it?
Yeah, I think partially we agree with it. I mean, if you're putting in a gas resource, I think you need to consider projected service life. But what's kind of unsaid in this sentence is, the service life could be changed. They're talking about this being, the context of this is the hearing examiner is concerned in 2045 that the ETA will allow for zero emissions. So I think she is saying that you need to consider that. And I think P&M agrees, yes, that does need to be considered. But we also agree that a gas asset, as I said in my testimony, there may be ways through hydrogen or some technology we don't even know of today that the projected service life of that asset can be extended and also meet the energy transition requirements. So there's a lot bundled into that paragraph there. It's page 78 of a recommended decision. So I don't want to say we agree with that particular statement or don't agree, but we certainly recognize the Energy Transition Act and what she was trying to say. Right above that, she talks about Senate Bill 489 in the Energy Transition Act.
So is it your testimony that you agree with that statement subject to the condition that you just said, which is there may be a technology in the future that we don't know about that could extend the life of a gas plant? Is that your testimony?
Objection. Ms. Nanasi, Ms. Nanasi's question is the third time asking Mr. Fenton this question. So asked and answered.
I'm just probing his answer. That's all I'm doing. I didn't ask the same question. He gave an answer, and now I'm asking a follow-up.
Will you just restate the question, Ms. Nanasi, so I can hear it?
Subject to what you just said as your answer, is there any other reason why P&M disagrees with the statement made by the hearing examiner?
I believe that question is asked and answered, and Mr. Fenton gave a lengthy explanation that effectively you need context to understand what it is Ms. Hurst is saying. P&M agrees generally, but more broadly, there's considerations to do with the ETA when the resource will exist well into the future, that it might not be a good deal because at a certain period of time, it won't be allowed by the Energy Transition Act. That was your answer, Mr. Fenton, correct?
It was, and I think in addition to that, besides saying just there's maybe technologies that we don't know of today, I also mentioned that there are technologies that we do know today, like hydrogen. So
So asked and answered.
Could you go to page 79 of her recommended decision, and where she says that the hearing examiner finds that alternative portfolios proposed by P&M and others that included new gas generation, noting that the use of natural gas turbines is also inconsistent with the ETA's policy of transitioning away from fossil fuel resources and reducing CO2 emissions through the graduated increases in non-carbon generation up to 2040 under the revised renewable portfolio standard. Do you see that?
I do now, but as you were reading it, I was up higher. So let me read this paragraph, please. Okay, I've read it.
So does P&M agree with the hearing examiner statement here?
Mr. Hearing Examiner, I object because the hearing examiner is simply quoting.
Please do not testify. Just make your objection, please. Just make an objection.
Okay. I believe she was trying to make her objection, but Ms. Padilla, what is the objection?
This paragraph of the recommended decision is simply a recitation of a prior decision. So the question just isn't, it's just improper that she's asking a witness to agree with a hearing examiner's, forget her exact wording, conclusions. It's because it just restates a commission decision in a prior case.
So Ms. Nanasi, what is the question you wish to ask Mr. Fenton? I'm not sure I recall at this juncture.
All I asked was, does P&M agree with the hearing examiner's statement here? That's all I
Okay,
asked.
so I think P&M can answer that question. And I believe Mr. Fenton was trying to read the question, if I remember correctly.
Would you like me to?
Yeah.
answer
I think if you've read it and you're prepared to answer, then I think you can answer that question.
I agree that the commission rejected the alternatives proposed by P&M. They certainly did. We had a scenario that was scenario one that included natural gas. Obviously P&M does not agree that the natural gas turbine proposal was inconsistent with the ETA's policy. We proposed a scenario one that had gas units in it, and we believed that scenario was consistent with the ETA. So I don't agree with the entire statement, other than I agree with the statement that they rejected our alternative proposal, and they went with the commission went with a all renewable portfolio. I don't agree that because of the ETA that you cannot have natural gas turbines in the future.
And in fact, all of P&M's requests for gas plants, the last 3 requests for gas plants to acquire gas plants in CCN cases before the commission have been rejected. Is that correct?
Which 3 are you referring to?
15-00205, 16-00105, and then 19-00195.
15-00205. I think, I don't know those case numbers off the top of my head, but I know we had proposed a gas unit and we withdrew that application. So I don't believe it was specifically rejected. If we're talking about the same one, I remember us withdrawing an application.
I stand corrected. That's true. So you withdrew one application, the other one also was withdrawn. Is that right? And then when you applied in 19-00195, that was denied. Is that correct?
I don't know if I'd say it was denied. The commission selected a portfolio different than the one we proposed.
Okay.
Mr. Nassi, this will likely be your last question. You have 30 seconds.
Thank you. The Valencia PPA ends in 2028, correct?
Yes, that's my understanding.
Can I have the next one?
Sure, yeah, you got 15 seconds.
Did PNM model any scenarios that extended the life of the Valencia gas plant post 2028 in this case?
Mr. Phillips would have to be asked about what PNM modeled or did not model. I'm not familiar with if the exact specifics of what Mr. Phillips modeled.
No further questions.
Thank you. We turn to the New Mexico Attorney General, Mr. Gedko. You've requested 5 minutes.
Yeah, good afternoon, Mr. Fenton.
Good afternoon.
In your direct testimony, you refer a couple times to PNM owned assets, correct?
Could you show me where
Well, yeah, the bottom of page 3, it's with respect to transmission lines, but line 21, you talk about PNM is also seeking approval to sell PNM owned assets. And then turning to page 5, on line 11, you reference PNM only leases and does not own the 114 megawatt leased interest in PVNGS.
I see that.
So is the answer yes, you do refer to the concept of PNM owned assets?
Not really. I mean, the context for this on page 3 is I was referring to the assets that we own that we were selling to Salt River Project, which is our switch yard or transmission facilities and other assets, which is kind of a moot point now because the commission, it was decided that we do not need to file for, we did not need abandonment. We also did not need approval for those assets. And then on page 5, I'm just acknowledging that the type of arrangement we have here is a sale leaseback arrangement that had benefits for customers. So I'm not really talking in my testimony about ownership in the sense of ownership versus a PPA, for example, but I'm talking about two specific examples.
Are you're familiar with that difference between ownership and a PPA though, right? And because you just referenced that idea of a PNM owned asset being in contrast to a PPA. Correct?
Yes, I'm generally familiar with that concept, yes.
Okay, and PNM owned assets are a part of your overall portfolio of resources, correct?
Correct. I mean, our portfolio of resources is a combination of, we own some, third parties own some, we also have PPAs. So there's a variety of different ownership and contractual relationships that we have in our portfolio.
When you make internal decisions with respect to resources included in your portfolio, is the fact that a resource is owned by PNM ever considered in any way?
Well, I think Mr. Falgren would be better in terms of how he may consider that in terms of reliability, for example. You know, I'm just immediately flashing to what happened in the replacement resources for San Juan and how those were PPAs, and we're now having some difficulties getting those online. But it's a consideration. But I think Mr. Falgren would probably be better to talk about his thoughts on generation and the difference between PPA and ownership.
Okay. And I'm still learning a lot, but PNM, you get a return on equity on utility-owned resources, correct?
Correct.
And do you get a return on equity on PPAs that you're a part of, that you've contracted for?
No, we
Okay.
don't. However, what I would say about that is the developer themselves have their own internal return that they're calculating when they come up with the price that's in the PPA. So even though the PPA, we may be passing those energy costs through the fuel clause, that doesn't mean that there isn't a return that is going back to the developer. So I don't think you can simply just say, well, PNM gets a return if they own it. They don't if it's a PPA. Therefore, it's cheaper. Therefore, it's a better deal. I think you could explore that some more with Mr. Falgren, but I think we would vehemently disagree with that. And we also have some concerns with reliability from time to time. In this case, though, Mr. Getko, these are PPAs and ESAs. These are not PNM-owned facilities.
Right. And I just want to make sure I heard two things that you said in the middle of that long statement, which was, one was that, just taken straight as fact, PNM does not earn that return on equity on those PPAs. And the second statement, the owner of that project that provides you with that resource for which you've contracted in the PPA, they're the ones that earn that return on equity on that resource.
Yeah.
Correct.
Yeah. I don't know if return
Okay.
on investment or return on equity, depending on their situation. Yes, I would agree with that, Mr. Getko.
But Mr. Getko, that's your time, sir.
Thank you for that. Thank you, Mr. Fenton.
Thank you.
Mr. Fenton, how are you? That's the end of the interveners questions for you. I have some myself. So one of the more interesting exchanges that happened between you, Mr. Throne, came with regards to whether, when we think about this case, is the commission being asked to approve the resources, or are they being asked to approve the modeling and the resources? I guess my question to you, sir, was whether or not you're familiar with any other cases in which it was pretty clear that the modeling was in fact what was under investigation. Can you think of another instance where?
No, I can't. And, I'm frustrated in this case that it seems like the modeling assumptions are clouding what we're really asking for, and that's approval of the PPAs and ESAs. And I can't think of a case where we went in asking specifically, please approve these underlying modeling assumptions. My experience in a CCN cases are that when we go on to the next case, no matter what happens in this case, when we go on to the next case, people are going to bring up the assumptions specific to that resource. Or in an IRP, they're going to talk about modeling assumptions. But to answer your question, Mr. Ryan, I don't recall it, and I don't believe that's what we're asking for here. And I'm frustrated because it's affecting the timing of this case, and we have a very high need to get these resources online in 2023. And we're already past the approval date that developers need. So.
And I understand all that. So I guess the next question I'd ask is, but I suppose, would you agree with Mr. Throne that the commission would have to, in fact, accept the modeling you did here and say that passes muster in order to say that these resources should be approved?
I don't think the commission needs to specifically approve any of the underlying assumptions. Inherently, by approving the portfolio, the commission, and for that matter, all the parties are saying that the assumptions were reasonable. The end result was reasonable. But I don't believe the commission needs to go and say the import capacity limit needs to be this going forward, or the reserve margin needs to be this going forward. I think what the commission that needs to know that the assumptions weren't unreasonable. And in this case, it seems like the parties all agree to the end result. And the end result was the portfolio itself. I don't remember cases where they go in and specifically say, and I don't think it needs to be done here, that these following assumptions going forward, that's what the commission should be using.
And I suppose the question I'd ask you too is, do you perceive what Onward Energy Holding is attempting to achieve here to be some sort of future statement about what must be modeled and whether that's appropriate?
I do think that's what they're achieving, and I don't think it's necessary to address that issue going in this docket. And I don't even think it's appropriate to address it in this docket.
To what extent is battery storage necessary in light of the decision to procure these solar resources?
It's absolutely necessary. I think Mr. Phillips would be better to discuss how he came up with the mix of the solar generation, the 300 megawatts of solar, 150 megawatts of solar, then the 150 of battery. And well, I won't go down all of it, but the mix and the requirements for storage are absolutely essential to this portfolio.
Is it correct, but is my understanding correct that batteries will function? And you just educate me. I'm not asking a directed question. I'm not trying to trick you in any way. You just tell me if I'm understanding correctly. But the way that the battery storage works is that it functions in very much like a backup generator, like a peaking unit, in that it can release energy when it's demanded because the batteries have stored it. So it's like you don't have to have the generator, you just have the batteries, which provide the generation that perhaps a peaking unit would. Is that correct, or am I wrong in what I've just said?
No, I think that's correct. But I would say that Mr. Fahlgren is very, very familiar with the use of batteries, and he's the next witness. And I think he could give you an excellent overview of the batteries that we're proposing. I think generally you had the concept correct, though.
Can I ask the question about the technology neutral and the no new combustion pad, as they've been discussed in this case? Where did PNM come up with that sort of paradigm in terms of how it was going to move forward and think about procurements? Is this something that others utilities are doing, or is this something that you all have sort of created as a consequence of what's happening here in New Mexico?
Well, Mr. Phillips would be a good one to ask. That's the term he used in the integrated resource plan, technology neutral. That includes natural gas. No new combustion means that it doesn't include fossil fuels. So it's really, there's different ways you could approach it, but it's sort of renewables and non-renewables is another way to think about it. It's a term that he coined, I believe, in his IRP. Whether it's in other IRPs, I really couldn't tell you. But Mr. Phillips he could go through that, because the first time I saw that coined was in the integrated resource plan.
Okay. At page 35, Mr. Throne asked you about this. This is your direct testimony. You write, although PNM's analysis also modeled lower cost scenarios that included gas combustion units that could be converted to non-carbon fuel supplies, PNM concluded that under the circumstances, it's reasonable to replace a leased carbon-free resource with other long-term third-party contracts for renewable and energy storage projects that provide savings to customers. And I guess what I'm wondering is if there were gas resources that provided an ultimately cheaper. I mean, Mr. Throne pointed towards Mr. Phillips' charts, right? And he said, look, it's cheaper to involve the gas. And the question I was wondering is why, I mean, and I know your testimony overall states this, but why is it essential to PNM to choose the totally no new combustion resource if in fact it is slightly more expensive?
In this case, as I stated in my testimony, we felt like that replacing the nuclear facility here was carbon free.
Mhm.
And if we would have proposed gas, what we found in the past, and I think what you're hearing in some of the cross-examination today even, is that becomes highly controversial. So the difference for the replacement resources was not great. It was 88 to 94, which isn't insignificant, but we just felt like because we were replacing a carbon free resource, that we should replace it with another carbon free resource. And I tried to say in my testimony that going forward, depending on the specific circumstances, that may not be the case. The cost differential may be more, and as this transition is happening quite fast, and as we learn more and more going forward, reliability is also a major consideration. So what I tried to emphasize in my testimony is that PNM will consider gas going forward, but in this specific case, the cost difference wasn't great, and we felt like it would be appropriate to replace carbon free with carbon free.
Is the Valencia facility one that can be converted to gas? It wasn't clear to me from all the testimony I read.
The Valencia facility is a gas resource.
Well, no, but if it could be, sorry, I apologize. Could it be converted to hydrogen?
I guess I don't know. Mr. Falgren would know the specifics. I think there needs to be some things done to the Valencia resource to make it more efficient, more efficient. But in terms of the hydrogen conversion, you would need to ask Mr. Falgren about that conversion, how much that would cost, and whether it's feasible for that type of resource, which is a heavy frame resource. What I'm trying to tell you, Mr. Ryan, is we have Mr. Falgren he's our vice president of generation, and he's really familiar with the different types of resources and hydrogen and those kind of things. So he would be the technical expert that could really help you with some of these questions.
Okay, that's fair. And then I guess Mr. Fenton is the executive director of regulatory policy and case management. Can you just describe what are you sort of overseeing those individuals? Are you sort of directing them? Is that the idea?
No, I do not direct Mr. Falgren. He's a vice president.
Okay.
Who I oversee is I have a regulatory case management group that we work very closely with the legal team. We prepare cases, whether it's this case or a rate case. We work with the legal team to develop the testimony. In some cases, I do testify in the cases, but I'm over the regulatory team, the case managers that, we serve the pleadings, we help the witnesses get prepared. In my case, I testify for the cases, but Mr. Falgren is the vice president of generation. Mr. Phillips, he's the director of integrated resource planning. They're in the operations group of PNM. I actually reside in the public policy side of PNM. I'm under Ron Darnell. He's the vice president, and under him is regulatory and governmental affairs, tribal affairs, the communications group, and pricing. And I'm the regulatory piece of it.
Okay. I think I'll leave it at there then. The last question, just really quickly. I mean, if I had a question about with the solar and the battery combination, the ESAs and the PPAs, well, two questions. First, is there anything different about ESAs than from PPAs? I mean, are these basically the same devices, but one's just for storage? Is this any meaningful difference between a PPA and an ESA in terms of?
Well, the ESA stands for Energy Storage Agreement. So it's for the storage facility. The PPA is a power purchase agreement,
right?
Where we're purchasing the energy output. I guess that's one of the differences. And then in terms of rate making treatment, the rate making treatment would be different. The PPA would go through the fuel clause. The demand component of the ESA would be in base rates. So there's a little bit different rate making treatment between the two. That's discussed in more detail in Kyle Sanders' testimony, but at a high level, that's what they are.
But effectively, I mean, these are just sort of pass-through costs, and one of them is for storage as opposed to the purchase power.
At a high level, yes.
Yeah. And then as far as the investment tax credits, my understanding is that with some of these solar acquisitions, you are in fact required to have battery power associated with them in order to take full advantage of investment tax credits. You talked about this at some point in your testimony. I mean, does it basically kind of create a situation where if you're going to have a solar project, then economically you are sort of committing yourself at some point to a battery project?
I don't think I talked about that. I think Mr. Falgren may talk about the tax credits.
Okay, well, maybe I just have bled that into your stuff. Do you have any comments about that subject, or is it something to ask him?
No, it'd be something to ask him, I think.
All right, I think that's what I was hoping to ask you, sir. Nothing further from me, Mr. Fenton. Appreciate it.
Mr. Hearing Examiner, you asked a question of Mr. Fenton about I don't have it exactly, but something like, has the commission ever addressed modeling in a prior case that affected the result? And Mr. Fenton's answer was no.
Mr. Hearing Examiner, I don't think this is proper right now. I don't have any redirect on Mr.
That's what I was going to wonder.
Fenton.
So, Ms. Nanasi, if you're going to say that Mr. Fenton's answer is incorrect, that is a subject that you can raise on post-hearing briefing. And if you're going to point to previous cases, that is not evidence, it is simply a fact, or a judicial fact, if you will, because the cases would reveal that. So if that's where you're headed, it's unnecessary.
Yeah, that is where I was headed, and I wanted it. There have been certain circumstances when the hearing examiner, based on questioning, did allow recross, and I wanted.
Yeah, I understand. That's the next question. Is well, the first question is, following my questioning, then we would have redirect, and then the question becomes, well, should there be recross? We are on a very tight time schedule here. If you'd like to ask. I mean, that's the question. It's 1 o'clock now. We have lots of work to get through. Ms. Nanasi, if you wish to have the opportunity for 1 or 2 questions, you're free to have them. But I don't think you can have more than that because we have a lot to do.
Thank you.
Do you wish to ask a question or two, Ms. Nanasi, of Mr. Fenton?
I would.
You would. Ms. Padilla, you're muted.
Yeah, sorry. PNM has no redirect of Mr. Fenton. So at this point, I don't believe any recross. I don't believe there's any opportunity for recross at this point. I'm not raising anything in redirect with Mr. Fenton.
I have one question.
Mr. Hearing Examiner, I mean, hearing examiners often allow parties to follow up with questions from the bench.
I'm aware of that. I'm trying to also to manage the fact that we have another 200 minutes of cross-examination to come. So, at some level, Mr. Throne wants to keep advancing his time. We're going to come to a point where that time doesn't get advanced anymore. So that's where we are. I will allow Ms. Nanasi to ask 1 or 2 questions, as I will allow Mr. Throne to ask a question or 2, but we have to be focused. So, Ms. Nanasi.
Thank you so much, sir. Mr. Fenton, are you aware of case 17-00129 UT, where hearing examiner Glick actually rejected a PNM owned solar resource because of what she believed was improper RFP and modeling. Well, RFP, let's just leave it there.
I'm not familiar with the finding that you just mentioned, but I guess what I would like to clarify, when I was speaking with the hearing examiner, I was talking about underlying modeling assumptions and actually having to rule on the underlying modeling assumption. You just mentioned an issue with an RFP and something with modeling. What I said is I don't recall the hearing examiners or an order where they explicitly identified a certain assumption that needed to be used going forward, other than the example I used with Mr. Throne during his cross, which was in the 08-00305 case, where there was a planning reserve margin that was established. But so that's what I was referring to during my discussion with Mr. Ryan.
And are you aware that Ms. Glick recommended rejection of P&M's solar that it was going to own because of the RFP assumptions that were used in that case?
Section P&M,
Yeah,
here, Leslie Padilla, Mr. Fenton just clarified what his dialogue with the hearing examiner was about modeling assumptions. So this question about RFP compliance is not a proper question in response to the hearing examiner's question.
Yeah, and then, but it's really at the end of the day, you're making a legal argument, Ms. Nanasi. It's okay. Does he understand that the recommended decision has X and Y legal meaning? I mean, the witness, whether he knows that or not, it's inconsequential. It means what it means. If you wish to point out in post-hearing briefing that Mr. Fenton answered questions incorrectly to undermine his credibility, you're free to do so, but we don't need to belabor this point.
Thank you, sir.
Mr. Throne.
Yes, just thank you. Mr. Fenton, regarding your answer to the hearing examiner that the cost differential between the no new combustion portfolio proposed by P&M and the alternative technology neutral portfolio that were described and presented by Mr. Phillips, you said the cost differential was not significant. I believe, were you referring there to the $144 million difference over 20 years in terms of net present value that is depicted on P&M figure NLP-4 page 35 of Mr. Phillips' April 2nd direct testimony?
I was referring to the replacement analysis piece of for the replacement resources specifically, the 88 to 94. And I don't mean that it's not significant. Certainly $6 million is significant, but in the context of the modeling and the sensitivity and the different parameters that go into a model, that's not there's a lot of different variables that could swing that one way or the other with sensitivity. And, for example, when the CCAE1 portfolio was selected, the alternative resources were much, much cheaper. There were some that were cheaper than that portfolio. So I was referring to the 88 to 94 million too.
And excuse me, just like one question. Where is that 88 to 94 reference, Mr. Fenton? It's in your testimony.
It's in my testimony. It's in Mr. Phillips' testimony. I believe it's on what Mr. Throne just referred to in Mr. Phillips' testimony. It's like page 35 and 36 of his testimony. I use those numbers when I identify the cost savings. Also on page 6, line 8, P&M currently estimates net present value savings to customers will be between 88 and 94 million to replace the leased resources.
Okay.
Later. So
that wasn't my question, Mr. Hearing Examiner. I wasn't asking about the net savings of choosing to not purchase the Palo Verde leases. I was asking about the difference between the two portfolios depicted on P&M figure NLP-4, and I'm just asking about the difference between the amount of 6,372, which is in thousands, so that's millions, and the 6228 on that figure, and that's 144 million by my calculation. So that's what I was wondering if that's what Mr. Fenton was saying was insignificant.
No, I was referring to the 88 to 94. And my understanding of the difference between the 88 and 94 is the difference between the technology neutral and the no new combustion. So I was referring to that. I wasn't referring to Mr. Phillips' testimony.
Okay.
Wait, sorry, I'm a little confused, Mr. Fenton. If you can just clarify for me, how does the value of the replacement resources with respect vis-a-vis the leased Palo Verde units? I mean, my question really to you earlier was about when you wrote in your testimony, I know we talked about it earlier, that PNM decided ultimately that it was more beneficial to select the no new combustion path, regardless of the fact that it cost more than replacement resources that may involve combustion resources, i.e. these gas plants, the aeroderivatives, or whatever it might be. And my question was about that. And I thought, and I think Mr. Throne then asked the follow-up question, like, what do you mean? Like, what numbers are you referring to? And so maybe I want you to answer my question again. If there is a significant difference in the cost between no new combustion and technology neutral, why should the commission sign off on the more expensive resources?
And that's what I was saying is what I was comparing on page 6 is the 88 million is the technology, the savings associated with technology neutral relative to repurchasing leases. The 94 million is the no new combustion relative to repurchasing. So based on those two numbers, you can get a sense for what the cost difference is over a 20-year period between the two.
And I see Mr. Throne shaking his head, and I'm guessing why he's doing that is it Mr. Phillips' indication here of the difference, the larger difference in price? I mean, I guess I perhaps don't fully understand what the difference in the price is. I guess that's maybe so it's your testimony, Mr. Fenton, that this 88 and 94 million is the difference between the no new combustion and then the technology neutral. That's what you're telling me.
The 88 million is the difference between the technology neutral scenario and it's the savings. It's the savings relative to comparing it to a repurchase. If you would repurchase it or replace it with a technology neutral portfolio, you would save on a net present value over 20 years, 88 million. If you would replace it with no new combustion, the savings are only 94 million. They're both significant.
Okay, and you keep referring to as the leased units at Palo Verde, right? If you replace it.
Because that's what we're doing here, right? And what this is demonstrating, I'm sorry for the confusion, but either portfolio, whether it's a technology neutral portfolio or whether it's the no new combustion, either one of those portfolios has a significant amount of savings relative to what's at issue here, and that's repurchasing the lease.
And I guess that's in the end, then let me ask that last question. So I understand everything you just said. And then the question I want to just ask again is, so why, if you're asking the commission to approve a more expensive option, and it's, if I understand correctly, the no new combustion is more expensive, why should the commission do that?
That's what we said in the testimony. We felt like the policy decision was to replace, because this is a carbon-free asset that we're replacing.
Yeah.
So for that amount, and that may look like a lot, but there's a lot of sensitivity in here too, right? You're looking at a 20-year planning period. There's lots of assumptions that go into that planning period in terms of the cost of what the resources are going to be, what the cost of natural gas is going to be, what the load forecast is going to look like. So there's a lot of variables. So you can't just look at these numbers and say that is the number. That's the exact number. It's, it is a model and it is, an analysis that's done. But looking at it, we decided that from a policy perspective, it was better to replace this with renewables. If you go back to our 195 case, there, which is the San Juan replacement case, there were cheaper alternatives that the commission didn't decide for policy reasons also related to. So.
And the policy choice you keep referring to is the one in which effectively we're moving to a world in which renewable resources shall be the only option moving forward. I mean, I know that's not entirely possible, but that's basically where you're trying to go.
Right. And what I was trying to say in my testimony is, going forward, we are going to have to consider, we will consider gas going forward also. And
with the idea that ultimately hydrogen becomes the basis for those gas plants, that's the idea?
Yes.
And then if you convert over to hydrogen, then technically you're still not emitting CO2 and you've solved the emissions problem. I mean, that's kind of the unicorn, right? We're all after.
Yes.
Okay. Why don't we stop there? Thank you, Mr. Fenton, for your time, sir.
Thank you.
Have a good afternoon. So Mr. Fenton's excused. We'll have to take a 45-minute lunch. Won't go the full hour. So it's going to be more like 40 minutes. We'll just come back at 2 and we'll all soldier on. See you at 2. Okay, it's 2:00 now. Ms. Gonzalez, everything set?
Yes.
Great, we'll go back on the record. All right, we've just returned from our lunch break. We are now going to proceed to PNM's second witness, Mr. Falgren. Ms. Padilla, go ahead.
Thank you, Mr. Hearing Examiner. Yes, PNM calls Thomas G. Falgren.
Ms. Gonzalez, if you could swear the witness, please.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Go ahead, Ms. Padilla.
Mr. Falgren, could you please state your name and your position at PNM for the record?
Thomas Falgren, Vice President Generation.
And you filed testimony in this case and in the related docket 21-00083, correct?
Yes, that's correct.
Okay. Do you have what's been marked as PNM Exhibit 3 in front of you?
Yes, that's my direct testimony. dated
Okay.
April
And
2nd.
Ms. Padilla, how about this? Unless there's an objection from any of the parties, so we move as fast as we can through these sort of formalities, just do all the tests. Is this going to be
Certainly.
acceptable to the other parties to do it all in one lump sum? I'm just trying to make us go as fast as we can. Very good. So Ms. Padilla, just
Okay.
do them all at the
Sure.
same time, if you know what I
Sure.
mean.
Mr. Falgren, I'm going to be asking you about PNM Exhibits 3, 4, and 5. You identified Exhibit 3. Could you identify Exhibits 4 and 5, please?
4 is my supplemental testimony on June 25th, 2021. And 5 is my rebuttal testimony on September 30th, 2021.
Okay. Were all of these prepared by you or under your supervision?
Yes, ma'am.
Do you have any changes or corrections to make to these right now?
No, ma'am.
And are they true and correct to the best of your knowledge?
Yes, ma'am.
And if you were to be asked the same questions today as are in the testimony, would your answers be the same?
Yes.
With that, Mr. Hearing Examiner, PNM moves the exhibit of PNM Exhibits 3, 4, and 5.
Are there any objections to PNM 3, 4, or 5, the direct testimony of Thomas Falgren, his supplemental testimony, and then rebuttal testimony?
No objection.
No objection heard. The PNM Exhibits 3, 4, and 5 are admitted.
All right. Thank you, Mr. Hearing Examiner. PNM makes Mr. Falgren available for cross-examination.
Mr. Throne, you are up for 155 minutes.
Thank you, sir. Good afternoon, Mr. Falgren. For the purposes of my cross-examination and in accordance with the hearing examiner's November 5th procedural order, I'm going to ask you questions about your rebuttal testimony, PNM Exhibit 5. And would you also have available to you PNM Exhibit 8, which is Mr. Phillips' June 14th, 2021 supplemental testimony, and also Onward Exhibit 1, which is Mr. Spurgeon's direct testimony. And tell me when you're prepared and we'll start.
Well, I have my testimony in front of me. We'll look at the other ones as we go.
Okay, but you have them readily available.
They're becoming readily available.
Okay, great, thank you. Let's turn to your rebuttal, page 5, line 13.
Yes, sir.
And starting there, and I'm going to ask you about that testimony, continuing over to page 6, line 11. You described there 6 actions and factors that PNM and the commission should take and consider with respect to renewable energy projects proposed by bidders in response to future PNM RFPs to help address potential delays in their ability to complete their projects by the time they are needed by PNM. Is that correct?
Yes, sir.
Okay. And is it PNM's position that PNM and the commission also should take those actions and consider those 6 factors with respect to energy storage projects that are proposed by developers in response to future RFPs.
I believe we were not distinguishing between renewable wind, solar, or batteries in that context. So I believe I concur with you.
And would your answer be the same regarding those 6 factors and those actions with respect to any flexible gas-fired resource projects that are proposed by bidders in response to future P&M RFPs?
Give me just a second. I think we could agree that those are generic to any future resource that we would be pursuing. That would be good to pursue those options.
Okay. Now, you were a witness for P&M in Commission Case 19-195 UT, where P&M was requesting replacement resources for its remaining interest in the San Juan Generating Station, correct?
I was a witness in 19-195, yes.
And in that case, that's correct, is it not, that P&M relied on 2 distinct requests for proposals to identify its proposed San Juan Generating Station replacement resources?
Could you repeat the first part of that question? I'm not sure I caught the first.
Sure. It's correct, is it not, that in that case, P&M relied on 2 distinct RFPs to identify its proposed San Juan Generating Station replacement resources?
I'm not sure if I agree with your characterization, but we had an RFP and we had a supplemental RFP.
Right. And the first one was issued in October 2017, correct?
That's subject to check.
And the second one was issued in April of 2019. Is that correct?
Subject to check, it seems.
Okay. Subject to check again, would you agree that the deadline for proposals in response to the first of those 2 RFPs, the one that was issued in 2017, was January 30th of 2018?
I'd have to check.
Does that sound?
I think when was the first one issued?
October 2017, and I believe this was established in that 195 UT case, that the RFP that you produced in that case said the proposals from bidders were initial proposals were due. The deadline was January 30th of 2018.
Subject to check, that seems appropriate.
Okay, and it's correct, is it not, that the first time P&M provided the commission with the results of those RFPs was on July 1st, 2019, when it filed a consolidated application for both approval of P&M's proposed abandonment of its remaining interest in the San Juan Generating Station and for replacement resources for those resources.
Mr. Hearing Examiner, Leslie
Yes.
Padilla for P&M. I think I need to object to this line of questioning. Mr. Thurn is asking about a 4-year-old set of IRPs that are unrelated to the RFP that led to the resources that are under consideration in this case. So I don't understand the relevance of the question.
Mr. Throne, go ahead.
Yes, I am addressing these. These are relevant to the issue of the timing in this case. P&M has represented not only to the other parties in this case, but to the commission in public meetings that as a result of the delay that resulted from commission approval of replacement resources for San Juan in that 19-195 UT case, there's a question about whether or not they would have the necessary resources in place by June of 2022 to meet their resource adequacy requirements. And so and then in this case, I know they've raised issues about whether or not the delay in a final order in this case may cause problems for P&M in terms of meeting its resource adequacy requirements in 2023. So I'm just trying to develop the record on that.
So the only thing I would say in response is, I mean, I just did the PNM Renewable Energy Act case, and the delays associated with the San Juan generating station replacement resources, I don't think that PNM has ever said that they're attributable to the commission, but that it's attributable to the pandemic, which basically nuked the entire world supply chain. And so what we have is the San Juan generating station. They can't get solar panels out of China. It's impossible. Can't be done, apparently.
Yes, and yes, Mr. Hearing Examiner, I realize you were not, with the commission back in that 195 UT case, but there was extensive discussion in the case about the long delay between the time PNM issued its 2017 RFP, which was an all source RFP, and the time they came in for requesting a commission approval, which is on July 1 of 2019, because ultimately the resources that were approved in that case all came out of that earlier RFP. And so there was a long delay in actually in PNM's filing, and I am developing that because I think it has some relationship to what's going on in the current case.
All right. Well, I'll allow it, Ms. Padilla. I mean, he can set the record, but I mean, Mr. Throne, try to drive to where you're headed as efficiently as you can.
And I don't think the witness answered that last question.
Why don't you restate it?
And it was, it's correct, is it not, that the first time the PNM provided the commission with the results of those two RFPs that we just discussed was on July 1st, 2019, when PNM filed a consolidated application for both approval of its proposed abandonment of its remaining interest in the San Juan generating station and for replacement resources for those San Juan interests.
I think I'll let the record stand for itself. I believe that we did file the San Juan abandonment and replacement case in July of 2019.
And is it correct that in that case, PNM asserted that the new resources proposed in its application would be needed for service by June of 2022 due to PNM's proposed abandonment of its remaining interest in the San Juan generating station by the end of June of that year?
I believe that's correct. Yes.
Okay, let's turn to page 7, lines beginning at line 5 of your rebuttal, please.
Very well.
Okay, get there myself. And there you address what you say is the role the Valencia facility plays in PNM's generation portfolio and the limitations in that facility's existing air permit from the New Mexico Energy Department, and how well that facility meets PNM's changing resource needs and the pricing structure and charges under the existing Valencia PPA, correct? And that continues all the way over on to page 9, line 20.
Can you tell me where you're reading from exactly?
Yeah, I'm trying to summarize what you're addressing, beginning at page 7, line 5 to page 9, line 20.
There are a number of questions in there, which I'll let them speak for themselves.
Well, it is my turn to ask the question. So well, let me ask it this way. Would you agree that your testimony there does not refer to any of the proposals by Southwest Generation that were made or submitted in response to PNM's 2020 RFP that included an extension of the existing Valencia PPA and offering to provide that facility with quick start capability and with lower minimum demand operating requirements compared to the existing Valencia PPA?
I don't think I agree with that characterization.
Well, you tell me where in that section you're referring to the Southwest Generation proposals that were made in response to the 2020 RFP.
I don't make I may not make a specific reference to it, but again, you know, our contention in this case is Onward did not offer any capacity improvements in 2023.
Now, that's not my question, sir. You're not
Well,
answering
on
my
a
question.
basis- Can I answer?
No, sir, that's not my question. My question is, in this part of your testimony, where you talk about what role does Valencia play? Now, you're talking about an existing facility, an existing Valencia PPA that expires in May 2028, correct?
I am talking about how Valencia used in the proposal from Onward in the case proposed that Valencia would be continued to be used in the existing configuration until 2028. And then the contract would be extended beyond that in a non-competitive manner without competition against other competitive bids. So I'm laying the foundation of how Valencia is used today and how that extends, how your proposal extends it.
Okay, well, I know actually the lawyers lay the foundation. I'm just trying to ask you a question about your testimony, sir.
I'm just trying to give you
when
an
you talk
answer.
about the role, you just talked about the role that Valencia plays today. Would you agree with me that when you speak in this section of your testimony about the role Valencia plays today, number one, you're talking about the existing Valencia facility as it's currently configured that doesn't have quick start capability?
What I'm discussing here is how Valencia is used today. And many of the provisions that are in this section would be continued past 2028.
Well, the way Valencia is used today is in accordance with the existing Valencia PPA, isn't that correct?
That's correct.
Okay, and so that has nothing to do with whatever Southwest Generation may have offered in terms of a Valencia facility that has additional capability, including quick start capability and lower minimum demand requirements, correct?
I'm sorry, repeat that, lower.
Minimum demand requirements.
The proposal from Onward included many of the provisions that are in this section. And I'm laying the foundation how Valencia is used today, which extends over for past 2028. So for instance, if you allow me to answer the question more fully, is the air permit provisions in your proposal are unchanged. The air permit restrictions have a significant limitations on Valencia. They do today, and they would post 2028. So I think it's important to discuss that and discuss that in the context of that.
Okay. Now, your testimony in the same section of your rebuttal, page 7, line 5 to page 9, line 20. That testimony, when you talk about the existing role, okay. Now, well, let me back up. You participated in the preparation of PNM's 2020 Integrated Resource Plan that was filed in the commission in January of this year in case 21-00033 UT, correct?
I may have visited with Mr. Phillips is the correct individual for that. If you want to ask particular questions on the IRP, I had some very limited involvement. Mr. Phillips is the individual that carried that filing.
Well, weren't you involved in were people under your supervision and control in describing, for instance, the operating characteristics of the plants in PNM's existing supply portfolio?
Again, I think if you're going to talk about the IRP, you should your best to get your best answer for you. You should just consult with Mr. Phillips.
So you can't answer that question?
I'm trying to get you the best answer possible. I had some limited involvement in the 2020 IRP. If you want to ask me a specific question about it, I'll attempt. But if you want your best answer, you should talk to Mr. Phillips.
Looking at pages 8 to 9 of your rebuttal. And there, you talk about the pricing structure and charges. And then you address, beginning on line 19 of page 8, carrying over to the next page, you say they don't indicate to the commission. Well, you refer to that pricing structure. Would you agree with me that the current pricing structure and charges don't indicate to the commission what the 20-year net present value of revenue requirements are of any of those Valencia PPA extension proposals that were made by Southwest Generation for the period 2023 through 2039?
And if you're referring to section 8, I mean, in page 8, where the question that says, please describe the pricing structure and charges. Those prices there are per the existing PPA. I would reference you up again to our earlier debate in page 8, lines 11 through 14, where I specifically reference what my testimony in this section refers to your potential bid.
Okay, but you're referring there in this section on pages 8 to 9 to the pricing structure under the existing Valencia PPA, correct?
The pricing structure there is under the existing PPA, yes.
Okay.
That would continue, that per your proposal would continue as is until 2028 with further obligations beyond that.
But you're not redressing in there that portion of this portion of your rebuttal Southwest Generation proposal. You're talking about the existing pricing structure, isn't that correct?
The pricing there, as I've stated, asked and answered, is that is in accordance to the existing PPA.
Now, on page 8, lines 10 to 17 of your rebuttal, you refer to the well, you refer to onwards, but well, you have a reference to OEH's suggested bid into P&M's recent RFPs. See that?
I see that section, yes.
So you're talking about multiple RFPs, correct?
I think I am mostly referring to the RFP in this case. There may be a typo on the S, but.
Well, you didn't identify that as a typo, and I believe you did read Mr. Spurgeon's direct testimony about where he addressed not only the 2020 P&M RFP, but also the March 8th, 2021 RFP for replacement resources for Four Corners, correct?
I have read his testimony.
Okay, so isn't it correct that you're referring there to both of those RFPs?
I'm mainly referring to the RFP in this case, but again, I think the same issues exist in the Four Corners replacement RFP.
Now, when you use the word suggested there, you're not suggesting you're there by that testimony. By your using the word suggested, are you that any of those Valencia PPA extension proposals did not offer firm pricing as required by P&M's RFP instructions to bidders, are you?
I'm suggesting that the onward bid into that did not meet the bid specifications. So you're
Well,
asking us to evaluate a bid outside the bid specifications of what I'm saying there.
And what bid specification are you referring to with respect to the 2020 RFP?
That we would have capacity additions in 2023.
And I know it's Mr. Nagel is the one who submitted the 2020 RFP bidding instructions, but isn't it correct? Are you familiar with those RFP bidding instructions?
I am, yes.
In fact, as I understand it, Mr. Nagel testifies that even though he and his firm developed those instructions, they were subject to ultimately to your supervision and control. Is that correct?
That's correct.
Okay, and it's correct, is it not, that there is no express provision in any of the our instructions to bidders in that RFP, which is an exhibit to Mr. Nagel's testimony, that indicates that in order to qualify for consideration, a proposal needs to provide incremental capacity to PNM in 2023.
I disagree.
So you can point to, and we'll get to this with Mr. Nagel because it's his exhibit, but you believe and you're asserting to the commission that there is a specific express instruction in the RFP bidders, to bidders in that 2020 RFP that says that to qualify, you have to propose a resource that will provide incremental capacity in 2023.
The entire purpose of the RFP was to make replacement resources for Palo Verde, which stated in the RFP instructions was to provide capacity that was available by 2023.
Would you agree with me that the proposal was made, there were proposals made by Southwest Generation regarding an extension of the Valencia PPA in response to the 2020 RFP, and that there was a distinct proposal made by Onward Energy for a PPA extension for the Valencia facility in response to the 2021 RFP issued by PNM on March 8th, 2021.
If you're asking me if I believe that Southwest Gen Onward provided bids on both of those RFPs, I would concur with that.
And they were not the same, correct?
I'm not as intimately familiar at this point with the Four Corners replacement. Our team is still evaluating that. When they do a complete evaluation, I'll get a debrief on it and we will review that. So I'm not intimately familiar with the Four Corners replacement RFP and bid that Onward would have submitted.
So as you sit here today, you don't know whether or not PNM has already indicated to Onward, as indicated in Mr. Spurgeon's direct testimony, that their bid in response to that 2021 RFP did not pass the screening process?
That's not what I said.
Well, what is your understanding in that regard?
That your bid in both cases was non-compliant with the RFP instructions.
But it's true, is it not? And we'll get to this with Mr. Nagel, that in fact, Southwest Generations, at least one or more of their bids for a PPA extension for the Valencia facility did pass the screening process in response to PNM's 2020 RFP.
I think I would not agree with that characterization. And if I could explain that for the audience a little better, I would. So what the process is, and Mr. Nagel can do a much better job of explaining it, is we really have a 3-phase process, right?
Mr. Nagel can address that. That's not in your testimony, is it?
You asked me a question, I should be allowed to respond, to answer the question.
Well,
so if you look at the 3 phases, I'm trying to respond to your question, sir.
And just for the record, I will note that I was reviewing the witness's testimony before the hearing, and it is in there. He does describe the 3 phases. It's actually one question I had, so to the extent to which that influences anything.
Thank you. If it's okay, I'll respond.
Sure, go ahead.
All right, so there's 3 phases to the process. The first phase is really just an evaluation process to see where there are fundamental errors in it. When we looked at the Southwest bid in the 2020 case, it did not meet that original criteria. However, what we did is there were no other, what we would call heavy frame gas units offered in at that point. And really when we get to phase 2, what we try to look at is the best in class. And when we mean the best in class, if we go back to kind of resource planning, maybe 10, 20 years ago, is we used to kind of look at levelized cost of electricity, but that doesn't work today with all the renewables and the different attributes that each particular resource brings to the table. So what you have to do is we get best in class for each particular technology. So there's a best in class for solar, there's a best in class for wind, there's a best in class for battery, there's a best in class for solar battery combination, best in class for aeroderivatives. And what we didn't have moving forward was any provision that was there was nothing offered in for a heavy frame unit into the RFP. So what we did is an abundance of caution. We said, well, there's nothing that's in that category. So we said, even though it does not meet the criteria, let's continue to investigate that. Let the developer go through a round of questions and see if the developer is willing to put to revise that bid so that it did provide a conforming bid. We went through that process. So technically we would have, you could say we moved it to phase 2, but we kind of moved it to phase 2 in a contingency manner to see if we could make it conforming. We got to phase 2. We had numerous conversations with Onward. We could not reach a conforming bid configuration. So then therefore we notified Onward that it was a non-conforming bid. We moved other bids into phase 3. Phase 3 goes into modeling, where we have to model the different resources to come out with a low cost portfolio.
Now, you keep referring to Onward, that you informed me, you mean Southwest Generation before the merger occurred and they became Onward?
Certainly, sir. I agree to that correction.
And so, so as I understand your answer then, as distinguished from the information provided by Mr. Spurgeon in his direct testimony, that he was notified by P&M that their proposal in response to the March 8th, 2021 RFP was just simply screened out, didn't pass the screening process, didn't get to phase 2. You did not screen out Southwest Generation's proposal in response to the 2020 RFP because it was the only heavy frame or proposal that included a heavy frame technology resource, correct?
I think I answered that previously in my last response, what I was stating.
Well, what I'm trying to, but you didn't disqualify. Okay. It passed the screening process, correct? Before you decided you no longer wanted, you decided not to model and go into the phase 3 modeling process, correct?
That's not what I said.
Would you agree with me that in terms of types of technology, that a heavy frame combustion turbine that is modified to have quick start capability, that is, be able to ramp up within 10 minutes, is a different or a distinct technology type than a heavy frame combustion turbine that does not have quick start capability?
I hesitate a bit because your question seems to be a bit premised on maybe an antiquated model of resource planning. And if you allow me to expand on that, I will.
I didn't ask you about resource planning. I asked whether or not you recognize that in terms of technology types. I mean, I understand that, you know, Mr. Nagel in his exhibits indicates that heavy frame is a distinct type of technology that should be modeled or should be considered. What I'm asking you is it also a distinct technology type to have heavy frame that is modified to have quick start capability?
If you want a yes, no answer, I'd say no, they're both the same. If you want me to expand on that and explain it, I will. If you allow me to, I will.
Okay, go ahead.
Thank you. What I believe, as I was trying to explain, is I believe the question seems to be centered in some antiquated thinking about modern resource planning. And the idea there is, if you look at resource planning that occurred 20 years ago, we made very distinctions between quick start units, which were peaking units, maybe an intermediate unit that could be a heavy frame or a heavy frame with a combined cycle. We'd have base load that might be coal and gas, if you would. And so there was much more emphasis, I would say at the time, on maybe a 10-minute start because there wasn't a lot of resources. There was a fair number of base resources. You'd kind of build it from the bottom up. You'd build your base resources, and then you'd factor in some intermediate resources, and then you'd have peaking resources. So then peaking resources would be your fast start requirements. But what you're really looking at in that criteria, when we're talking about a 10-minute start distinction, is that is one requirement, that is one NERC requirement that's very limited today, if you would, has very limited, very limited effectiveness, if you would. So yes, it's a requirement, but if you look at that 10-minute requirement on a P&M system, what we have to do is we have to meet about 60 to 80 megawatts of capacity on that 10-minute requirement. If you look at the amount of resources that we have in 2023 that meet that requirement, we will be 800, 1,000 megawatts of resources that can meet that 10-minute requirement. So the fact that a bid from Onward or from Southwest Gen said that I could take none of my frame unit and start in 10 minutes, but their proposal wasn't even a full capacity in 10 minutes. It was just moving a small amount or a limited portion of that capacity over to the 10 minutes. When you look at that from a practical basis, it really has no impact on the effectiveness or the flexibility of the unit, nor our ability to meet that 10-minute requirement for NERC, because I have an abundance of resources that meets that. Really, what you're looking at today in modern resource planning is more of a continuum of the flexibility of every resource, which is what we continue to emphasize. And I'm sorry if I entertained you, Mr. Throne.
No, it's just going
a little respect. I would appreciate a little respect when I have an answer.
Yeah, and we're going to be here for 2 hours, folks. So let's let a little air out of the room.
That was a very long explanation. So let me just ask this.
Before you go, Mr. Throne, real quickly, you said twice, and this is partly for the benefit of the court reporter, Mr. Falgren, NERC requirements. Can you explain what that is? I see Melissa's shaking her head, so thank you.
Sure, it's a capital N, capital E, capital R, capital C. Stands for North American Electric Reliability Company. And it's really the FERC arm of the regulatory reliability requirements we're required to have on our system.
Thank you, Mr. Falgren. Go ahead, Mr. Throne.
Thank you. So, Mr. Falgren, going back to your previous response. It's correct that when Southwest Generation made their proposals in response to the June 2020 P&M RFP, and as you say, out of abundance of caution, you went ahead and follow up that. And I know this phase is discussed, phase 2 and phase 3 at length by Mr. Nagel in his testimony. But at that point, you did have discussions, and at that point, it's correct, is it not, as addressed by Mr. Spurgeon in his testimony, that at that point, there was an offer to lower the existing minimum demand requirements that are specified under the existing Valencia PPA.
I am familiar with the presentation that Southwest gave during that. I did not participate in it at the time. There seems to be a footnote that said if you wanted to, we could lower that. I would also add that that's a very simple add that really doesn't cost Southwest anything, and we've already done that on all our 7 FAs. So I guess I would have hoped that Southwest would have done that just out of abundant caution and being a good partner anyway. But I believe there was a footnote in that offer that said that there was a provision in there that was a consideration.
And so that would, and Mr. Spurgeon, you don't dispute, but Mr. Spurgeon, how he describes the offer that was made by Southwest Gen, correct? In your rebuttal.
You'll have to refer me to exactly what you're referring to.
Well, I'm just saying your rebuttal testimony. does not rebut or dispute that description by Mr. Spurgeon of the offer that was made to P&M, correct?
Again, I'm not offering opinion here on the validity of Mr. Spurgeon's, what he suggested, unless you give me a reference that I can read.
And you're not disputing, are you, that P&M made a decision to not even model any combination of resources as part of its replacement analysis, in this case, that included any of the Southwest Generation Valencia.
I'm sorry.
PPA.
I'm going to need that again.
Okay, certainly. You're not disputing, are you, Mr. Falgren, that P&M made a decision to not model any combination or portfolio of resources as part of its replacement analysis, in this case, that included any of the Southwest Generation Valencia PPA extension proposals?
I believe P&M considered in their modeling, took forward to phase 3 and modeled bids that the best in class bids that were conforming to the RFP. I would agree, I would contend that P&M did in discovery then offer additional modeling for the proposal that you're suggesting.
But I'm talking about as part of the replacement analysis that was presented in your P&M's direct testimony, in this case, upon which your application was based. There was no modeling as part of that replacement analysis performed of any of the Valencia PPA extension proposals, correct?
I would answer that. It doesn't make any sense to model non-conforming bids.
So the answer is yes, you didn't model it. Any combination of resources that included any of those Southwest Generation.
I'm sorry, wait. So the answer is yes, you did model it. Any combination of resources that included any, okay, you're cutting in and out for me. I'm very sorry.
Yeah, who knows? It could be on my end with the technology. I'll go more slowly. The answer is yes, P&M did not model any combinations or portfolio of resources as part of its replacement analysis presented in this direct case that included any of the Southwest Generation Valencia PPA extension proposals in response to P&M's 2020 RFP.
In our original analysis, we only took the conforming bids to phase 3. We did not model the onward non-conforming bid in the 2020 IRP analysis. We also did not model it in the 2021 RFP. And just to confirm the validity of that, P&M is working with an independent evaluator in Four Corners case. And we did review that decision in the Four Corners case, not to take that the onward bid in that case was non-conforming. We did review that with the independent evaluator that we will provide available for the commission in that case. And he did concur that that was an acceptable and reasonable and appropriate decision, and that particular bid was non-conforming.
And now your answer that you just gave, you're now referring to an RFP, the process that that P&M hasn't even asked the commission to address yet. Isn't that correct?
You referenced it earlier, so I'm referring to that. Yes.
And P&M hasn't filed an application for replacement resources for Four Corners, or for that matter, for any other reason based on that 2020 RFP. Isn't that correct?
I believe you might have met 2021 RFP.
2021 RFP, March, yes.
We have not filed a replacement case for Four Corners at this moment in time.
Okay. Going to page 9, line 7 to 20. And there you, here you compare what you refer to as, quote, the costs associated with the existing Valencia PPA to other resources available to P&M. Is that correct?
Yes, sir.
And when you say the other resources available to them, do you include in that, in those other resources, other existing gas-fired resources that are identified in P&M's 2020 IRP that are owned by P&M?
Could you send me to the specific language you're referring to?
Yeah, I just did. You said other resources available to P&M.
What
So
line
you're-
are you on? What line are you on?
Well, line 7 to 20, let's see.
It's 15.
Thank you.
What I'm referring to there really is the other, if we were to do capacity additions. So I'm really referring to the available batteries that would be available in that case. It's other available resources. And I think what I was referring to there is if we were going to do a comparison on an extension of the Valencia PPA, we really should evaluate it against other competitive bids that were solicited for the same time as the capacity addition was going to be made.
Well, when you're doing integrated resource planning, isn't it correct, Mr. Falgren, that you're looking not only at proposed new resources, but you're looking at your existing resources and whatever assumptions you have about how long you plan to operate those resources?
I don't believe I'm referring to here in the IRP process, so I'm unsure of your question.
Well, I'm asking about it. When you're looking at resource proposals and satisfying the company's resource adequacy needs for a particular point in time, you're not just looking at proposed new resources, you're also looking at whatever your assumptions are about your existing resources, correct?
What we're looking for in this case is when we do a evaluation of a particular, I'm sorry, sir, are you, your facial reactions and your body motions are disrespectful to me.
You're not answering my questions. I apologize, Mr. Falgren. Let me try it again. When you make a decision about what resources you need, you're not looking only at new resource proposals. You're looking at what your existing resources can provide in terms of both capacity and flexibility during particular years during your planning horizon, correct?
I think when we're looking at resource replacement decisions, we're looking at the incremental. So we took the Palo Verde resources out and we evaluate what other resources that fit into that hole satisfy. So is there a base assumption that some of the existing resources remain? Likely. But again, the focus of that is Palo Verde is going out. What resources are to replace that? Does that meet a reliability criteria? And then what's the low cost for achieving that particular transition?
Are you generally familiar with P&M's description of P&M's existing P&M-owned gas-fired resources in its 2020 Integrated Resource Plan that was filed as an exhibit to Mr. Phillips' supplemental direct testimony in this case?
You'll have to refer me to the particular page, but obviously I'm the VP of Generation, so I'm familiar with our existing resources. So if you want to reference a particular page, we can do that.
Okay, and again, you're generally familiar with the fact that, for instance, the appendices to P&M's 2020 IRP has various information regarding the operating characteristics, things like, expected useful life, and cost information regarding both existing resources and proposed new resources, correct?
Yeah, if you want to refer me to a particular section, I can opine on that, but
unfortunately, I don't have the time to to go through evidence that's already in the record. Will be in the record when Mr. Phillips' testimony. I just wondered if you can answer that question without referring to that. If not, I'll move on.
I'm familiar that the 2020 IRP has information on existing resources as part of the rule.
Let me have you look at what's been designated as Onward Exhibit 1, which is Mr. Spurgeon's direct testimony at pages 66 and continuing to page 68. Please.
66, Mr. Throne?
Yes.
Thank you.
Page 66, I am there.
You there?
I am there.
Yes.
Okay, thank you. Let me get there myself. I'm looking at page 66, carrying over to page 68, where Mr. Spurgeon addresses certain operating characteristics and planned retirement dates for some of the for the existing PNM owned gas-fired resources that are assumed in PNM's modeling in this case. Did you review that before you filed your rebuttal testimony?
I tried very hard to read Mr. Spurgeon's testimony. I struggled at times. I'm not sure if I verified those specific dates with ours, but I did read it.
And in your rebuttal testimony, you didn't rebut any of Mr. Spurgeon's testimony there, did you?
I did not. I don't believe I've referenced that in my rebuttal testimony.
And then specifically page 67, where Mr. Spurgeon reports the capital additions that PNM has made for its ownership interest in each of the existing PNM-owned gas plants during calendar years 2018, 2019, and 2020 to keep those plants running. You reviewed that before you filed your rebuttal?
I read his testimony before I filed my rebuttal. I'm going to assume he lifted that from a discovery request. I don't have specific reference to it, but
well, he referenced it in his testimony, didn't he?
He does reference a discovery request. I don't believe I would have sponsored that discovery request. That would have been sponsored by our financial department. So I would not have verified those numbers.
And your rebuttal testimony doesn't dispute any of those, that information, correct?
My rebuttal does not address that particular section of his testimony.
And then
I would like to opine on that, though. I can. He suggests there that these are additional costs that would be added on top. I think that's really that's not a great representation of what we do in a dispatch model. Is those costs that are recorded there are really overhaul costs, and so they're variable maintenance costs. Those variable maintenance costs are rolled into what we call a dispatch order perspective. And so those costs are already factored in how we operate the units. And again, all of those units would operate before Valencia with those variable maintenance costs already included and factored into the equation.
Well, I'm talking about the capital additions for PNM's own gas plants. You understand that?
That's exactly what happens is we roll those, we break those down on a per megawatt hour basis because those costs are either on a start basis or an hourly fired basis. We break those down. We factor that incremental variable O&M or in general in a model. So I'm talking about capital expenditures, but you break that down on a per megawatt hour basis, whether it's O&M or capital. That goes into our dispatching model. Our dispatching model then selects the lowest resource including those capital expenditures to overhaul the turbine, and picks the lowest dispatch resource, and Valencia loses every time.
Okay, and those capital additions, which occurred since P&M's last general rate case was decided, those P&M has not yet decided whether or not to seek to recover those capital costs in its, and that will do that in its next general rate case. Is that correct?
Again, you'd need better talk to the finance witness, but generally that would be my understanding. But again, what we do on the dispatch is those are factored in and we optimize that for the low cost for the customer. So it is factored into our optimization of low cost supply for customers.
And it's correct that you don't dispute Mr. Spurgeon's testimony at page 66 of his direct testimony, that P&M's modeling for its replacement analysis in this case assumes that P&M will continue to operate its own 146 megawatt share of its gas-fired Reeves resource, which commenced service in the 1959 to 1962 time period until the end of 2030.
Better to ask Mr. Phillips that, but I have nothing to refute. I'm not aware of anything that that was an assumption. I believe that's the depreciation schedule that we're on that has been reviewed and approved by the commission.
And do you know that in fact that P&M's 2020 IRP actually indicates that that plant is going to remain in operation until its retirement at the end of 2030?
A better question to ask of Mr. Phillips.
Okay. But you do know, as in your position as head of generation for P&M, that P&M's existing owned Reeves resource is a steam combustion turbine that's used by P&M as a peaking resource, and that it was put into service in the 1959 to 1962 time period, correct?
I believe those numbers are correct. I wasn't around at that time period. I wasn't even born. So, but yes, I believe that to be correct.
Well, I am sorry to admit that I was born. Okay. And the information on page 67, you didn't dispute the information on page 67 of Mr. Spurgeon's direct that P&M made a total of a little over $14 million in additional capital expenditures on that Reeves resource in the years 2018 through 2020 to keep them running.
I'd have to do the math on those, but 14 appears close to, I'm not sure it's over under, but 14 in that time period appears to be accurate. Again, those costs are modeled into the dispatch. And again, Reeves does come ahead of Valencia in the batting order, considering all those factors.
Do you have any understanding of whether P&M's application in the companion case, the 21-000-83 UT case, prior to the bifurcation into this case, whether or not P&M's application is requesting commission approval of a regulatory asset that would allow P&M to recover its share of past capital additions associated with its Palo Verde leased interest?
Mr. Hearing Examiner,
Yeah.
I'll Leslie Padilla, P&M, I'll object. That is not subject of the case that we're here for today.
So I think that's a relevant objection, Mr. Throne.
Yeah, I'm just trying to tie this into the testimony about these capital additions for existing plants, about how P&M goes about seeking commission approval for recovery of capital additions in between rate cases.
Okay, so maybe it's a general comment about capital expenses for resources, not so much related to the specific issues to the regulatory asset is what you're really asking ultimately, right?
Yes.
Yeah, I mean, that's permissible. So go ahead.
Can we re-ask the question I'm going to answer? Sorry.
Is it your understanding that PNM's application in the companion case number 21-00083, prior to bifurcation of this case, that PNM is requesting commission approval of a regulatory asset that would allow PNM to recover its share of past capital additions associated with its Palo Verde leased interest?
My understanding and better reference to the financial witnesses are Lisa Eden in the next case, but my understanding is PNM is seeking recovery or a regulatory asset for the undepreciated investments in Palo Verde.
And undepreciated investments in a resource would include any capital additions that are booked in between rate cases that have not yet been recovered through rates, correct?
I believe I can agree with that characterization.
Okay. Would you agree with it that when comparing the cost of different resources, to the extent PNM procures a resource that is structured as a power purchase agreement approved by the commission, the cost of that resource is fixed by the terms of that power purchase agreement for its duration?
Well, if we look at the Valencia PPA, those costs are not fixed, they escalate. I'm not sure I would agree with that characterization.
Well, let me ask it differently. If Onward or Valencia, which is the operating entity, Valencia Power, if they were to need to put in $10 million in capital expenditures to keep that plant running between now and the end of the existing PPA, which expires in May of 2028, there's nothing in the existing Valencia PPA that would allow the owners of that plant to recover those additional capital costs, correct? They take the risk on any necessary capital additions.
I'm not sure I agree with that characterization either. If you look at the variable maintenance costs that we pay on Valencia and the fixed maintenance costs, I think there's more than ample provisions in the existing contract to more than cover for any expenditures and more that would occur over that time period. Again, even to bring that closer to reality is when we attempted to bring Valencia into the EIM market, we got feedback from CalISO that the fixed and variable maintenance costs were not supportable because they were too high, and we were not allowed to bring those into the EIM calculation on a contract basis. So I think there is more than ample opportunity in the Valencia contract for any expenditures that would occur there, and little risk to Onward for any potential exposure.
Now, the response you just made refers to the existing Valencia PPA, correct?
I think would have to, I think there's existing cost. Let me give me a second.
I mean, you're not referring to any of the proposed PPA extensions when you talk about your analysis with respect to the energy imbalance market, correct?
I still think we'll have to look at how much, where we haven't had the review with CalISO, whether those would be allowed. We do know the existing ones would not be allowed.
Okay, that was my point. My point is you're talking about existing, not a proposal.
Well, and I can't, I'm going to guess that based on the change, which wasn't substantial in that category, I don't believe that we would have issues as well.
Move to strike non-responsive and pure speculation by the witness. Mr.
Yeah, I don't know. I kind of lost the track of the discussion there, Mr. Throne, to be honest. If you want to re-ask your question and see if you can get the answer, well.
Well,
not sure
I'm
that-
moving to
that-
strike because now you're as using Mr. Falgren's own words, he's guessing about something in the future that not only was not responsive, but it's pure speculation. And it's just inappropriate. I mean, I understand witnesses have a right to explain an answer, but what's happening here is it's going way beyond that.
Mr. Hearing Examiner,
Yeah, Ms.
Um,
Padilla.
you know, the subject matter that Mr. Throne is asking about is a little confusing. We've got two different IRPs. We've got, and there's that confusion too, the acronym IRP, RFP. There's two RFPs at issue. There's an existing PPA that Southwest Gen has with PNM. There's a, future, the changes to the Valencia plant that's been offered after 2028. So I think some allowance for Mr. Falgren to answer these questions in the way he's doing should be allowed. I mean, this isn't simple or straightforward.
No, and I mean, the other problem is it's combative too. So, I mean, there's that layer of it there, and that's not a judgment. It's just, Mr. Falgren's response at times has been, raising to the challenges that you're giving him, Mr. Throne. So, I mean, I'm not going to strike it. You don't have to worry about, I mean, if you have a position later in briefing to discuss how it's an incorrect answer in some way, you have the opportunity to do that.
Okay, thank you. Mr. Falgren, let's turn to your rebuttal of page 10, lines 9 to 11.
I'm there.
And there you say that due to its higher cost and other limitation, Valencia is operated on the PNM system more as a, quote, break the glass, close quote, type of resource that is used sparingly. Is that correct?
That's my statement.
And there you're talking about how the Valencia facility currently operates under the existing Valencia PPA, correct?
Partially, and an extension as well, because a lot of that limitation is associated with the Title V permit, which does not change in post 2028.
Now I'm familiar with two different break the glass metaphors, Mr. Falgren. One of them has to do with what happens between a bride and a groom at a Jewish wedding, but I assume you're not referring to that. I assume you're referring to those old, when I was a kid, there was schools and they had a thing on the wall. It's an emergency, break the glass. I guess it's where they pull for the fire alarm. Is that what you're referring to there with that metaphor?
The latter would be the more appropriate. And what I'm referring to there is we use Valencia as a very last case resource.
And you're referring there to how PNM has dispatched Valencia in the recent past, as in the last couple of years?
Yes.
Okay. But that isn't how PNM described the Valencia facility and the Valencia PPA in the 2020 IRP that it filed with the commission 2 months before it filed its application in this case, is it?
Could you refer me to a specific section?
Yeah. Let's go to Mr. Phillips. To get to Mr. Phillips, the right exhibit here. Okay, we're in his June. So this is PNM Exhibit 8. And we're in his June 14th supplemental testimony. And it's the reference here is to PNM Exhibit NLP-1 at page 135 of that exhibit. Tell me when you get there, please. I'm sorry, I said, yeah, 100. That's right, 135 of that exhibit. Actually, it's page 125 of the IRP, but that should get you there. Tell me when you're there.
All right. I think
Okay.
I'm in the right spot.
And looking at under the section title, P&M's Northern Load Center, you see that?
Yes, I do.
Please read into the record the last sentence in that paragraph, beginning with the word accordingly and ending with the word outages.
Says accordingly, despite the low capacity factors of load side resources, Reeves Generating Station, Rio Bravo, and Valencia PPA provide crucial capacity to ensure reliability both during peak demand periods and in the event of transmission outages.
And now if you would move to page 187 of that exhibit.
What's the page in the IRP, if you would, please?
It should be 177 of the IRP.
Very well.
I'm trying to get there too. Your computer is faster than mine. All right, and there, let's see. And they're looking under where, see where you, the subject heading says Valencia and Reeves replacement 2028, 2031.
Yes, sir.
So that's where you indicate that as part of P&M's 2020 integrated resource plan, the plan is to replace both Valencia and Reeves during that time period, right?
I believe that's what the first sentence says.
And
Yeah, and let me correct that. I think what it says is that the PPA expires in 2028, and then we plan to retire Reeves in 2030. So we should let the language speak for itself.
okay,
We've never contended that we wouldn't look at Valencia for an extension in 2028 when it's more appropriate looked at in comparison to competitive resources at the appropriate time.
but anyway, would you agree with me that that's in that section is that's another section where you where P&M describes the role of the existing Valencia facility under the existing PPA.
Mr. Hingsamer,
Yes.
I would object to this line of questioning, just that it's unnecessary. Just asking our witness to read testimony into the record isn't very, efficient use of our time. And this is in the record. It's an exhibit to Mr. Billups' testimony. So Mr. Throne can cite this if he needs to in his briefing.
Well, I mean,
If there's a question.
Okay, to the extent to which there's questions coming in, and it's a relevance question, I mean, it seems to me it's self-evident. There's some discussion about the Valencia facility and how it's utilized in P&M system. Mr. Throne's, his time for cross-examination. It's seems on point to me. And if he wants to ask the witness to read stuff, it's not, that's his choice to how to use his time.
No, I already asked the question about to Mr. Falgren about that. Wasn't how P&M described the role of the Valencia facility and the IRP, and I will move on now. I've already made that point. Mr. Falgren, do you recall after reading Mr. Spurgeon's direct testimony that as he addressed case number 08-00305 UT, where the commission approved the existing Valencia PPA, where P&M's witness Cynthia Bothwell testified that one of the benefits of the Valencia facility was that its, quote, direct interconnection with the interstate pipeline avoids the payment of additional charges for local distribution that are included in natural gas delivery to P&M's Reeves and Delta resources, thus lowering fuel costs, close quote. Do you recall that he cited that?
I recall he cited that. I will also recall that that testimony was 13 years ago, and a lot of things have changed in those 13 years.
I understand. Is it correct that that distinction between the way gas is supplied to the Valencia facility as distinguished from the way gas is supplied to PNM's Reeves and Delta gas plants is still accurate today?
Again, what we do, I'm going to say generally, but specifically when we look at dispatch, again, we do factor in the gas costs, which includes the transmission cost. We factor all of those again, like the capital costs we had before. We factor all that into a dispatching cost, and Valencia is at the bottom of the batting order every time, including the gas resources as well.
And the PNM owned Reeves gas plant is much older than the Valencia heavy frame gas plant, correct?
I think we reviewed the dates already, so I'll let that stand as is.
You're refusing to answer the question?
You're re-asking the same question. So you asked me about the dates for the Reeves station. We answered that. You asked me about the dates for Valencia. The dates are there. Yes, Reeves is older than Valencia.
So given the way the different facilities are supplied by gas, for example, if New Mexico Gas Company's prices for gas supply go up to the extent PNM dispatches its Reeves units, the supply cost for that plant will increase, correct?
Cause for speculation, what I go back to is we factor in all the gas prices, including transmission costs. And today, the Valencia plant is behind all other gas plants.
Now you're talking about modeling, correct?
I'm talking about actual dispatch. That's modeled. That's included in our dispatch protocol that we have. We include the transmission gas. We include the gas. All those provisions are loaded into the dispatch. We run a batting order. Valencia ends up at the bottom.
Now it's correct that the PNM's Reeves plant doesn't currently have quick start capability, does it?
Again, we've gone over quick start. I think it's an antiquated term. Valencia has, I think it's about a 20+ minute startup time.
I asked you about Reeves, sir. I didn't ask you about Valencia.
I said Reeves. I'm sorry if I misstated it. Reeves has about a 20-some minute. It does have what we would call a fast start. They've made some provisions there for a fast start on a steam unit. I'm not exactly specific what the startup time is, but I thought it was on the order of 20-some minutes or so.
And PNM's owned Rio Bravo resource, formerly known as the Delta plant, that's a GE 7F heavy frame combustion turbine that went into service in 2000, correct?
I believe that's correct, yes.
Mr. Throne, is it possible, sir, if we can take a short break? We've been going now for a while. It's about 3:20. I was thinking we could just take a 10-minute break just to give everyone, and unless
You're the
there's
boss.
some, is that okay?
Oh, certainly.
Okay, so let's just take a quick 10-minute break. Everybody can collect themselves, and then we will come back and go for our last stretch until 5.
Oh, okay.
Everybody there? Folks, I think that are essential are here. I believe, I'm sure the other folks who we don't see are probably listening. But I'm just attendant to the time. Mr. Throne, you have, I'm not gonna go back, just start, this isn't on the record yet, Ms. Gonzalez.
Okay.
So we've got Mr. Throne, hour and 19 left. We're at 3:24 now. That puts us at, do you think you'll use that full hour and 19, Mr. Throne?
I hope not. We'll see how,
Yeah, how it goes.
the old saw, it depends on how long the answers are.
Sure. So, but anyway, I'm just trying to time manage here. That puts us at 4:40. I definitely have some questions for Mr. Falgren myself. There is additional time requested by county and the Attorney General, 15 minutes. So we're definitely behind schedule. We'll just move forward. I did look at the testimony of Mr. Sanders and Settlage. I won't need them, but I'm gonna deal with that after we finish with Mr. Falgren, if that's okay.
Yes, thank you, Mr. Hearing.
Do that on the record. I did look at Mrs. Crane stuff, Dr. Crane stuff. I would ask her to appear. And the reason I'm gonna do that, I don't see Mr. Gedko. She represents the public interest in this case, obviously, through the Attorney General's office, and I would have liked for her to appear. So let's start back up. Mr. Throne, you all set?
Yes, sir. Thank you.
Ms. Gonzalez, let's go back on the record.
Very good.
Go ahead, Mr. Throne.
Thank you, Mr. Hearing Examiner. Mr. Falgren, I have a couple of questions about your testimony and your rebuttal on page 9. If you're there.
Yes, sir.
And there you state that P&M called on or dispatched the Valencia facility for approximately 72,000 megawatt hours in 2020, correct?
Yes, sir.
And when P&M dispatches its gas-fired peaking resources, it does so based on what it refers to as its economic dispatch criteria. Isn't that correct?
I'm not sure I agree completely with that characterization. Generally, yes, but there are a number of provisions which provide otherwise.
Well, generally speaking, isn't it true that P&M has described in many cases prior to this for the commission that it's under its general economic dispatch criteria, it dispatches its lowest cost resources before dispatching its higher cost resources, including its import capability when they're needed. Is that a fair description?
I would say the caveat to that is we dispatch on reliability is the main criteria. And within the reliability provisions of what we need to serve customers is we do that in an economic manner. Again, with giving transmission constraints, variability constraints on different plants, those type of things. So reliability is first. Within that reliability criteria, it's an economic dispatch.
So explain that, if you would, for me. If you have several resources that are available to you, and one is more higher, costs more on an output basis than the other, how would you not do the lower cost one based on reliability? Give me just an example of how that might work.
I'll give you two examples. The first one, as we already read in there, is there are load side resources. So again, if you look at the transmission system, there's electrons that are actually moving, if you would. There's firm capacity, but again, you have to do an instantaneous look at that, where the electrons are flowing. If you've got too much flow that's going one direction, you'll have to run load side resources. They're within the load pocket that provide so we don't overload those transmission lines. That's example number one. Example number two, I would use particularly for Valencia. Let's say Valencia has start limitations. And let's say that we needed to start Valencia at 6 o'clock at night. The fact that once we use it, it's used up and we can't call in another start. We may look at the reliability needs for the next morning, and we may conclude that in order not to lock Valencia out, is we would have to uneconomically run it throughout the night, so that it would be available in the morning because it has limitations on starts. So those are two examples of where we may have to operate in the interest of reliability over economics.
So to be clear, and first, when you say load side resources, so Valencia is one of your resources that's in your northern New Mexico load pocket, correct?
We read that in the IRP, so yes.
And then when you're talking about this other limitation, you're not talking about reliability, but you're talking about what you believe to be environmental permit, environmental department permit emission limitations, correct?
I'm saying it's a limit. It's a permit limitation that if I run Valencia, I am not allowed to, and I shut it off like I should. Like if I compare that against an LM6000, what I'd normally do is I'd run an LM6000 for maybe 20 minutes and solve that particular issue, shut it off, because instantly I can restart that LM6000. What I can't do on Valencia is I got to wait. I've got to wait a whole for 8 hours, or if I ran it twice, I got to wait a whole 24 hours. And so if I have if I have concerns about reliability the next day, oftentimes, excuse me, we will leave Valencia online in an uneconomic condition because of those limitations, because I have concerns with reliability events the next day.
But I think you've already indicated, though, in terms of your replacement analysis in this case, you never modeled that. Those are just your observations about what you think the permit is, but you didn't model that in terms of potential combination of resources to meet PNM's needs in its replacement analysis. Is that correct?
I'm sorry, you're going to have to.
You didn't model those permit limitations in terms of Valencia in PNM's replacement analysis in this case.
I think the limitations that are on Valencia are included in the model, but that's a better question for Mr. Phillips.
But we've already established that you didn't model any combination of resources that included any of the Valencia PPA extensions, correct?
Well, you said that the permit limits, the ability that for Valencia to provide resources that are limited by the permit limits as an existing resource. So Valencia was included in the model as an existing resource, and the limitations that are in Valencia would have been included in that model. We've already established, I think, that we didn't model, other than in discovery for you, the extension, the non-competitive extension that you're suggesting.
Yes, I understand that you can model permit limitations regarding a specific resource like Valencia, but I'm just trying to make it clear in the record that even with those limitations, as they might apply to the any of the Southwest Generation PPA extension proposal, that with those limitations, they were never modeled by PNM for its replacement analysis in this case, correct?
That was a long question, so what I'm answering is, yes, we already went over, I think, that we did not model the extension proposal, the non-conforming bid. We did not model that. If that's your question, that's the answer.
Do you recall that PNM's 2020 IRP includes information showing what percentage of PNM's total power generation in megawatt hours was provided by each of its generation resources in 2019?
You'll have to show me.
Okay, let's go to, if you would, this is again, Mr. Phillips, June 14th supplemental testimony. So it's the IRP, and it's going to be, you'll find this at, it's page 71 of the exhibit. It's the NLP, I believe it's page 61 of the IRP, table 8, and it appears on page 71 of NLP PNM exhibit NLP-1 June 14th supplemental.
I'm there. Table 8, right?
Okay. And so, and that shows, does it not, that at least for the calendar year 2019, the annual generation from the Valencia facility in its current operating configuration, that is without quick start capacity that was offered, relied on by PNM to meet its needs was greater than the annual generation PNM relied on from its aeroderivative combustion turbine resources at its La Luz energy facility and the Lordsburg generating station. That is in terms of annual net megawatt hours and percentage of share of total generation.
I think that's an inappropriate characterization of that. Those plants are much smaller than the Valencia plant. And again, as we talked about, there are other limitations. I think the better comparison, if you're going to go to the other 7 FAs on the chart, is the better comparison.
Isn't it correct that
you got 160 megawatt unit versus a 40 megawatt unit as your comparison?
isn't it correct that the La Luz is a aeroderivative LM6000 facility?
La Luz is an LM6000, yes.
And isn't that true? Isn't Lordsburg also LM6000s?
Lordsburg is LM6000s as well.
And those are both peaking resources, correct?
Again, peaking is an antiquated term, but they're run briefly. Those LM6000s that I described earlier are run very intermittently. Most times they're run less than 15, 20 minutes, and they'll address a specific variable resource disruption in the system, and we'll shut them off, and they may restart a half hour later. They may restart 5-6 times a day. But they do operate at a very minimal time if you're looking at it, particularly on a megawatt hour basis, but they do provide extreme flexibility to meet the variable resources.
And it's true, is it not, that all of PNM's, well, getting back to the characterization of peaking, I mean, it's true, is it not, in the PNM's 2020 IRP, in its description of its various existing resources, it describes the duty cycle, those are your PNM's words, of each plant, and they describe the duty cycle of not only Valencia, but also Lordsburg and La Luz as peaking, correct?
Could be. You'd have to show me that in particular.
Well, it's there. I'll just move on because I don't have the time to point out your PNM's own evidence. Now, at the time this data was reported about how much each of these plants share was of total generation in 2019. Now, that time period was before PNM's addition of any of the solar and battery storage resources that were approved by the commission to replace PNM's remaining interest in the San Juan generating station in 2022, correct?
If you're asking me the replacement resource, the replacement resources in San Juan would come on line in 2022. This chart shows that 2019. I believe if that's your question, then yes, that would be my answer.
Okay, and during that 2019 time period, PNM's net system peak demand was lower than the net system peak demand that PNM is forecasting for 2022 and subsequent years in its 2020 IRP, correct?
Again, that's a better question for Mr. Phillips. If you show me the data, I can confirm or deny it, but
Well, to save time in the hearing, I'll just refer the hearing examiner to the IRP. This is P and M exhibit NLP-2, 614, that's June 14 supplemental at page 209, and I'll move on. Is it correct that during that 2019 time period that this table addresses, P and M had available to it both 497 megawatts of capacity from the San Juan Generating Station and 114 megawatts of capacity from the Palo Verde lease interest?
I believe the answer to that's correct.
And I believe it's correct that, well, tell me if it's correct. As you testify here today, you can't tell the commission, can you, how often P&M would need to dispatch the Valencia facility between 2023 and 2039, consistent with economic dispatch principles, assuming that facility was configured with fast start capability?
Again, the modeling that we've seen from Mr. Phillips, he can explain that in more detail. We don't anticipate, that provides substantially no benefit to customers. I don't anticipate a significant change, I guess, but.
That wasn't my question. My question was, as you sit here today, you can't tell the commission how often P&M would need to dispatch the Valencia facility between 2023 and 2039, assuming that facility is configured by June 1st of 2023 with fast start capability. And the lower mid.
I'm not the resource model. That's a better question to ask to Mr. Phillips.
Okay, so you can't answer that question.
I'm not the resource modeler.
Let's go to page 10, line 11 of your rebuttal, please. Let's see. And where you say that you use the word sparingly there, type of resource that is used very sparingly. You see that?
I do, yes.
Is it correct that if P&M proceeds with a technology neutral resource analysis approach in its future supply side resource acquisition cases to determine whether that approach would be less costly for P&M and its customers, P&M would expect to use any additional LM6000 aeroderivative capacity fueled by natural gas that it proposes sparingly, to use your words?
It was quite a
Senator, objection. I think the questions are getting fairly far afield from what Onward's position in this case is. And I know Mr. Spurgeon, so I don't think this is relevant. Mr. Spurgeon makes recommendations on, modeling and modeling assumptions going forward. But I don't understand where Mr. Throne is going with these questions. It seems to be very specifically about the Valencia plant post 2023. And that the Valencia, that is not that resource is not the subject of the request PNM is making in this case.
Well, let me just say before you answer, Mr. Throne, that I, like Mr. Falgren, did not understand the question. So I'm at that disability, but go ahead and respond as to what the purpose of this line of questioning is.
Well, Mr. Falgren's rebuttal testimony, for lack of a better word, sort of disparages the Valencia facility as one that would be used, that is used sparingly. And what I'm trying to establish whether or not, in fact, as P&M has represented in the 19195 UT case, that to the extent that, as is shown by their technology neutral portfolio that Mr. Phillips presents in his direct testimony, that if P&M was to require new gas using that new LM 6000 aeroderivative combustion turbine technology, that resource would also be used sparingly. In other words, trying to establish that that word sparingly really doesn't provide much helpful information to the commission about the value or role of a resource when it comes to the flexibility and its ability to satisfy the flexibility needs of the company going forward.
And I understand that point. I see how that fits consistent with your positions. I suppose my request would be to try to keep the question simpler, if not for Mr. Falgren, then for myself.
Certainly, I'll do my best. I know I try to be very technically correct because I know in the past when I haven't been, the witnesses have liked to correct me. So we're playing a little bit of a game here. I guess that's my question. If you to the extent, isn't it correct? And I think you were involved in the 19195 UT case that where P&M said, gee, we proposed 6 or 7 in its preferred, I think it was 7 LM 6000s in its preferred scenario 1, and it said, well, if we get this, we're going to use this, in a very well, I don't think the word sparingly was, but I think you may recall that Mr. Falgren, that it was said that the capacity factors of those plants would be declining and going forward, and they would be used very little to simply provide the flexibility that P&M needs when they have sudden loss of load due to intermittent resources. Is that generally an accurate statement?
I don't think I agree with that completely. What I would say, we would contend that all gas units and all, particularly LM 6000s, would have a low capacity factor. I would not correlate that to use sparingly. As I gave in my previous example, is we do call on our LM 6000s on a very frequent basis, maybe multiple times each day, in which they are solving a very short-term issue associated with our variable energy resources. And so that flexibility to start multiple times a day and to be at a 40 megawatt start and even run down to 20 megawatts, have 20-minute increments that you can put on and off in very short time periods and do it multiple times a day, that I would not call that using that sparingly. We use them very frequently. But if you look at strictly at a capacity value, then yes, there's a low capacity value because again, we're starting and stopping them very frequently. The Valencia plant, again, if I'm sitting in the operator chair next to the operator, what he would tell me is give me many more LM 6000s, but don't give me Valencia. Because of the limitations that are on Valencia, both the size limitations and then also the start limitations.
I believe in response, and we asked you some discovery about capacity factors of all of the existing P&M gas resources, including Valencia. And as I understand it, P&M's response was they did provide capacity factors, but not for Valencia, saying that only Valencia as the operator could provide that information. Is that accurate?
Again, when we have GADS data, Valencia plant operators enter the information into GADS. You keep the information in GADS associated with Valencia. Every time we have an information request from Onward or anybody, we have to call up Onward. We have to call up Valencia and ask for that information. So we could provide it, but we'd have to call you and ask you to then provide that in discovery. So it seems like you have that. I mean, it doesn't seem sense that I have to call you, ask for that, and then turn around and give it to you.
Okay, so that was your P&M's response was we don't, you have that information, we don't have it, correct?
We wanted to get the latest and best information that's in GADS, so we would have had to call you to get it. So it's best that you just collected it yourself.
And GADS is what? I'm sorry, could you explain that?
Oh, sorry. Generation Available Data System. It's it's a recording system from NERC that we talked about before,
Yep.
where all facilities enter certain information in, and we record capacity factors, operating hours, forced outages, all of those things into a system. Then NERC kind of collects that. A lot of times NERC will take that generally idea from, you know, what kind of technologies are having certain outages or capacity factors and kind of use that information. But it's a requirement we all report into NERC through their system, their reporting system, which is called, again, I think it's a generation availability data system, if I'm not mistaken, and GADS.
Thank you very much, Mr. Fulton.
Yeah.
Turning to your page 8, lines 14 to 17 of your rebuttal, Mr. Falgren. You testify there that any proposal to extend the existing Valencia PPA with quick start capability and lower minimum load requirements, such as that proposed by Southwest Generation in response to PNM's 2020 RFP, is best evaluated, quote, at a time closer to when the existing Valencia PPA will expire in May of 2028, correct?
I'm not sure I followed you reading all of that, but I believe if we just focus on the last part of that, where I said that we should evaluate that closer to the PPA expiration, then I agree with that, yes.
And that would be approximately when, in your opinion?
Again, when we're doing evaluation of bids in 2028, compare it so we can justly compare it against other alternatives that will be available in 2028. It's not appropriate to just evaluate it without alternatives to review. And again, I believe if we look at recent commission direction to PNM, they would provide us direction that resource extensions are more appropriately evaluated closer to the time when those extensions would occur. So
you referring to some specific commission order?
I think if you look at the Palo Verde lease extensions, and if you look at the 2016 rate case from what that those are some of the feedbacks that I read just reading the final order.
Well, were you listening in to Mr. Fenton's testimony when he was examined?
Most of it, not all of it.
And but you're aware he testified about policy guidance from the commission in two cases, one including the El Paso Natural Gas CCN case where they asked for approval of a new gas resource.
I vaguely remember the conversation. I mean, I remember part of the conversation. Again, I was in and out, so
okay,
you'll have to be more specific.
Well, are you familiar with what the commission decided in that case regarding PNM's proposal for new gas supplies, a new gas resource rather?
Are you talking about 19195?
No, El Paso natural gas case.
Well, then that wasn't a PNM case. So, but
okay, if you don't know, that's fine. I'll move on. Do you recall generally in the 19195 UT case that PNM provided direct and rebuttal testimony by Dr. Gary Doris addressing his company Ascend's Power Sim analysis of PNM's system flexibility and ramping needs to comply with the Energy Transition Act's 2045 zero carbon standard?
I'm generally familiar with Dr. Dorman's participation in the 195 case.
Okay, and
I don't have it in front of me, nor I have read it lately, but
okay, and it's been admitted, so we'll let that testimony speak for itself. But I just want to find out generally if you recall any of this. Well, it's correct, is it not, that PNM did not ask Ascend or any other contractor to perform or provide any similar Power Sim reliability analysis to support its replacement analysis in this case?
I'm not sure I agree with that characterization. If you'd let me explain, then I could, if you would. So if we go back to 19195, there's some fundamental differences here than there, and I think it's important to talk about them. So again, if you look at 195, that was the transition. That's the first time we used Encompass as the expansion model for PNM. We had previously used Strategist. A couple of things we're looking at in that is just making sure that we confirmed, with multiple model inputs, actually, 3 different model inputs, that what Compass was telling us was validated. So a number of that testimony in the 195 was really kind of validation of the Encompass model. And we showed very close accommodations for that. And we did use SurvM in that case, again, to do modeling. We also use SurvM, again, kind of as that calibration to validate the Encompass model. We use SurvM for calculating a net present value in that case, again, to compare that against the Encompass model. So when we did that, we did run multiple year runs for SurvM, but that was only specifically to run the NPV calculations in that case. It was not to justify the reliability of the replacement cases as we're doing here. If you look at what we did, what we asked Mr. Dorman to do is we just brought him in kind of a completely independent review and told him to review the ProSim model. We didn't provide him a lot of direction. We just said, here's what we see. You run your own model, again, as a confirmation of that Encompass model. So we did use Dr. Dorman in that. We did use 3 different models. Again, it's not appropriate to use that going forward. We did that calibration. We do use SurvM in this case, but we don't use SurvM in this case for NPV calculations because we have established that Encompass is the right place and the appropriate tool to use for net present value. So it's appropriate, and we still stand by the fact that you need to use SurvM in this case for verifying the reliability in the year that we make the technology change, but we don't have to use it in multiple years because we're not trying to pull out the NPV calculations from SurvM.
Okay.
So yes, we did use Dr. Dorman in case 195.
Just 1 second, Mr. Thron, real quickly, hold on. So you said Mr. Falgren several times, Dormand, and I just want to confirm that you're referring to Gary Doris. Is that correct?
Doris, yeah, sorry.
No, that's okay. I just want the record to be clear who you're referring to. Go ahead,
Gary
Mr.
Doris.
Thron.
Yes, sorry.
That was the first part of this I was going to try to clear up. Now, well, as long as you've gotten into all that, then you'll recall, will you not, that in fact, PNM relied in that case on different net present value calculations for over the 20-year modeling period using Encompass, SurvM, and PowerSim, correct?
We used, you'd have to check with Mr. Phillips if we used PowerSim. We did do an NPV calculations on SurvM I'm familiar with. We did do a calculations on NPV with Encompass, again, to correlate the 2 models.
Yes, and I believe it is reflected in the testimony in that case that's been previously admitted. Now, also, you recall that in that case, there was testimony by, in fact, Mr. Phillips, that capacity sufficiency modeling, that is to say, to meet the planning reserve margin that was the target for PNM's modeling, was not sufficient anymore to really provide the PNM and the commission with the information it needed regarding reliable service, because reliability you needed to also deal with the flexibility of the resources that would be needed when you had sudden fluctuations in output from intermittent resources like solar and wind, correct?
I believe what we said in case 19195 is Encompass, which we would characterize as a deterministic model. It's an expansion planning model. We still need to verify through a sub-hourly risk analysis, which is what we do in SurvM, which is a statistics model, probabilistic model, if you would, the 5-minute or sub-hour reliability verifications. So I'm not sure I agree with the whole characterization there. We have recognized, and then what we do is Encompass is the right expansion model that we use. And then we kind of do an iterative process where we verify that and SurvM, bring that reliability, a sub-hourly reliability component back. That's what we did in 19195, and that's exactly what we did in this case as well.
Well, in that case, 195 UT case, you provided and asked the commission to rely on distinct flexibility metrics using SurvM and PowerSim for the 4 different scenarios and 2 additional no gas scenarios that were presented in P&M's direct testimony, correct?
We did include those in our testimony in that case. That is also provided in discovery in this case. So again, that flexibility, that reliability metric is in discovery in this case.
Well, the discovery in this case, unless it's in testimony, is not going to be in the record. Isn't that correct?
Because I think the feedback we got, the better question for Mr. Phillip, but I think the question we got from the feedback we felt we got from the commission was, it's your job to verify reliability. We want to just look at the other provisions. So the better question for maybe Mr. Phillips or Mr. Wintermantle, but again, that analysis is there. It is performed. It is part of the SurvM output. It is what was verified. I mean, essentially, it's the same thing was performed. The same thing was done.
And isn't it correct that, and will you recall that in his rebuttal testimony, particularly to CCA's witness in the 195 UT case, where CCA's witness had questioned whether or not the flexibility metrics using SurvM and PowerSim were something that should be relied on, Mr. Phillips, I'm sorry, Mr. Wintermantle actually was the one who said, this is a valuable and necessary information because it allows the commission to compare different portfolios in terms of their reliability as well as their economics.
That's a level of detail I'm not familiar with. It's a better answer for Mr. Wintermantle, I guess, when he's on the stand.
Okay, and his rebuttal is already in there in the record. And then is it correct, and do you recall that when P&M presented its direct case in that 195 UT case, it presented not just one proposed scenario, well, it had one preferred scenario, but it presented 3 different resource scenarios for which it provided modeling and the results of its modeling using PowerSim, SurvM, and Encompass.
I believe there was 4 scenarios presented in the 195 case.
Right, and 2 additional no gas scenarios presented by Mr. Doris, correct?
Sounds accurate. I'd have subject to check.
Okay, and in this case, as I understand it, P&M proposed only one scenario, and that is the replacement scenario for which that is described, the no new combustion scenario described in Mr. Phillips' testimony, correct?
There's a preferred scenario proposed in here. I think we offered the other scenario for comparison, which was a technology neutral scenario for comparison of the commission.
Right, and that you're getting to the point I was trying to make, that in Discovery you indicated that scenario was simply for illustrative purposes, but was not being proposed by P&M in this case, correct?
The 3 scenarios that we presented in 195 were for illustrative purposes as well. They were not proposed, but P&M had a preferred scenario in 195 as well. So I'm not sure of the point of your question.
Well, I'm just trying to get to the the point of the question, and this goes to Mr. Spurgeon's recommendations, is in a resource procurement case, if P&M only proposes one scenario and models only one scenario in its direct testimony, basically that leaves it up to staff or your interveners. If they want to look at any other scenario, they have to basically go hire an expert and either do their own modeling or ask P&M to model an alternative scenario, correct?
Again, I think I'm not sure I'd agree with your characterization. I mean, you certainly have, all the stakeholders certainly have the ability to provide their opinion or input into the inputs and outputs of the scenario. We've provided opportunity to run reasonable scenarios in this case, like we have in previous cases. So I guess I'm not sure I appreciate your distinction or your issue of the moment.
Let me ask you if you recall that in the 19195 UT case, P&M estimated that it would need 374 megawatts of 15-minute ramping capability by 2025 to meet its system flexibility needs and satisfy the Energy Transition Act's 2045 zero carbon standard.
I don't remember that specific. That's a better question for Mr. Phillips.
Okay, I'll just refer the hearing examiner to, on that point, to Onward Exhibit 3, Mr. Doris's direct, page 21 of that testimony. You didn't disagree with any of Mr. Doris's testimony in the 195 UT case, did you?
That's a pretty general statement, so I can't respond to that.
Now, let me just go look again at your rebuttal, page 7, line 5 to 11. Don't think I covered this. Want to make sure. Let's see. Maybe I did. No, I did cover that. Strike that. How much time do I have left? With
You have 39 minutes.
Okay, what I'd like to do is conclude my examination now based on Mr. Falgren's answers and referrals to other witnesses and reallocate that time to my next witness. I guess that would be go down to Mr. Nagel next. I don't think I'm going to need all that time with Mr. Nagel, but I'm just, again, I want to, this is the reallocation just so I'd have enough time to cover the subject matter with all of the witnesses, depending on their answers.
And is there any objection to reallocating that time? I mean, it puts that at 165 minutes for Mr. Nagel, which I understand Mr. Throne is saying you probably won't require that much.
Hopefully not. But I, again, each time I have a witness, I don't know how much they're going to say they can answer versus another witness. So we've already had some deferrals, but yes, that's what I'd like to do.
Ms. Padilla, were you saying something?
Yeah, Leslie Padilla with PNM. I mean, we don't object to reallocating the remaining time for Mr. Falgren, but I do worry about the waterfall, the cascading effects of this. And I don't know that it's fair to continue to push the surplus onto the next witness. So at some point we may object.
That's, I mean, I'm sort of thinking the same thing. I mean, it's designed that that we're trying to do here is not use everyone's time wisely, right? So not that someone can take all the time and then always keep it and just kind of keep moving the game forward. So I mean, Mr. Throne, I'm happy to entertain it, but I mean, even 165 minutes is a lot of time.
All I can do, since we didn't, P&M selected the order of witnesses. I've been through, can't tell you how many cases here where we've had this situation where witnesses say, you better, you'll get a better answer from the next person. So, I mean, that's the situation we're dealing with. And I just want to, I did the best guessing I could about what I could do with each witness. And then if they tell me they can't answer something, I have to move on to the next one. So I'll do my best, but I certainly I'm hoping also to not use that much time with Mr. Nagel.
I appreciate that. Okay, so we'll just, I mean, I'll make that notation that time's available, and, you know, the idea will be, hopefully we'll get, everyone will be able to ask their questions, because of course, at the end of the day, a complete record with all the evidence everyone thinks should be in is what we are all after. And hopefully there's time to achieve that. So let's just leave it at that. I have the county who's asked for 10 minutes. Mr. Albright.
Yes, good afternoon, Mr. Hearing Examiner. Good afternoon, Mr. Falgren.
Afternoon, Mr. Albright.
My name's Jeff Albright. I'm with J. Albright Law LLC, and I'm here on behalf of Bernalillo County and the Bernalillo County residents in a parent patri position. So my questions are pretty much going to be focused on PNM Exhibit 3, your direct testimony. If you want to pull that up, please, that would be helpful. I only have 10 minutes, so I'm going to try to focus on just a couple of items.
Very well in there.
Okay, and initially, if you turn to page 38, please.
Yes, sir.
And at line 12, the question is asked, did PNM limit its consideration of these bids to a 1-to-1 replacement of the 114 megawatts of capacity? Do you see that question?
Yes, sir.
Can I accurately read that, I assume?
I think so. Yeah.
Okay. All right. So in looking at the numbers there, particularly down at the bottom, it looks, well, midway through, the total nameplate capacity for the proposed resources, 450 megawatts of solar and 290 megawatts of battery storage. Do you see that at lines 17 and 18?
Yes, sir.
Okay, so my question is, were those numbers, were the 450 and the 290 megawatt of battery storage a result of the modeling, or were those inputs into the model to come up with those numbers?
Right. The model will drive reliability. And so you need the number of resources to drive the reliability. And so those come out of the model, if you would.
So were those a result of needing a certain reserve margin by PNM?
Yeah, I mean, it's better to look at the loss of load probability events, which then indirectly drive a planning reserve margin. But yes, essentially, they are a result of the modeling to drive a certain reliability number. If we were to just comparison, if we wanted to look at the San Juan case, we retired 497 megawatts of coal. The replacement resources there ended up being 950 megawatts total. So kind of same situation, right? Which is, it just depends. And those numbers can be a little misleading because you're looking at, again, when you have traditional resource like a gas or a coal or a nuclear resource, the capacity and the energy are fairly well fixed together, if you would. You've got a bunch of variable resources that can provide energy, and they might provide energy at a very cost-effective manner, but they don't provide a lot of capacity. So then you've got the batteries that supplement the capacity component of it. So it's not only just meeting the reliability, but it's also an economic. So I'll give you an example. If I was to get a tremendous amount of low-cost solar resources, let's say, that could displace a lot of other resources from an energy perspective. And then that could save customers money, but you'd still have to supplement it with the battery to make sure you got the capacity for reliability. So it is an economic and also a reliability component that comes out of the model that does select those resources.
So I'm seeing roughly 450 megawatts total of solar and 290 megawatts of storage. Is that accurate?
Yes, sir.
Okay. I mean, that seems well in excess of the 114 megawatts that you would simply need in replacement if it were just a replacement resource and you didn't have to worry about the reserve margin. Is that an accurate assessment?
Yeah, I would refer you to the bottom of that question though, if I could, based on the resource model, 150 megawatts of solar, 40 megawatts of storage is really a direct replacement for the lease interest. The remaining 300 megawatts, the 150 storage is really to improve the resource adequacy requirements. And Mr. Phillips does talk about that in many detail, but we are providing, again, enhanced reliability for the system, which is what you need to do as you continue to progress to clean energy, if you would, or 100% carbon free. You're going to have to build in more of those reliability values. But again, it does provide, I think the last sentence there does provide an explanation of the split that's really a direct replacement for Palo Verde and then an expansion of the reliability requirements.
So on page 39, lines 5 through 10, you talk a little bit about what drives those numbers. What is your projected reserve margin for the summer of 2022?
Again, I mean, what we're targeting is 13%. As we've talked in other cases, we still have some concerns with all the San Juan replacement resources coming online. The reserve margin at the moment is not very good. We're continuing to find examples. We again are trying to target 13% for 2022. But again, as we look and continue to march towards 100% carbon free, we understand that we need to take additional steps forward. In this case, we're taking a step forward, proposing to take a step forward on planning reserve margin from 13 to 18%. And as Mr. Phillips explains in his testimony in more detail, is during the next IRP we'll file in 2023, we'd also like to go from the loss of load probability of 0.1 from 0.2 down to the industry standard of 0.1. So that'll be another step. And again, as Mr. Phillips explains in his testimony, we want to make appropriate steps as we move forward, but also consider the economics of those steps as we move along as well.
And I've a couple of questions. It's related to both the Jicarilla ESA and to the Sandia Peak ESA. Specifically, I think Jicarilla is discussed page 49 again of your testimony, Sandia Peak ESA at page 66 and 67. So for Jicarilla, you have an ESA, a 20-year term, which is fixed at $7.65 per kilowatt month. And for Sandia, you have $5.99 per kilowatt month, but there's a 2% per year escalation on the Sandia Peak ESA for the 20-year term. Is that an accurate statement?
Yes, sir, I believe so.
Okay, so my question is, it seems to me, or my question is, why wasn't getting all of it at Jicarilla ESA for the entire term a more viable option, since at the 2% per rate increase per year? Well, let me back up a little bit. So my understanding is that for the ESAs, that goes directly into rate base. So we're basically committing that into rate base for the next 20 years if this is approved in this proceeding, correct? For both ESAs?
Capacity payments would be in rate base is our proposal, yes.
Okay, so why wasn't, and you passed the $7.65 point, I just ran some rough numbers last night, roughly at the 10-year point for the Sandia Peak. So it's going to go beyond that. So why was there not additional capacity in the Jicarilla ESA to get all of that from the Jicarilla ESA rather than the additional cost from Sandia Peak ESA at the higher rate after 10 years? Or roughly
yeah, I mean, those are the discrete projects that were entered in by the developers. So I mean, that's what they offered in. Again, I would contend that payments later in life are better than payments right now. So even if there's a breakover point at 10 years, it's probably still more beneficial. And that's probably a question that Mr. Phillips can answer, but I would speculate that we're either very close or even the lower cost with the escalation might be a better NPV than the higher cost. But again, those are discrete projects that are offered in.
But even so, if approved in this case for all of the extra capacity to increase that reserve margin, that's going to be embedded in rates if your proposal in this case is approved for the entire 450 megawatts of solar and the 290 megawatt of battery storage, correct?
I think our commission is to provide reliable, low-cost energy, focus on reliability. So yes, I mean, our recommendation is those are critical resources to maintain system reliability. I think Mr. Slog will talk extensively in his testimony about as you continue to progress to 100% carbon-free or more renewables on your system, those are the appropriate steps that we need to move along that process. So again, I think we're taking the appropriate steps at the appropriate times to maintain reliability. People want their lights on as well as maintaining low cost. So yeah, I think that's the right balance. We feel that's absolutely the right balance moving forward.
Okay, and one final question I have unrelated to subject we've just been talking about, but throughout your direct testimony as well and some of the provisions, in terminating the lease, the decommissioning costs, which you include and make some reference to, don't include any cleanup costs, ultimate cleanup costs, which would still be incurred. Is that correct? For the nuclear, once Palo Verde is retired.
My lawyer might object that might be in the next case, but I'll answer it anyways. Decommissioning costs do include all costs required for demolition, site cleanup, all of those activities. So the decommissioning costs do include all site activities necessary.
Okay. And do you know if all of this and your proceeding and your testimony and the models that were run was Avangrid or Iberdrola or their attorney or their DC attorney or their local counsel or anyone involved in the discussion about the resource replacements for the 114 megawatts?
No, again, both Mr. Phillips and myself were unaware of the merger until it was announced, and any involvement of that activity would be inappropriate and illegal. And obviously, no, with that, there's no activity of that.
Okay, all right. That's all the questions I have. Thank you, Mr. Falgren. Appreciate your responses and thoroughness.
Thank you.
Thank you. Mr. Gedko, and you requested 5 minutes.
Yes, and I most likely, if I may, take the 5 minutes that I reserved for Mr. Phillips so that I could use 10 minutes right now.
Yeah, we have the time for it. I'm amenable to that.
And I also want to say that I heard what you said about having Andrea Crane present her testimony. I was struggling to get through an automated door here in the building, but was watching on YouTube for that 1 minute.
It's fine. We'll address it at the end. Yeah, but that's fine. Go ahead.
Okay. Good afternoon, Mr. Falgren.
Afternoon, sir.
I think you may still have it up from Mr. Albright's questioning. In your direct testimony, which is PNM Exhibit 3, you have Exhibit TGF2, which follows after your testimony. In the PDF, it's page 86, but it doesn't have a page number.
Okay, go ahead.
Okay, and what it is, it's a chart that shows your various resources that you have. And so what I see there is there's an electric utility sector and an IPP sector, IPP meaning independent power producer. Is that correct? I'm seeing electric utility and IPP as the two sectors.
Yes, sir.
Okay. And the electric utility sector, when I first looked at it, I figured it out quickly, but it's all projects in which PNM is either a partial or complete owner, right? Correct?
Yes. Yes, sir.
Okay. And then two of those utility-owned resources, PNM-owned resources, are Luna 2x1 CC and Luna 1x1 CC, correct?
Yes, sir.
And then Okay, yeah, and they have in-service dates of 4/1/2006. Is that correct?
Yeah, and if I could clarify there's not two units there. There's, this chart has multiple uses, if you would. This is kind of a chart we used to supplement data into our EIM filing, our EIM data with CAISO. So if I could explain Luna a little bit, it's what we call a 2-on-1 unit. So
I'm not sure it's going to be relevant to the
very good.
questions that I
Thank
have.
you.
I appreciate it though. Thank you. Okay, so I just wanted to cover that quickly. And now we've been referencing it. Can you turn to Onward Exhibit 1? And we've been here before.
Very well.
And on page 67, there's a chart there, which was provided by PNM in response to Onward Discovery Request OEH 2-11.
Yes, sir.
And I'm not going to ask any questions about dispatch. That doesn't interest me. But what I see there is that the chart lists capital additions that were made to Luna in 2018, 2019, and 2020. Correct? Just that it purportedly lists those. I recall.
Yeah. Yes, I can agree with that.
Okay. Yeah, and I recall that you weren't able to vouch for the exact numbers. But would you feel comfortable saying that you do agree there were capital additions made to Luna in 2018, 19, and 20?
Yes.
Are those sorts of capital additions made as a result of any kind of RFP process by PNM?
Generally, yes. Yes, I would say yes. So if I could explain a little more. So when you're looking at the full RFP process, let's say about a new resource or an exchange of a resource, right? What we do in that analysis, and Roger Naval could talk lots more about that, is we do include the ongoing capital cost that would be required for PNM, and we include that on our evaluation of which resources would be low cost for customers. So the idea that there's ongoing capital expenditures on PNM owned resources, absolutely included in an evaluation of an RFP comparing PNM owned resources versus a PPA model. These specific things here are generally turbine overhauls. And so it's an overhaul of an existing turbine in that particular case, which is obviously we would go out and we would solicit bids from a number of people that do turbine overhauls, and we would select the low cost bid for the people doing the overhaul.
Okay, so what I understood there is that there's a choice made by PNM to include those in the existing capacity that you have, and that frames the RFP process, the larger RFP process that you're undertaking, because we have to understand what resources you have in your system, and that's going to affect what else you need. Is that a fair statement?
I'm not sure I follow exactly, but I would characterize it as when we look at comparisons between PNM owned resources and a PPA, definitely ongoing capital expenditures are included in that evaluation.
Okay. And so with these capital investments, did they lead to any extra capacity or additional capacity on your overall system? Like if we took what capacity was right before you put those capital additions in 2018, when you finished with those in 2020, was there additional capacity on your system due to the investments in La Luna specifically?
What it is it preserves the ability to operate. So if you have a gas plant, major maintenance is usually based on either a start or a number of fired hours duration. And so what you do is, let's say you got up to 900 starts. What GE would tell you is you got to do an overhaul, an inspection, overhaul, evaluation. Otherwise, you're no longer able to use that unit.
Okay, but to preserve capacity is different than to add additional capacity, correct?
And again, if when you do a turbine overhaul, you'll gain a minimal amount of a few megawatts, if you would, back to restored capacity, but generally not. Generally they are a maintenance type. Generally, they're what I would characterize as a maintenance capital expenditure. And again, if you look at a PPA model that has, like Valencia PPA, they also have that same component in there. And it's factored in both the fixed maintenance component that we pay them and also the variable operating maintenance component that we pay them. So you really do have a apples and apples comparison.
Yeah, that doesn't really concern me. I have one. So if it added negligible capacity in 2020, would the same hold true in 2023 that we didn't get additional capacity come 2023 because of these capital investments, did we?
Again, it's a maintenance activity to maintain.
I understand. Thank you.
There are no capacity additions as part of these projects.
Okay, then I want to turn to one other document. I think, do we have about 4 minutes left here? Two. So if we turn to PNM Exhibit 8, and included in that exhibit is PNM Exhibit NLP 1, which is the IRP.
Okay.
And if we turn to page 113,
the IRP or the exhibit?
Yeah, the numbering wasn't done very clearly, but of the in the upper right-hand corner, it says 113 of 189.
Okay. What's the number at the bottom of the page, please?
103.
Okay, very good. Thank you. I'm there.
So one thing we see stated there is that Luna is configured with two heavy GE heavy frame 7FA gas turbines, correct?
Yes, sir.
Now let's turn the page 104, and there's a description of the Valencia Energy facility there at the bottom. And it says its generator is a heavy frame GE 7FA gas turbine, correct?
Yes, sir.
So if now I want to go to page 6, line 18 of your rebuttal testimony.
Very well.
All right. Are you there?
Yep.
You state, while Mr. Spurgeon correctly highlights the reasonableness of the Valencia PPA in 2007, not unlike a variety of other resources under review in other PNM cases, the relative economics of Valencia compared to newer technologies has significantly changed since Valencia's introduction into the PNM system. Therefore, while PNM is committed to honoring the existing Valencia PPA, as there are no economic termination provisions, it would be inappropriate to artificially extend this contract prior to having a full competitive procurement process to fully evaluate its continued participation in the PNM system versus other resources. Did I read that correctly?
I believe so.
Have the relative economics of Luna compared to newer technologies significantly changed since Luna's introduction into the PNM system in 2006?
Luna is actually one of our most relied on units in the system because it has extreme flexibility. It's actually our most flexible unit due to a number of contractual issues that we have with the other owners. So it is a very valuable resource. And again, I think if you look at, if you're trying to make a comparison of, I made capital expenditures and did I make the analysis? The Luna plant was put into, into rates based on a certain depreciation schedule that was approved by the commission. So we continued to do that. When we did that evaluation, those capital expenditures were included as part of that evaluation over the overall life of Luna. And if you look at the comparison Valencia, it has the variable maintenance cost. So it has all the same things in there. And again, the Luna costs are much lower than the Valencia cost.
Regardless of the depreciation schedule that you got approved, you could make choices at any time with respect to the amount of capital expenditures and the manner in which you want to maintain a PNM owned resource, correct?
In the case of Luna, I would probably have to, if you wanted me to stop making those capital expenditures, I would probably have to ask the commission to abandon it.
But it's something that you could do. You could make that, you could make that ask to the commission.
Just like
correct?
Valencia has a contract, I also have a contract on Luna with the other owners. So I have an obligation to the other owners in Luna that would require me to live to the end of that contract. So just like at Valencia, if I get to the end of the Luna contract and there's a decision on whether we extend that contract or not, I would have a similar decision. But again, I wouldn't come to the commission right now and extend the Luna contract. I would wait until closer to the time period, just like we should with Valencia, where I can compare it against other competitive bids in the process.
And then I just want to.
Mr. Getko, sorry, you've gone well over, sir. I have to cut you off, so I have to ask some questions myself.
Your Honor.
Yeah.
There was one question there that I thought was very simple, and it was actually the last one I asked that didn't get answered. Can I just repeat that question and
okay, yeah,
request just
go
a
ahead.
yes or no answer?
Sure.
So have the relative economics of Luna compared to newer technologies significantly changed since Luna's introduction in 2006?
I'd have to do further evaluation. Luna is similar to Valencia. My personal opinion is if I was to do an evaluation of Luna at the moment, it would still be a most valuable resource.
Okay, I see that my question didn't get answered again. I understand that you want to explain things, but sometimes we just need the question answered. And it's just whether relative to other technologies, it's changed. And I can let that go, Mr. Hearing Examiner.
Sure. Thank you very much, Mr. Getko. Mr. Falgren, how are you, sir?
Good, sir.
So I'm going to start with your rebuttal testimony. It's been well covered, but I'll just ask you some general questions. You say there at the bottom of page 6, your rebuttal, the Valencia PPA is an excellent example and a microcosm of the larger changes in the utility generation business over the last 2 decades. While Mr. Spurgeon correctly highlights the reasonableness of the Valencia PPA, the relative economics of Valencia compared to newer technologies has significantly changed. And could you just expound upon that a little bit? Like, what is it that you're actually describing there?
In short, I wouldn't sign the Valencia contract today because I'd have better options for my customers.
And that would be sorry, go ahead.
Yeah, that would be, if I looked at the battery prices I see today, renewable prices I see today, and do those comparisons, or even another alternative for gas plants, I see that the bids that I typically receive for those resources would be much more beneficial to customers than the existing contract. But again, we made a prudent decision in 2007. I'm not questioning that. It's just, as we've seen in Four Corners, we've seen in Palo Verde, we've seen in other things, you make long-term decisions. People want to poke holes everywhere along the line on that, but.
And I'm assuming the relative economics are in part driven by RPS, limitations and the fact that throughout the country, those legal standards had driven down the costs of renewable resources. Is that basically a true statement as well?
That's part of it. Yeah, I think that's a valid statement. Yes.
So you point out a price actually, which I thought was an eye-popping bit of a number on page 9 of your testimony. You're talking about the costs of Valencia, and if I understood correctly, you're saying there at the bottom at 19, that is an equivalent of over 330 megawatt hours for each megawatt hour that Valencia provided to PNM customers in 2020. So that Mr. Throne may have asked you about this. I guess I'm just wondering your basic point here is that this is a very expensive unit at the end of the day.
Yes, sir.
Is there anything else you'd want to say about that? It's a very, very expensive unit.
Yes, sir. Gas plants are nominally used. So again, when you look at those values, that But yes, Valencia's existing contract is a very expensive unit.
Okay. On page 7, the top there is actually the sentence that Mr. Gedko was just asking you about. It would be inappropriate to artificially extend this contract, meaning the contract with Valencia, prior to having a full competitive procurement process to fully evaluate its continued participation in PNM system. I'm just a little, can you explain for me the mechanics of what happened here in terms of Onward or Southwest Generation, or whatever we want to refer to them as, coming to you at a period of time that I guess you're suggesting is too early? Can you just describe perhaps for me so I better understand what are they doing and why would there be an artificial extension? And how is it in your view? I'm discerning from your testimony that what they're trying to do is something that's kind of inappropriate. So explain that to me a little better.
Very good. Yeah. And so, you know, what they're proposing is there's a change, and I'll use air quotes, in 2023, which is why they get to submit the bid. But the change they're proposing really provides no benefit to our customers in 23. So the change they would propose in 2028. The RFP we had was very specific to say we need capacity in 2023. It's like, so if you looked at in the extreme, if everybody that wanted to provide a new capacity anytime between now and 2040 wanted to submit a bid into the 2023 IRP, into RFP, it just becomes ludicrous, right? I got to evaluate all these different options. And so we didn't solicit any bids that provided capacity expansion in 2028. So nobody provided an alternative to the Valencia extension in 2028. So what we're saying is Valencia might be okay, and Onward may be a bid that wins, but we need to evaluate that against the competitive process, which is like, let's look at all the other alternatives that are available in 2028, and let's make that a specific RFP or a specific RFP request that says, here's a time we're looking at Valencia. It's not any different we would do elsewhere. But let's open that wide open so it's competitive. I get all the alternatives for that expansion in 2028, and then I can come forward and say that was a competitive bid.
Okay, so in other words, when the PPA comes to a conclusion, that would be the moment at time that Onward should submit the bid, and then you would have an RFP process to see if that's in fact something worth pursuing. Is that what you're basically saying?
And obviously we would want to, we would probably do that 2 or 3 years ahead of that time period.
Okay.
So again, we don't want to, if the Valencia plan is a good plan, we would obviously want to continue unaltered. So you'd probably see an RFP that might come out in 2024, 2025, that would be for that potential replacement. And they obviously they would have full rights, and we would encourage them to bid into that process at the right time. So it's got comparison against all their alternatives.
And so you and Mr. Throne talked at length about, Onward's efforts here. And I want to understand, is what they've done here fairly unusual from your perspective?
Yes, I would say yes. Their request is very unusual. And again, we have eliminated a number of bids that were non-conforming if they weren't able to meet the 2023 time period.
Okay.
We've had I don't want to drag you through a lot of mud. Obviously, PNM and Southwest has had a long history and a long history with Valencia. If you get into the details, PNM actually has the right to purchase 50% of Valencia. We've gone back and forth for a decade or better about that opportunity. The deals were never right for our customers, so we have never executed on that. Any of those executions.
And so it sounds to me like there's two things that's going on with the Valencia deal. Number one, there was discussion about what we've already talked about is number one, which is it's premature, it's too early, right?
Yep.
And then secondly, you've said several times there's no incremental generation capacity gained from the Valencia bid, and I just want to make sure I understand what that means. You're basically saying you already have the PPA with them to deliver so much power or whatever it might be, that there's no addition to the system through that possibility. Is that correct?
Yes, sir. And the increment they would say on quick start or whatever provides no value, basically no value. So what we've offered back to them, and we've offered many times throughout this multiple history we've had, is if you can come to us and demonstrate, like we have in other cases, that you can provide customer benefits, but no extension past 2028, absolutely, we want to have that conversation. But again, having an artificial extension without a competitive bid, we're not going to go there.
Okay. Is the Valencia facility a heavy frame? Is that convertible to hydrogen?
Yes, I would say in today's environment, most gas plants can run on actually a certain percentage of hydrogen already.
Okay.
You know, and heavy frames can be convertible to 100% hydrogen. The question there isn't really about the technology of running gas plants on hydrogen as much as the supply of hydrogen and the type of hydrogen you would supply to the turbine. Again, PNM would contend that if you're going to go to hydrogen, you would go with a green hydrogen. And, you know, we can have a long discussion. There's green, blue, pink, orange, black, brown hydrogen. And green hydrogen is hydrogen that's produced from a renewable. And so it has, so the electrolyzed water. And so there are no emissions through the entire process, which is what PNM would advocate in that process. So then the dilemma for Valencia would be, well, how do I locate a large solar field, let's say, that would include a hydrolyzer on a facility that would readily supply, you know, Valencia plant. So that'll be the dilemma when you talk about hydrogen extension. But most gas plants can run like, you know, 7FA, just have hand. I think it can run about 30% today with no alterations. But again, most gas plants with a few alterations in the firing system, you can run hydrogen.
So I mean, I think one few follow-up questions about the Valencia system. You had mentioned how these aeroderivative facilities have the benefit of quick startups, whereas apparently Valencia does not. Is that because of some technological change in the new plant, or is that somehow tied to the economics of the agreement with Valencia? Is it a technology question, or is it? Can you explain that a little bit better?
Yeah, traditionally we had what we would have called peaking plants. In general, it would have been smaller units. So they're like LM6000s. And just to give you a comparison, if you were to ride on a 747 jet engine, the jet engines on either side of you would be an LM6000. That's what they are. And so if you can imagine, you're starting and stopping those, you know, several times a day. They come up to full speed before the end of the runway, hopefully, right?
Right.
And so that's what an LM6000 is. It's built to be a jet engine that runs very quick, very fast. In those, the 7FAs traditionally in the history were built as somewhat of an intermediate, and they work very well coupled, like in the Luna plant and the Afton plant. They work very well coupled with a steam engine on the back of it. And so they're kind of more along the line of kind of an intermittent resource, which was intended to be kind of that we knew we were going to run it, but when we ran it, we would probably run it a little longer. Obviously, we continued to make advancements. You know, I wouldn't have any argument that, and I myself have done 7FAs and converted them to quicker starts. Actually, our Rio Bravo plant has some fast start capabilities. So you can do it. Generally, what ends up happening is you increase your maintenance cycle on them, those type of things, but it's not that sophisticated to make that conversion. And generally, it's really not that expensive either. So, but again, what you also have is you've got size difference. So Valencia is 150, 160 megawatt plant. The LM6000s are 40 megawatt plants. When you look at the PNM system, we operate between 800 and 2000 megawatts. And generally, when we have seen variations, we're seeing variations in maybe the 20 to 40 megawatt range. And so it's easy to bring those on and off, and it's the right size that fills in those gaps for us. So again, you know, the more important thing is just the start and stops as well, which is kind of provides some of the limitations of Valencia currently.
One of the questions I asked from Mr. Fenton last time was, you know, we're here, nobody objects to these resources, right? The actual selection of the resources, and we're here talking all about modeling. Is that, I mean, his answer to that was that that seemed a little unusual. I mean, Do you have the same response to Mr. As Mr. Fenton does?
Generally, I'd say yes. I mean, we have to justify, we've gone away from leaving the IRP being prima facie evidence. So PNM understands that every case we come to, we've got to prove the reasonableness of all the inputs and the model inputs, right? And so we understand that we did that in this case. Nobody's disputed a lot of the inputs, outputs, and nobody's disputed the resource that we're requesting. So again, we see a lot of this as kind of immaterial to this case. When we go to the next case, we understand completely that we'll have to still justify the process. We'll still have to justify the inputs. We'll still have to justify the modeling. So again, we're not sure why we're here either, honestly.
And is it true that in the future cases, I mean, am I correct to think that what model one uses is not necessarily a static thing, but one that is responsive to the exigencies that's demanding modeling itself?
Yeah, yes, I would agree with that. And again, if you've seen up until the San Juan case, we used to use a strategist model. And again, as the industry developed and we got more renewables on the system, the strategist model became it became obsolete. And so we moved to Encompass. Encompass is the industry standard at the moment. Does Encompass stay the industry standard for the next 10 years? Maybe, maybe not. And maybe Encompass expands. But yes, as we continue to move forward, we're going to have to continue to advance the modeling technology and then see what the best it is. But each case will have to justify that.
So there's no new combustion versus technology neutral path, these two pathways that sort of PNM's utilizing to think about this present circumstance. Is that something that you see continuing well into the future? And I don't know if the answer is obviously yes, because it's in the IRP. I don't know the answer to that question. Do you have any sense of how long this will stick around?
Well, I think, we're getting to a point where, the further we get along in this process, we're mandated to be at 100% carbon free by 2040. Maybe there's an opportunity, 2045, we're trying to get there by 2040. There's a push amongst parties to try to get there by 2035. If you look at our merger case, we made a commitment to look at being carbon free by 2035. So again, the closer you get there, we're going to have to figure out that last few percentages. And again, like Mr. Phillips and I, we talk a lot, everybody's kind of excited about lithium ion batteries. We're beyond that. We're onto something else. When we look at how to get that last 20% of carbon free, that's really that's really complicated when we get that far. It's not going to be lithium ion batteries. It's going to be something else. And what does that look like? So yeah, we're going to continue to evolve this, but at some point, either we're going to convert gas plants to hydrogen and that path will materialize. Otherwise we'll have to go, we will have to go away from gas in the future at some point, right? Obviously.
Mr. Albright asked you a question about seeming to be there a little bit of a dissonance between the resources which are being abandoned and then the amount of resources, the megawatts that are being brought onto the system. And I understood your answer, and I just want to make sure I understand this. Part of the reason why there's an over capacity brought on to replace the 114 megawatts lost through the leases is because with intermittent resources, there are just different considerations that demand more resources present. Is that a basically generally correct statement?
Yes, I'd say two things for that. One, if you look at the capacity factor from a solar plant, the best you're going to get is 35% capacity factor. If you look at a capacity factor from a gas plant or a coal plant, gas plant in particular, you're 95%. So again, right there, you would say almost 3 times the amount of resources. But also there's a divide then between the attributes of those. Like we talked about, the traditional resources both had capacity and energy that were kind of lockstep. But now the renewables bring the energy and typically bring the energy at a lower cost, but they don't really provide the capacity or the ability to then serve reliability needs. And so you kind of have to add both of them then to correspond to it. So while it looks like you're adding quite a few resources, the incremental energy uses that you're getting are generally much lower. which then provides the value for customers. But yes, when we look at pure nameplate capacity, we will have much higher nameplate capacity on our unit for all replacement resources from traditional resources.
Very good. Let me just move on here. I'm familiar with looking at the megawatt hour prices, and I've been involved in several cases now with PPAs and discussions about how some of them are so low and historically low by the acquisition, but I don't have an equal frame of reference for this battery storage agreements. This $765 per kilowatt month, for instance, with Hickoria. Is there a meaningful way, since the battery storage is kind of coming onto PNM system for the first time? Can we know how to think about what is this a great deal or not a great deal? How do we evaluate it?
Yeah, that's a good question. It's a good deal. Is it the best deal we've got ever? No, it's not the best deal we've ever got. If you saw a battery price that's $6 a kW a month, you should buy that every day. If you saw one that's $9, you should question that. So that's kind of the range you might see.
At present, I assume that this might change with technological advancement.
Yeah. And what you've seen too is if you look at Tesla's, they're abandoning their model 1.0. And of course, those are probably lower price. They're on the model 2.0. But of course, the model 2.0 has a little different chemistry, has a little different higher efficiency, has all those other things. So obviously, higher cycling capabilities. So obviously it demands a higher price. So there are a number of things to factor in there, but generally a $7, someplace in the $7 battery is a good deal.
Okay. On page 59 of your direct testimony, I don't necessarily need you to read it along with me, but you talk about the Atrisco Energy Storage Facility, and you say, as a paired storage project, the Atrisco Energy Storage Facility must be charged from the co-located solar facility for the first 5 years. And this is a consequence of the investment tax credit. And so I was wondering, as I was thinking about Mr. Throne's position and Valencia's desire here, is there a certain degree to which, to the extent to which solar is being brought on, these battery projects, if you're going to have them, there's a certain economics at play that demand that those two things be brought together?
Generally, I agree with that. And again, it's the solar. The solar provides the investment tax credits. The previous law, they coupled the battery. So if you have a solar and then you couple the battery with it, you can extend the solar 30% tax credit to the battery.
Okay.
So you can always get a solar ICT or wind ice. Usually we do production tax credits for wind. If you bring the battery with them, you can basically bring that under that investment tax credit issue. The current, I think the infrastructure bill that's currently in front of maybe in front of the president by now, if it stayed in there, is providing just a pure tax credit for the batteries.
Am I correct to understand that the battery itself is functioning in very much like a, I know you've said several times that a peaking unit is kind of a passé term, but that's my understanding of what the technology is doing, is that it's supplying, short bursts of energy when it's demanded on the system, very much the way a generation plant would have. Is that a correct understanding?
Yeah, except for batteries are gonna, the use of batteries are going to mature quite rapidly here. Again, I think most people would think of a battery like a flashlight battery. I run out of power, I turn it on and I run it till it's empty. These batteries won't do that. They'll be much more dynamic and they'll operate intermittently. If you can imagine, one of the severe cases we have on our system is actually when we get too much generation, over generation. So if you imagine a similar case, you're sitting in the operator's chair, I got no wind on my system. All of a sudden the wind picked up. I got 200 megawatts of wind on my system. What am I going to do? I got to put it someplace. Ideal for battery is boom, I've got a battery that's not fully discharged. Boom, I'm going to put all that energy into the battery until I got longer time to sort it out. But batteries add a lot of capabilities. They'll add a frequency response. So basically all the frequency response we required off all the other units will default to the battery. I've got energy arbitrage when I'm moving it from one point of the day to the other. but I've also got all these flexible capabilities of both a sink and a source. And that was our point in the 195 case, is this is really complicated. I've got a staff of engineers that are working on a super algorithm on how to operate the battery.
Is it okay? So when we've talked about this, and no new combustion, and you're moving towards, but at the same time, you use that label, but we say also simultaneously in this testimony that it seems like, and I understand maybe perhaps anecdotally, that you can't entirely eliminate the combustion option in these gas turbines. I mean, do batteries make those things unnecessary, or is that just fiction?
It's a condition of the amount of renewable. So if you imagine when we had 10% of renewables on our system, no harm, no foul, even the coal plants could ramp fast enough to accommodate that. We've got to 30%, 40%, 50% of renewables on our system. We're going to need something else. And that's why the base load units are really being displaced to a large degree. So again, batteries can provide, lithium ion batteries provide a good 4 to 6 hour component. What we're going to struggle with, and what I would say is it does a decent job of getting us to maybe that 60, 70, even 75% kind of penetration of renewables. But that last 20, 25%, we're going to have something else. It's either going to be, and it's going to have longer term storage. So if you look at Texas, you look at California, those were week-long events. Well, a 4-hour battery doesn't do me a lot of good in a week-long event, right? And so I have to have things like pump storage, there's compressed gas storage, there might be hydrogen on gas plants, but obviously hydrogen on gas plants provides other emissions like NOx. So that's a question we're going to have to get through. Or is there other technologies out there that help us with that last 20%-ish kind of range? So yes, we're on the right path, I would say, moving in this direction. It's just, this is not the path that's going to take us all the way to 100% carbon free.
And it's the point that at the moment, the technology that does exist to satisfy those gaps is basically gas resources, even though they do have carbon emissions, you just can't escape from them.
Right now, the gas that we have on our system helps us with those, fills in those gaps. But yes, we're just going to we're working hard on the next technology. You might see from us shortly is an RFP that kind of looks at those longer term storage options and what does that look like? Because a lot of those options we're going to have to struggle with too. So if you look at pump storage, you look at some of those, or even flow batteries, which is a longer term storage, a lot of those may be a 4, 6 year, 10-year development of some of those technologies to bring them online. And so we're going to have to get further out and look at it. So yes, this is the right move for now. We're going to have to progress and think about things differently as we get closer and closer to carbon free.
Just want to, I'll have a few more questions. Only a few more minutes with you, sir. I know everyone's eager to wrap
No
up
problem.
here. So, but I oftentimes find some of these charts you guys include, you include them for good reason. And I just want to make sure I understand them. So 72 of your direct testimony.
Yes, sir.
Can you just kind of walk me through what are I'm looking here, frequency response, and why this is significant? Like, why are you giving me this chart, and tell me just generally, what is it, this information that you really hope for someone to walk away with looking at this?
Yeah, again, it kind of speaks to the flexibility of a battery and also the different capabilities attributes that a battery brings. The first one, the frequency response. Right now, we're getting that mainly off our gas plants. And that's like somebody started a large motor. Frequency might drop from 60 to 59.7, and I've got to recover to that with, the NERC standards we talked about.
Mm-hmm.
I've got certain standards I have to recover from. I think our obligation's around 20 or something. What you could gain from that is batteries basically kind of takes those frequency responsibilities kind of out of contention. I mean, there's no issues with them. So frequency, it covers very well. But again, those are things that we want to make sure that we cover. The ramp rates, if we took a look at a traditional, gas plant, we can ramp 100, maybe 10 megawatts a minute. When you get to a battery, when you hit the go button, you can go from 0 to 150, 200, whatever the full capacity of the battery is. You can discharge it instantly at that full capacity rate. So rather even trying to ramp up over 10 minutes or 20 minutes, you've ramped up over less than a second.
So is that why batteries are, I mean, in some ways, a better solution than more gas plants? I mean, is that kind of what you're?
A battery is a good solution, but again, you've got to consider the limitations of a battery, which is the limit. It's a limited energy source.
Yeah.
But again, that's when we talk about like fast start capability. If I've got batteries on my system, I can go from 0 to 800 megawatts in less than a second. And
Are
so
batteries absolutely essential to the future of the P&M system?
batteries are a critical component of where we need to go to carbon free. Yes. Yeah. And then the cycles are obviously how many times can I cycle in a year? And there's no limitations on a number of days, a number of times I can cycle them in a day.
Okay.
Just
And
as
that-
long as I meet that.
System latency?
That's just the how fast it responds. So again, the discharge above, I can go from like 200 megawatts, I can go in a half a second. I can be from 0 to discharging 100 megawatts, in less than a half a second. So that just speaks to the quickness of which they respond.
So let me ask you this, just one final question. I've gone through all the specific points in testimony I wanted to ask you about. You and Mr. Throne had a very spirited exchange there. I kind of felt like, what's the expression? When the elephant fights, the grass loses, right? Something like that. I guess take the most cynical perspective, perhaps, this is in someone's testimony, and I'm sure I'll find it and bring it up. It's not your testimony. Is that Onward Energy is attempting to somehow position itself to ensure its continued use by PNM. I mean, is that what you see is happening in this instance? And what is your general take on what's occurring here?
Yeah, I'll see if my lawyer runs across the room and kicks me under the table. But
I can read between the lines. I mean, I'm here.
yeah, no,
watching all
absolutely,
this.
absolutely. I'll have a couple of things if I could on that. Yes, obviously they have a vested interest. I mean, there's no secret of that. Do they have the right to petition? Obviously, they can be a stakeholder. Everybody has the right to be a stakeholder. What we've seen over the last few cases is, Onward has used PNM customer resources, i.e. Nick Phillips Group, which are in base rates, which are paid for by customers, to really inform their bid strategy and how they should bid Valencia in. My contention is, why is that fair? Right? We continue to run these models. The other thing they contend is, well, there's no way you can buy these models and there's no way you can have the expertise. You can buy an Encompass model for $20,000. You can buy a Servin model for $25,000. Onward Energy is part of the JP Morgan entity now, which is a 500 billion with a B capitalization plan. So I think we might have David and Goliath a little bit reversed in that equation. And the fact that, again, these models they are complicated. But again, the state sent the energy policy for the state, the legislative did. This is the math associated with how to get there. It's complicated, and I don't want to be the one to say it, but it's going to get a magnitude more complicated as we get closer and closer to carbon free. So we can't apologize for the math, but we're going to have to understand it, and we're going to have to move forward. And we have tried numerous times to have modeling conferences, to try to explain to people, what this looks like, try to educate people in that process. And we have conferences and nobody will show up. So we're like, we're trying, okay? And then where we've been with the model is people would submit ideas to us. And we used to say, listen, that's not a viable option. That's a contract violation. That doesn't meet physics. That's not practical, those type of things. And then when we get motions to compel and say, run it anyway, right? And we'd say, it doesn't make sense. And we used to be a few cases ago under that argument. And so we've said, fine, we'll run it, right? And that's where we got to now, which is like, listen, we'll run whatever you want, but you have to give us the inputs. And now everybody's like, well, I don't understand the inputs. And we're like, well, you wouldn't accept our inputs. You wouldn't accept our guidance of what makes sense or not. You compelled us to run a model. We ran it. We told you why it doesn't meet. But again, the idea that we have an endless supply and continuing increase in supply of garbage in, garbage out model runs I don't think that serves anybody well and doesn't inform the commission, and a lot of times just distracts the commission. So that's where we're at, is yes. Does Onward have a seat at the table? Do they have the right to petition? Yes. I think where we are officially informing Onward on how to future bid, I agree. I think that's part of the process. Should we all have work on trying to understand the models? Yes, better. But again, they're not prohibitive and an Encompass model can be shared by multiple parties. And again, $20,000, I don't think is a high entrance fee, particularly for somebody that's a $500 billion capitalization.
Last question I'll just ask you and then we'll wrap it up. I mean, is it inevitable that there are winners and losers as this all shakes out?
Yeah, hopefully the winner is the P&M customer though.
Yeah, okay. That's all from me. Mr. Throne, I know there's going to be desire. Unfortunately, we have 5:15. So we have two options. We can do, I'm sure you want opportunity for redirect. Or not
Yes.
redirect, excuse me, recross. Is that what you're after, Mr. Throne?
Yes, I don't have a lot, but just based on your answers to your questions, yes.
And Mr. Hearing Examiner, I do have some redirect as well.
So I'll ask you, Ms. Padilla, even though you may just ask Mr. Falgren, but can we have Mr. Falgren back Monday morning?
No, well, we hadn't anticipated this, but I don't know how long the hearing examiner can continue. I mean, do we want to limit the time that we spend?
Well,
today?
Ms. Gonzalez.
Can I go off the record a second?
Yes.
Oh, thank you. If I could have 5 minutes, I'll be back here for you guys if you need it tonight.
Okay, that's, no, not tonight. I'm thinking, I mean, do you need, how much, Mr. Throne, how long do you expect?
I can't imagine it would take 10 minutes.
Okay.
As long as I get, I mean, it's going to be limited to 4 or 5 questions that he answered that you asked. So yes.
All right, let's, go ahead. Sorry, who you
Yeah,
trying to say something?
Mr. Hearing Examiner, this is Leslie Padilla with, I hesitate. I actually have a kind of a crisis that I need to pick up a foster dog from a clinic tonight and they close at 6. So I do want to have an opportunity for redirect though. I think if we can wrap this up in 20 minutes, my question should take only about 5 minutes and then an additional 10, then that's fine. And then we don't have to bring Mr. Falgren back.
Ms. Gonzalez, it sounds like you need a momentary break.
Maybe 2 minutes.
That's fine. Let's do that. Let's just call that a 2.5. It's 5:15. We'll start as close to 5:18 as we can and try to wrap up by 5:30 at the latest. Thank you, Ms. Gonzalez. Really appreciate it.
Not a problem. I just need 1 minute here.
So yeah, Mr. Gedko, yeah, Ms. Crane, if she could come back, if she could come and be with us, I'd appreciate that because I think I will have some questions. And again, I said, I'll say this on the record too, but just so we don't have to belabor the point, you know, as a person representing the public interest, I think it'd be responsible for me to ask her just a few questions about what we're hearing during the course of these proceedings today.
Okay, I've already reached out to her and I know her general availability and I expect her to be available.
Won't take very long. She can just find a computer anywhere and plop herself down, and I'm happy to accommodate whatever she might need in terms of rearranging time if she has issues. So
I feel like a new person.
I hope you get the answers you want. She did a lot of testimony on the finances that pertain to the 83. And so she is not a resource expert.
Yeah.
But yeah, she's really wonderful. So probably still of value. So thank you.
Sure. Okay, are we everyone back?
I am back.
So we'll go on the record again. Ms. Gonzalez, thank you. So we would go to redirect at this point. Ms. Padilla.
Thank you, Mr. Hearing Examiner. Mr. Falgren, do you recall Mr. Throne questioning you about the 2020 RFP? And he said there was no express provision in the instructions to bidders that a proposal had to provide additional capacity.
Yes, ma'am.
I wanted to share, if I could, we'll share this screen. I want to share an exhibit. This is an exhibit to, oh, maybe I won't be able to do it that as quickly as I'd hoped.
Do you want to maybe just reference the page in Mr. Nagel's testimony?
Sure. Do you have, it's exhibit 4 to Mr. Nagel's testimony. So it's PNM exhibit RWN 4. And at section 1.3,
yes, ma'am.
It describes, the title is resources sought through this IRP, correct? You see that?
Yes, ma'am.
And I'm sorry, Mr. Hearing Examiner, I had hoped to share quickly, but, and does it state there that, that the PNM is targeting the acquisition of 150 megawatts of accredited capacity?
Yes, ma'am. And then down below, it does say resources under this RFP are targeted for in-service date prior to June 1st, 2023. So it does state the capacity is what we're after. And then also the date of 2023 for that capacity is the requirement of the RFP.
Okay. And then as to natural gas resources specifically, is that addressed in section 5.4 of the IRP? It's same exhibit RWN exhibit 4 to Mr. Nagel's testimony.
Yes, it's both described. I would say that you could just say it's described in 5.4 and 5.5.
Okay. And is there a requirement for natural gas flexible resources that they be capable of achieving a full output from a cold start in 10 minutes or less?
Yes, ma'am. That's one of the items listed on the top of page 11 in section 5.4.
And the next bullet there is that they must be capable of 1,500 starts per year, correct?
Yes, ma'am.
So Onward didn't meet any of these requirements, correct?
That's correct.
Okay. My second question is about some questions that the hearing examiner asked you. Let me get back to my screen here, sorry, so I can actually see what I'm about the relationship between PNM and Onward, and whether Onward's proposal, whether Onward's position in this case is relevant to, you know, actually, what is the relevance of Onward's case? And one thing I wanted to ask is, you discussed that PNM and Onward or Southwest Gen, the previous owner, had many discussions over the years about how the Valencia plant might better meet PNM's needs, correct?
Yes, ma'am.
Did PNM suggest, I think this would have probably been in the course of after the 2020 IRP, but you can correct me if I'm wrong, that that Valencia might lower its cost to PNM prior to 2028?
Okay. What's the objection, Mr. Throne?
She's leading the witness. This is redirect. She's leading the witness. It's inappropriate.
Okay, I can ask in another manner.
Okay, why don't we try that?
Okay, sure. what were the discussions between PNM and Valencia about, that specifically go to PNM's interest in trying to find some solution between PNM and the Valencia plant?
Again, I think we asked them, and again, Nick Phillips, I wasn't directly involved in the conversations, but Nick Phillips would have been. And again, was it, would you adjust your price for the existing PPA terms, adjust some of the terms for the existing PPA price? And their contention was they could not do anything because they had a fiduciary responsibility to JP Morgan.
Mr.
maintain
Higgs, I got
contracts.
to move to strike. I mean, on its face, it's hearsay. I mean, Mr. Falgren just admitted he doesn't have no personal knowledge of these discussions. And I know it's, it is addressed in Mr. Phillips' rebuttal, but to try to bring this in now, secondhand hearsay through Mr. Falgren is inappropriate.
Mr.
Padilla.
Yeah, Mr. Herring, this is directly related to, your series of questions to Mr. Falgren about the relationship between PNM and the Valencia plant. So I think it's important to understand the full picture, and Mr. Falgren has knowledge of it.
Yeah, overruled.
Those are all the questions I had.
Thank you. Mr. Throne.
Okay, let me go back first. Mr. Falgren, do you remember when the hearing examiner was asking you about your rebuttal at page 9, and he was saying, is the Valencia, where you described the cost of the Valencia, and he said, well, this is a very, very expensive unit. Do you recall that?
Yes, sir.
Yeah. Now, you're referring there to the cost under the existing Valencia PPA, correct?
I'm demonstrating in that section what the existing costs are, correct?
Okay, those aren't the costs of any proposal that was made for a Valencia PPA extension, correct?
Those costs are the existing PPA, so it does not include the post 2028, which was non-competitive. So.
Okay. And then you were asked by well, you actually volunteered in response to a question by Mr. Ryan. You talked about the fact that under the existing Valencia PPA, PNM has a right to purchase 50% of that facility. Is that correct?
Yes, sir.
And in fact, Mr. Spurgeon actually refers in his direct testimony to the fact that in 2012, is it not correct that PNM actually tried to buy 100% of that facility?
I wasn't employed at PNM in 2012.
Right, but that doesn't mean you don't know the answer. Do you know the answer to that question?
I know there's been a series of discussions over the last decade or so on various options. I'm not familiar with the particular offer or that you have that you've stated.
So you don't know whether or not, in fact, the problem with the negotiations regarding Valencia was that PNM wanted the entire plant as opposed to 50% of the plant as provided in the existing Valencia PPA?
I can speak to the negotiations I've been as part of Southwest Gen over the last couple of years. The contention I had with Southwest Gen at the moment when you provided the discussions for me was that you wanted PNM to take the plant at an inflated price. And then in my 38 years, it's the only time I've been threatened, where your senior vice president threatened that if I didn't take the deal, that he would send you to Santa Fe and try to muck up every proceeding we had since then.
Well, I guess I'm flattered that you apparently had some conversation along those lines. I've never heard of that, but anyway, let me move on. Do you recall when Mr. Ryan, I asked you why Valencia currently doesn't have quick start capacity?
Could you rephrase the question? I'm sorry, I missed the.
Well, there was my notes reflect that Mr. Ryan asked, well, why currently does Valencia not have quick start capacity? Do you remember that?
I don't remember.
Yeah,
I
I
don't
don't,
remember that specific question.
So I'll just clarify. I mean, I got into a discussion with Mr. Falgren about trying to understand the difference between whatever they are, the aero derivative.
7FA,
Yeah, and why,
LM600.
yeah, well, how many starts you can have on a heavy frame versus the other, and is that a technological limitation? And he gave me an explanation, so.
Okay, well, let me ask it this way then. Would you agree, Mr. Falgren, that in Southwest Generation's proposals regarding Valencia PPA extensions in response to PNM's 2020 RFP, they described how they would provide quick start capacity to that facility?
They described how they would improve the start time on it, but the proposal did not provide a full load output of Valencia within 10 minutes. And again, we talked about the importance of 10 minutes in the new world of batteries and other capabilities.
Well, let's assume that for the purposes of this question, that the proposal included a proposal to reduce the minimum capacity requirement of that facility to 50 megawatts. And if a plant like Valencia has capacity of, and I believe it's 144 effective megawatts capacity and 149 of rated, but even if it can ramp up and with a minimum demand requirement of 50 megawatts, you can do that without having to increase that capacity more. You can get 50 megawatts. You don't have to ramp up the full amount, correct?
You can stay at minimum load. If you start, you can stay at minimum load. But as is described by Mr. Phillips in his testimony, that provides essentially no value to customers.
Now, I believe you in part of your answer to Mr. Ryan's questions, you said, I myself have converted a heavy frame to quick start or faster start capability, correct?
Yes, sir.
And which facility was that?
It wasn't at PNM.
Was it another utility?
Yes, sir.
And did you do so because that would provide greater benefit to that utility and its customers?
Yeah, but what I'd say is that was 15 years ago. So the value of that 15 years ago was much more important than it is today.
But it had value, correct?
That provided value in that particular system at that particular time. As Mr. Phillips has explained in his testimony, the increased speed for the Valencia plant provides no value to PNM customers.
Okay, and now, and just to put a little meat on the bone in terms of this, you had a discussion with the hearing examiner, about the effect of adding more and more renewables as you have a higher penetration of renewables on your system. I would like you to just go back again to this, to Mr. Phillips' direct testimony. That's PNM Exhibit 6, where he has that on page 35. He has the PNM figure NLP4, where he shows the technology neutral and no new combustion scenario. Do you have that?
Yes, this is in response to Mr. Ryan's question. How?
Where you were talking about the fact that because of renewables, as you add renewables, they have a declining effective capacity, and so you need more and more of them. In terms of why you're replacing more megawatts than, for instance, something that you're retiring. Okay, you recall that? Okay,
Understand that. I understand your question.
So I just want to just for clarity. So looking at the proposed, this is the top box on the left-hand side of that NLP figure 4. Okay, and these are your company's proposed resources, correct?
Yes, sir.
And so what that shows is for the solar hybrid Atrisco plant, which has a installed capacity of 300 megawatts, in terms of satisfying P&M's planning reserve margin, that is only going to have 18 megawatts of effective load carrying capability, correct?
You were talking about the top one, or you're talking about technology neutral?
No, I'm talking about the proposed portfolio, top one.
Yes, sir.
Looking-
Yes, sir.
Right.
I'm with you now.
Okay, good. And then it shows that for the additional 150 megawatts of solar, you're going to only get 8 megawatts of effective load carrying capability in 2023, correct?
Yes, sir.
So for the 450 megawatts of solar, in P&M's modeling, in order to meet its planning reserve margin target of 18%, the total amount you'll get of effective load carrying capability will be 16 megawatts, correct?
16?
I mean, 26 rather. I'm sorry, 26.
Yeah, I'm not sure. I'm not sure I agree with for the solar components, which is better explained by Mr. Wintermantle. The electric load carrying capacity of those combined looks like it's 26. And again, as we talked about before, the attributes for renewables and capacity are split now. So again, an economic valuation, but yes, okay.
And those will be resources that P&M will be committed to at whatever price you've agreed to in the PPAs for 20 years, correct?
PPAs, yes. Actually, yes, PPAs.
And it's very likely that even 15 years from now, the price of solar resources will be lower than it is today.
Disagree with that completely.
Okay, you think
we're actually seeing an increase in solar prices. So
you think, okay, so 15 years from now, you think solar prices will be higher than they are now?
As I talk to developers, that's their speculation, and that's what they put in their model is solar prices will rise in the future.
And also, and the cost here of these resources, just to be clear, those are incremental costs for just the new resources being proposed. Those, right? That's for over a 20-year net present value basis.
I'm not sure I understand your question. I'm sorry.
Well, I'm just to understand that the cost of these new resources is shown there. Those are incremental. Those are additional costs for just those resources over based on a 20-year net present value.
And I'm not sure where you're showing me the cost increase. And generally, yes, we're taking all the Palo Verde resources off. All the expenditures we would do with Palo Verde, all the O&M expenditures we do with Palo Verde, the capital expenditures, fuel expenses we do with Palo Verde. We model these new resources in at their PPA prices, and we come up with the difference.
So it's 5:35 now. So Mr. Throne, we need to, for the benefit of our court reporter.
I think I have just one more. I believe I have one more question, and I'm done.
Great.
Oh yeah, this has to do with the very last question that was asked by Mrs. Padilla, where you talked about the minimum requirement in the RFP bidding instructions that are provided as an exhibit to Mr. Nagel's testimony, which I believe is exhibit RWN-4. The 1,500 starts per year requirement, isn't it true that currently you don't have any gas plants that come even close to having 1,500 starts per year?
We probably have them in the order of 5. Yeah, I would agree with that, except for what when we do and we look out the modeling, that's a better question for Mr. Phillips, is when we look at that over the next 10, 15-year time period, is we do anticipate that those are the type of starts that we're going to have on those particular units. So if you want to look closer at the modeling, that would be a good question for Mr. Phillips. But the reason that came up is that we look at those, we looked in the future over the next period and see that we're going to continue to see a significant rise in those. But so that's the requirement there. Yes.
And isn't the reason why you put that requirement in there is because that is tied to your proposal and your plan to use going forward LM6000 combustion turbines as your gas units to meet your flexibility requirements.
I would not agree with that. I think what we're looking at is the modeling inputs and what the necessity of the system moving forward is. And that's driving the requirement rather than some conspiracy theory.
Thank you, Mr. Hearing Examiner.
No problem.
No further questions.
Mr. Hearing Examiner?
Mr. Getko, we've run out of time.
I believe I have a right to just one cross-exam question, a recross after the questions that were made.
Mr. Hearing Examiner, I do have to, I
We have to go.
apologize. I do have to go. Mr. Alvidrez will take over representing PNM, and I really do apologize. It
You're
was
leaving, Ms.
unexpected.
Padilla?
Yes.
Yeah.
Mr. Alvidrez will represent PNM. Thank you.
What is the nature of your question, Mr. Getko?
It relates to the question that you made as to the background of this proceeding and what the motivations were for Onward's position, and to which the answer was that he believed that it was to extend the ability of Valencia to be part of the portfolio. And I would just like to ask this one question, because I think that is one perspective only. And it's, could the way that modeling is performed affect the interest of other interveners' constituents as well? Simple question.
Okay, Mr. Falgren, go ahead, and if you want to answer that, if you have an answer, sir, go for it.
Absolutely. Yeah. Yes. Modeling, the way modeling is performed, obviously it affects all potential stakeholders, all potential developers. I think what we're advocating for is, do we get it on a level playing field? Do we get in a competitive environment? And then also, do we get it where we actually understand valid input and outputs to the model? So absolutely, we need to get better at how we do modeling together. We're not disputing that, but again, that, you know, it takes both sides of the parties to do that, and how we do that, because we can't just have this constant throw garbage in, garbage out. But hopefully I answered your question.
I think you did with the very first part. Thank you.
Okay, so now we're going to address Mr. Falgren. Thank you very much, sir. You are excused.
Thank you.
Great. There was a request by Ms. Padilla to take not notice, but to admit the testimony of Mr. Settlage. That would be, and you can correct me if I'm wrong, Mr. Alvidrez. I'm looking at, it's a lot of tests, just a lot of exhibits here. Which one is Settlage? Looks like it's 18. Mr. Alvidrez, is that correct? It's muted.
Yes, Your Honor. It is 18 for Mr. Settlage.
And then we have two testimonies from Mr. Sanders. This would be PNM
15 and 16.
That these be admitted by stipulation of all the parties. Earlier, we heard there was no objections. I reviewed them per the discussion we had earlier in this proceeding over the course of lunch, and I have no further questions. So unless there are any objections, I would move to admit that was 15, 16, and 18 PNM exhibits. Any objections to doing so? Those will be admitted. And as mentioned to Mr. Getko, I would like Ms. Crane to appear. So I will not admit her testimony in. Good. That brings us to the end of our day. Anything on the record before Ms. Gonzalez goes or turns off the transcription?
Just to confirm, this is Rick Alvidrez. Are we starting at 9 a.m. on Monday?
Yes, we are. So we'll go off the record, Ms. Gonzalez. Your hands are done.
Thank you.
Yeah, so 9 a.m. Monday, and it does not appear as if this is going to be a 2-day hearing. So we're going to have to make up. I think we have. I'll be curious to see if we do it. So hopefully we'll get this done in 3. That's my hope. Just based on math. So. Anyway, anything else from anyone? Good.
I hope everybody has a nice week.